Morning.
Good morning. Good morning. Welcome to the Judiciary Committee. We are going to commence the public hearing for today, Wednesday, March 22nd, 2023. Hope everybody is ready. We have a lot of folks signed up today, over 100 people, 3 minutes apiece. That's a lot of time. So what I'm going to say to the committee is please be cognizant of the fact that we have a lot of people. You are free to ask questions, but just think about what it is to ask those questions. And if you've asked a question and you've gotten an answer, please move on. Also, we have all sorts of folks with all different levels of ability that are part of these hearings. Please take that into account as well. And with that, we'll, unless my co-chair or ranking members have something, we will get right into the testimony. Seeing nothing, we will start with Tino Martinez. For the information of all of the public, I'm sure many of you are aware, but for the information of all of the public, you have 3 minutes. There is a timer to make you aware that your 3 minutes has elapsed. Somewhere after that point, I will remind you gently and then less gently. So, good morning, Mr. Martinez. You may begin.
My name is Tino Martinez. I'm here to ask you to vote yes on Bill 952. My uncle was incarcerated at the age of 20 as a result of street violence and has been incarcerated for 23 years. He has been in prison my entire life. I will be 23 this year. Something about me. Doctors told my mom I had autism when I was 3 years old. They told her I would not be able to say a lot of things in my life. They said I would never tell her I love her. I would not be able to be independent, cook for myself, have friends, or a job. They were not sure if I would ever speak at all. They told her someday she would have to put me in an institution. I bet they never imagined I would be here talking to you. Today, I have done all of those things. When they looked at me, all they saw was autism. They defined me and my future based on that one word. The state of Connecticut has defined my uncle with words his entire life. When he was 2 years old, he was defined as abandoned by his mom. When he was in his early teen years, he was defined as a foster child, then a runaway, then abused and neglected. When he was 18, he was defined as aged out. When he was 20, he was defined as a murderer. That seemed a lot in just 20 years. I wonder what words people would have used to define each of you as you were growing up. Have any of you ever lied when you were younger? If so, does that make you a liar? Or does it make you a person who lied and now as an adult make better choices? Bill 952 will give people like my uncle the opportunity to show that they are not defined by their worst moment or by one action or one person's opinion. Just like I am not defined by autism. My uncle never had a real family when he was younger. He was raised by strangers who didn't teach him the best things, and then by whatever the state of Connecticut had an open bed for him. He met my mom when he was in high school, and after their friendship grew, while my grandma adopted him when he was about 24 years old, while he was in prison. With people who loved him in his life, he grew up and took responsibility for what he did. He is very remorseful. He has spent years trying to help other people learn from his decisions. My uncle is not dangerous. His prison record now defines him as a trusted mentor, said a warden, a role model and a leader, said a captain, gentle, quiet, and a man of reason and logic, said a counselor, passionate and dedicated, said a unit manager, reliable and consistent, said a counselor, and a responsible adult, said a lieutenant.
Tito, let me just ask you a question. How much more do you have to go?
Not much.
Not much. It's almost done. The first 20 years of his life, he was a child and other people defined my uncle. Now, as he has grown into adult, he has been able to define himself. If you pass Bill 952, he will have a chance to be looked at as the person he is today.
Thank you.
Thank you for listening.
Thank you for testifying. Senator Kissel.
Thank you very much, Chairman Winfield, and I'm mindful that we have over 100 people signed up, but I wanted to congratulate you. Your ability to speak is wonderful. You're articulate, well thought out. So obviously a physician's assessment early on may not be the whole story. I personally think God has plans for us, but that's just me. And I don't want to mix church and state and things like that. But if not a miracle, certainly an example of perseverance. So thank you for coming and testifying. Thank you, Mr. Chair.
Thank you, Senator Kissel. Comment or question from other members of the committee. Representative Osborne.
Thank you, Mr. Chair. And I am mindful of the time we have, but thank you so much for reminding us. We think a lot about laws and the legal construct of statutes and where the commas should go and what the right words are. And thank you for reminding us that who we're talking about, these statutes, are people. And thank you for speaking from your heart, because that is more powerful than any comma or correct word choice. So thank you very much. And Mom, congratulations. I know that this young man did not happen without a lot of hard work and love and dedication from you. So thank you for that. And thank you very much, Mr. Chair.
Thank you. Comment or question from other members of the committee. Comment or question. If not, thank you very much for joining us and informing us on the situation as it pertains to your life. You did a great job.
Thank you.
Helen Caraballo. Helen,
Hello.
you may testify.
Hi, good morning. Co-Chair Senator Winfield, Representative Staffstrom, Ranking Member Senator Kissel, and Representative Fishbein, and distinguished members of the Judiciary Committee. Thank you for the opportunity to testify today. My name is Helen Carabello, and I live in New Haven, Connecticut. I am here to testify in support of HB 6918, an act concerning erasure of criminal history records. I am waiting for Clean Slate to start as soon as possible. This bill would help make that happen. So in hopes that you will support it and make sure the bill you passed and was signed into law nearly 2 years ago becomes a reality for me and hundreds of thousands of others like me all over the state. I was convicted back in December of 2000, over 10 years ago. And to this day, I still face consequences based on that conviction. I would like to become a nurse. I've faced several challenges along the way. Upon my release, I was given a 5-year suspended sentence. In order to be released, I had to take that conviction. And even though I did not have a criminal background as a juvenile or as an adult, and it was a crime that was committed because the car was registered to me, I had to take a felony charge. Because of that, I was unable to go to nursing school during my 20s. And I decided to go into cosmetology school because you don't get your background checked working in a salon so much. It is now that I have become into the healthcare field as a CNA. I was just licensed back in February, and I look forward to starting nursing school. But because I still have this felony on my record, I have to be honest when giving my background to an employer. It says on there, do you have a felony or have you ever committed a crime? I cannot lie about that because then it would make me dishonest. And then I would be judged during my interview because I put the correct answer and was honest with my employer, having to explain the situation, even though it's been over 10 years ago. Going forward, I would like for this bill to pass fully because I just was offered a position at a rehabilitation center, and I signed the offer papers and I went to go do my fingerprints. And because of what came back on my fingerprints, even though it was back in 2011, they declined the offer and took it back. So I'm still faced with dealing with those consequences back from December 2011. I would like to move forward becoming a nurse, and I don't have a problem asking
Ms.
the Board of
Caraballo.
Nursing for a pardon or for a waiver.
Ms. Caraballo. I know it's difficult for people online. The bell has rung. Could you finish up?
Thank you for your time.
Thank you. Comment, question from members of the committee? Comment or question from members of the committee? Seeing that, Ms. Caraballo, thank you very much for joining us. I hope that you do get the relief that you're seeking and move on with your life. Thank you. Attorney.
Thank you for your time.
Thank you. Attorney Zalotis.
Let's see. All right, can we hear me? I think we can.
We can hear you. You may testify.
Oh, good morning. Well, thank you for having me. I'm here to testify about Senate Bill number 1041, the proposal to raise the small claims limit. And I understand that the limit that's currently being debated is increasing from 5,000 to 7,000. I'm here to respectfully submit to the committee that the proposed 7,000 limit is woefully inadequate for the needs of our constituents. I will point out to the committee that 22 states and the District of Columbia have small claims limits of at least $10,000. 4 states have small claims limits of $15,000, and 2 states have small claims limits of $25,000. While I applaud the intention to increase, again, I reiterate that the incremental proposal from 5,000 to 7,000 is way too low. Rather, what we should be doing is we should be following the lead of those states in the $15,000 to $25,000 range. And my reasoning is as follows. First of all, if we bring it up to $7,000 and I have a $10,000 claim, there's no way that either I or any other sensible business person is going to pursue that claim in the Superior Court. Rather, we're going to do what I regularly do in that situation, is to write down the balance of whatever's owed to the small claims jurisdictional limit. And the reasons we do that are several. First, you got you're going to be out of pocket at least $400 between the court filing fee and the service of the marshal. You're going to be waiting a year and a half on average, typically, before you get your day in court. The cost of, pursuing it with representation is cost prohibitive. I mean, the cost of legal fees has gone up dramatically. You're not going to resolve a superior court action for a couple $1,000s, which means even if you win in the superior court, you're going to be net negative, as opposed to if you had actually just brought it quickly in the small claims court to begin with. Even someone like myself, who's an attorney who could very easily self-represent in small claims court or in the superior court, that when you consider the time value of, what I could be doing with the rest of my day if I weren't showing up for, motions to strike, motion to dismiss, motion to amend, and so forth and so on, it's just not worth our time. And what's ultimately, and although this, may, cause some individuals to forego their claims, it's just not fair to individuals with legitimate claims that if you're owed $10,000, you're owed $12,000, that you're writing off a legitimate claim for legitimate services provided, whether it's an attorney or any other individual, simply because the superior courts, the pace of the superior court and the cost involved make it cost prohibitive to pursue those claims. And I think, ultimately, the amount of controversy has to be significantly high to justify involving the judges of the superior court. I mean, ultimately,
your time has elapsed.
Okay, well, very good. Well, thank you for your consideration, and I'll leave it at that.
Thank you. Representative Fishbone.
Thank you, Mr. Chairman. Good morning, Attorney Zolitis. I would expect that in anticipation of your testimony today, you had an opportunity to review the language, the present statute. Is that correct?
I'm familiar with the present statute, yes.
Okay, so you would agree with me that for some areas of litigation, if we want to call it that, in small claims, it is already $15,000.
Oh, well, okay. Well, then I guess I missed that part then. All right. Well, then I stand corrected.
Okay, well, I mean, it's not very long language, but so you told us that other states have done something and we should follow that charge. Can you tell me, in those other states, what is the appeal process?
Oh, I'm not that deep into that process. I couldn't comment on that. It was just brought to my attention that there was an anticipated increase from 5,000 to 7,000, and there was going to be a hearing today. So, I mean, I haven't researched this issue, with any particular detail. I can't comment to that.
Okay, and I trust that you've misspoken a few times. It's not 7,000; it's $7,500. So it's a little higher than what you said. But are you aware that in our small claims process there is no appeal?
No, I'm not aware of that. I'm not in small claims court often, fortunately.
I appreciate you coming to us here as a lawyer, and I understand the perspective of your testimony, so thank you.
Thank you.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us today.
Thank you.
Andrew Bloom. Andrew Bloom. Deshaun Bowden Lewis. And I'm just going to take the time as she's coming to remind members, since not everyone was here, we have 129 people signed up. We're going to ask you to ask only the questions that are necessary. We know you like to greet everybody who you know. Please, if you have to do that, be very quick about it so that people have the opportunity to testify, because people will lose that opportunity as we go on. Welcome. You may testify.
Good morning. Again, my name is Tashawn Bowden Lewis, and I am proud to be the Chief Public Defender for the state of Connecticut, and I lead a wonderful staff of attorneys, social workers, investigators, and clerical staff. And we support the indigent, the underserved, the discounted, and the poverty-stricken, who are primarily Black and Brown. I'm here to testify very briefly in support of 3 bills today. Senate Bill 1230, which expands access to public defender services. Senate Bill 952 regarding lengthy sentences, and also House Bill 6917, which we did in partnership with DCJ, Office of Chief State's Attorney, revising certain criminal law and statutes. So again, very briefly, in regards to 1230, we are in support of this bill. Clearly, we do represent the indigent and those who are underserved, and having more the ability to represent people who are in these categories would be our honor. But we were asking that if this were to move forward, we would have to have the adequate resources and funding in order to staff the people who are needed to do the work, to be able to be zealous advocates for this situation. So yes, we support it, but we would need the adequate funding and resources. In regards to Senate Bill 952, yes, we are supportive of that. This is just regarding increasing the age up to 25 for considering parole eligibility for a hearing for those who fall under that category. As you know, there are people who are 21. You have to be 21 to have certain things, to be able to obtain certain things here in the state, such as alcohol, firearms, things of that nature. Though legally you're 18 as an adult, you still have to be 21 for certain things. So we're asking for the age to be expanded for review, the possibility for review. And then again, in regards to House Bill 6917, we are happy to say that we were able to partner with DCJ, the Office of the Chief State's Attorney's Office, to come up with these situations here that we do support, which regard the actual sentence modifications, changing that in terms of 5 years to 3 years, just changing the name from Summers to Osborne, allowing more discretion for judges for certain sentences, also expanding the Good Samaritan provisions regarding situations with drugs, and so forth and so on.
Thank you.
You're welcome.
How many questions for members of the committee? Comment or question, Representative Porter.
Thank you, Mr. Chair, and good to see you this morning.
Good morning.
I just wanted to go to Senate Bill 952. You're in support of that bill,
Yes.
and ask you, why do you think it's important that the age be raised to 25?
The brain science is clear, Representative, in terms of children. These are people who were children at the time that they committed these offenses. Clearly, the offenses have been horrific. No one is saying that that has not happened. And of course, we all feel for anyone who's lost anyone that they know or love. But these were children at the time, and the science is very clear that they're not fully developed. And these people who have been in for, if it's 50% or less, I'm sorry, 50% or less, they have to serve 12 years or 60% of their time. If it's 50 or more, they have to serve 30 years. So there is a punishment that's been handed down for individuals who have done these kinds of crimes. But again, the focus is on the fact that they were children at the time that they committed these crimes.
Thank you for that response. Thank you, Mr. Chair.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? If not, thank you very much for joining us again, and thank you and the other side for working together to bring us a bill that I think we can work together on to move forward. Thank you.
Thank you. Have a good day.
Malcolm Rogers. Malcolm Rogers. James Ravella. The individual with you, is he signed up to testify?
I don't think he's signed up, but he's in the testimony, sir.
He can't offer testimony. He can't offer testimony, but
That's it.
okay. Chief Ravella, you can proceed.
Good morning, Senator Winfield, Representative Stafford, Senator Kissel, Representative Fishbein, distinguished members of the Judiciary Committee. My name is James Ravella. I'm the Commissioner of Emergency Services and Public Protection. Joining me today is Dane Silcox, also Lieutenant Colonel Mark Davison, and my Executive Assistant Scott DeVico. We're here to fully commit and make sure that everyone knows that we're fully committed to support of House Bill 6918, the act concerning erasure of criminal history records. The legislation provides clarification regarding the criminal records for the eligibility of erasures. My partners are also very committed to this, sir, too. Those partners have been good partners throughout this: Judiciary, Department of Correction, and Court Support Services for the Judicial Branch. So they're all fully participating in this. This adjustment that we're requesting that is in front of you really begins to clarify, and we believe this is legislative intent, and that's why we're back to see you folks for the implementation and to determine the intent for the clarification, rather than just reading the 2.5 pages that were submitted. I'd like to save some time if you have some questions.
Okay. Comment or question for members of the committee? Comment or question for members of the committee? Representative Fishbein.
Thank you, Mr. Chairman. Good morning, Commissioner.
Morning, sir.
I recognize that this policy change has become a mess. I think it would be very helpful if the public had a list that one could go to say, this thing is going to be erased. I can tell you, I have had numerous calls to my office with people saying, how do I figure this out? We've got the pre-2010 that because of the computer system, is going to call for hand culling the files. You have to do a petition to the court. You have to give a docket number. I don't know how these people are finding docket numbers. I think it would be very helpful for the public. I think, I don't want to speak for my colleagues on the other side of the aisle, but somebody should know that their conviction is going to get erased, and quite easily. I'll tell you, I spent about 3 weeks almost exclusively reviewing what we passed in conjunction with our statutes, in conjunction with the regulations, for a client who's got a panoply of convictions. And at the end of the day, I gave him back his money. I was like, I can't figure this out. I don't know how the public can figure this stuff out. So at some point, once we can see the end of the tunnel, I would hope that there's a list somewhere, but there's particular portions of 6918 that I wanted to ask you about. Well, the first is lines 84 through 88, which I read it to be that if somebody is convicted of a sex crime and they're required to sign up on the registry, that even though their conviction may be erased, and once again, I can't tell which ones would be erased, that they're going to remain on the registry. Do you read that to be the same?
Yes, sir, that's correct. First of all, in regards to your first statement, once we have some clarification, we'll certainly post it on everybody's website, some simple question and answers, and what gets eliminated, what doesn't. So we can take care of that. In regards to 84 versus through 88, yes, you still remain on the site. Matter of fact, you still have to register. And one of the proposals in our in my testimony also addresses a sex assault. It's more of a possession of child pornography too. So it's a cleanup on both sections.
Well, just to address my vision is not just if you had a class D felony, pre-1992, that it's erased. I would ask for a specific list of statutes, so that somebody goes and gets their criminal history from your department, they pay their $75, which that's a discussion for another day. And then they can compare it to the list, say, okay, this thing's gonna go away. That's what I'm looking for. I think that's what the public is looking for. But I thought the intent of the legislation that I voted against, but the legislature passed, was to erase the footprints of these things as well. So how, if the intent is to follow the policy as dictated by the legislature, and I'm not saying I'm in favor of this, I'm just trying to look, congruent application, we're going to erase a crime yet require an individual to be on the registry. Can you explain, unpack that?
I can't unpack that for you, sir, but I can. You're right. It does say in the law that that subsection doesn't terminate the obligation to register.
Okay, well, and then if we shift to 89 through 92, which has to do with standing criminal protective orders. I have a client who got into a domestic about 10 years ago. And he's got a standing criminal protective order, I believe, for the rest of his life with regard to the victim. Now, I believe under what he was ultimately convicted of, that his conviction would be erased. However, what I'm seeing in lines 89 through 92 would mean that the criminal protective order would remain in place, so he could possibly be arrested for violating that in the future. Am I reading that correct?
That would be my interpretation. Yes, sir.
Okay. And not that I'm for or against, I don't know that a lot of people read this stuff, but then looking at lines 155 through 171. What is the intent of that paragraph? I know it's maybe a difficult question because there's a bit of text there, but it appears to reach out to third parties for a fine, right? If you don't follow the procedure. And I'm particularly in lines 164 through 166, right?
Yes, sir. I see it.
So what is the procedure? And I'm just going to read it for those following along. The judicial department or any criminal justice agency shall fine such person $10 per record per calendar day. I'm not aware of any adjudicative proceeding in this state that would provide for that, because I'm all about due process and equal protection. So please explain to me, what is the process that is anticipated to be followed there?
There is no process in place at this time, sir.
So is there draft language? We're being asked to pass this thing to clean up this sea change in policy. How can I support this if there is no policy in place?
Well, the system isn't even running yet, so we have time to put policy in place.
Okay, would I expect that policy is going to come before us, or is it because it's characterized as a policy and not a regulation that something else happens?
I wouldn't expect that policy to come in front of the legislature, no.
You would not, or would?
I would not.
Okay, and why is that? You've got the executive branch delving into directing the judicial branch to do something without the third leg of government being involved. I thought we dictate adjudicative policy or procedure.
You do dictate policy, sir. On this procedural part, judicial department will be the lead. We're not even close to even discussing this one yet.
Okay, and then at the end of the language, it has to do with claims against the state. Lines 211 through 214. What is the intent of that portion?
Let me just take a quick look at it.
Sure, right at the very end.
The intent appears that no person shall have a claim against the state or any state agency for compensation or payment for failure for an erased record pursuant to the provisions.
I know what the language says, but it says before January 1 of 2024. So this is a rolling policy, right? So 5 years from now, if somebody had a misdemeanor conviction today, potentially they are within the next 2 years, that is going to be erased so long as they don't reoffend, right?
7 years, yes, sir.
Sure. But this bars a claim against the state if it's not erased before January 1 of 2024. So if the erasure is supposed to happen prospectively 7 years from today, and it doesn't happen on that day, the way I read this language is you would have a claim against the state. Do you read it differently?
I'm not going to agree with that, sir. This language was put in place. All it claims is that no person shall have that claim. That date can be adjusted, I imagine.
Yeah, the problem is the date, right?
Correct.
So I think it should say within, let's say, 6 months of when under the statute it should have been erased, right? 6 months would be unreasonable in my opinion. If something was supposed to be erased and it wasn't, and it's the state's fault, it's a claim against the state. But you can't go back and say what this says because of the date. You would agree?
I'd agree with the date, yes, sir.
That needs to be adjusted.
It could be adjusted, yes.
Okay. All right. Thank you. Thank you, Mr. Chairman.
Thank you, Representative. Comment or question from other members of the committee? Comment or question from other members of the committee? If not, thank you very much for joining us.
Thank you, Senator.
All very good reasons for having public hearings. Yonatin Zamir,
That's me. Good morning.
you may proceed.
Good morning, Mr. Chairman, Senator Winfield, Representative Staffstrom, the ranking members, Representative Fishbein, Senator Kissel, and the other distinguished members of this committee. Thank you all for your service to our state, and I appreciate the opportunity to testify. I'm submitting written testimony in support of this technical correction bill. My thanks also goes to the commissioner who just testified for his work and his colleagues' work in trying to do their best to try and address the concerns that were raised by the judiciary as well as by the governor's staff as they tried to help implement this bill. I'm a legal services attorney, New Haven Legal Assistance Association, and we provide civil legal services to as many folks as we can. And as you can imagine, as a civil legal services attorney, I have to turn away a lot of folks whom I do not have the resources to represent, but I can only give advice to. I also co-teach a law school re-entry clinic, and with the help of a number of very smart and capable law students, one of the things that we do is we try to address the conditions associated with being a person who is formerly incarcerated. We work with those folks who have the criminal convictions and try to help them do things like get housing and get jobs that they're barred from doing. So you can imagine that with the passage of the Clean Slate Law, myself as an advocate and others were very excited and very filled with a lot of hope about what could be for a lot of our clients who are continuously just hampered by criminal records that are in many ways very old. A lot of them have paid their debts, obviously, to society. Not a lot of them, all of them have. And a lot of them are still suffering in the sense that they're still barred from some of the basic things like employment and housing. So the delay in the implementation, obviously with this bill offering the technical corrections is amazing, and I'd like to fully urge swift passage and let you know of just a couple of specific stories. I heard testimony earlier from a member of the public who spoke about her what could be, she could be a client of mine if she was if she was income eligible, right? I'm helping people who are exactly like that, who are barred from getting further employment or from advancing in their employment. So you can imagine they're very limited in what they can do with their lives because they can, they were lucky enough to get whatever job they have, but they can't advance because of the criminal record. I have another client of our clinic who has been languishing, basically homeless, for a number of years now, and has been on a wait list to apply for HUD subsidized housing in the area. And he was called, he got the call, hey, you can apply, your name came up off the wait list after however many years. And to even be considered for housing, he may otherwise qualify and his application may be accepted, but it'll be denied because of the criminal record. So we have to spend a lot of time, resource advocating.
Time has elapsed.
Yes.
Thank you very much. Comment or question from members of the committee? Comment or question? If not, thank you very much for joining us to share your perspective. Have a great day.
Thank you.
James Williams. You are here.
How you doing? Good morning, committee. How you doing? Thanks for giving me a chance to speak today. I'm James Williams. I'm with the Republican Town Committee of West Haven, Connecticut. I'm here today to express my support for a long overdue Senate Bill 5, strengthen the protections and response to domestic violence. My reason is as follows. In the state of Connecticut, when one of our valuable female residents get fed up with their abusive partner and take the initial step to separate from him and obtain a protection order for their safety. It seems to me, referring to 3 cases that just happened in Connecticut, the ex-boyfriend or husband violates that protection order and harms or even kills the female victim. What gets me more upset with these cases, the victim would notify police and show proof the suspect is threatening them and violating the order, and the police don't act. Then I think to myself, why didn't one of my well-respected police officers didn't step in and arrest the suspect before he was able to do any harm? I met a woman last year in Norwalk that was at the time living in a battered women's shelter. And I said to myself, there's no need for our battered women's shelter if we just arrest the individual who is battering them. People tell me most women let their abusive partners back into their lives. So it's their fault if something happens. But I know most women are caring, loving human beings and still show compassion for individuals they care about, even if they are doing something unethical to them. Because domestic violence is on a rise, because most bullies love targeting people who they know other than people who they don't know, for some type of feeling of control of another human being's life. This bill will force our police departments to step up their game and protect those vulnerable residents who are in need to be protected from an individual who is willing to obstruct their rights to safety and peace. Thank you.
Thank you, Mr. Williams. Thank you for joining us again. Comment or question from members of the committee? Comment or question from members of the committee? If not, as I said, thank you for joining us again. Have a great day. Al Erdin, Islam. Al Erdin, Islam. Jeff Clayton.
Morning, Mr. Chair, members of the committee. My name is Jeff Clayton. I'm the Executive Director of the American Bail Coalition, here to testify against House Joint Resolution 261. I've worked on this issue for 34 years, and so I kind of know what I'm talking about. But what this legislation does is eliminate a core constitutional right in Connecticut, the right to bail, and ask the voters to vote for an unknown system of bail. But what that system really is going to be the federal system, a system of preventative detention and release. Former Justice Thurgood Marshall called preventative detention policies consistent with the uses of tyranny and tantamount to a police state in dissenting from the decision to allow preventative detention in the federal system in 1984. At the time, the arguments are very similar to what they are now. People can't afford bail and we need to do something about that. And at the time, 24% of defendants waited in jail pending trial, an average of 60 days each. And fast forward to today, 75% of defendants in the federal criminal system await trial behind bars, and they do so for an average of a year. A recent study by the University of Chicago said that preventative detention policies in the federal system have created a culture of detention where we err on the side of detention. And that's been a major shift. At the time, and if you've listened to the oral argument, the Solicitor General told the Supreme Court, we will restrain ourselves on this. We will not go and start locking more people up and locking more people up. But that's exactly what happened. And so if you were going to replace the right to bail and you were going to expand preventative detention, there should be some data that says these are the worst of the worst. And that's what the Supreme Court was talking about in 1987 in the Salerno decision. And so you might go through an exercise like California and some of the other states that say, if you have a 3-time violent felon, then there could be eligibility to deny bail. Or if you have a 3-time violent sex offender, or if you have eligibility for a life sentence, then you could seek preventative detention. And so this would be the most expansive preventative detention constitutional provision in the nation. And I can tell you that the New Jersey system is very similar. And what has happened over time is the creep of preventative detention has increased. The goal of reducing racial disparities of the incarcerated population wilted away and hasn't happened. And so the dream of self-control that we could replace the right to bail with something else just hasn't proven to be the case. I would encourage you, if you're going to do something on bail, to do something at the low end, to look at maybe certain charges where we don't need bail, or where we don't need arrests, or where we need citations. And that's what's happening on the other side of the Hudson. Preventative detention policies in that caucus would never fly. In fact, even basing bail on prediction of future dangerousness would never fly on the other side of the Hudson. So these are evil policies. I've watched these policies in operation for the last 34 years. And it has nothing to do with bail bondsmen or anything like that. It's just a civil rights atrocity. And I encourage you to vote against it.
Thank you.
Thank you.
Representative Stasher.
Thank you, sir. A question for you.
Yes, sorry.
So you referenced a couple instances. You talked about a 3-time violent sex offender. Under the current construct of the Connecticut Constitution, isn't it true that even if this legislature wanted to say you've committed 3 very violent sex offenses in rapid short order while awaiting trial for the first one, we cannot hold that person in lieu of bail, correct?
That's correct. And I guess the point I was trying to make was that other states have changed their constitutional provisions to put in certain specific
But the point
sections.
is we have to change the Constitution to do that in Connecticut.
You would, yes.
Right. If Adam Lanza had survived and walked out of that school in Newtown, he would have been entitled to bail under Connecticut law, correct?
Yes.
And frankly, there's nothing this legislature can do to stop that without a change in the Constitution, right?
That's right. I mean, we rely on judges, as this state has for the last 3
No,
years.
we can't, because we can't, under our current construct of the Constitution, we can't enable judges to hold someone without bail. It's not, the legislature couldn't possibly do that. It would be unconstitutional for us to say that.
That's right. Connecticut is a right to bail state.
Okay, thank you.
You got it.
Comment or question from other members of the committee? Comment or question from other members of the committee? If not, thank you very much.
Thank you, sir.
Hal Basso.
Good morning, members of the Judicial Committee. I'm here to testify about 926 for the Connecticut Psychiatric Security Review Board. This morning, I'd just like to talk to you about the recommitment of acquittees under the Psychiatric Security Review Board. For the last decade and a half, there has been acquittees who have been recommitted 5 times past their time. If you spent 25 years under the board, you're spending 40 years under the board. If you do 10 years of commitment under the Psychiatric Security Review Board in our state, you end up spending 5 more years past that time. Here in our state, we have had individuals throughout the last few years receiving 40, 60, 70 years. And it's come to a point where we have to start recognizing here in our state, if you were to commit a murder act, if you were to commit a sexual act, you would head off to correctional institution. You would have a set time that you are committed to that institution. When you come to an institution such as Whiting and under the Psychiatric Security Review Board, you have that stigma that says you are indefinitely committed for the rest of your life in a term that will never end. And in our state, I know for the 15 years that I've been under the Psychiatric Security Review Board, I've seen a number of clients come through the facility with high numbers that are very outrageous for crimes that did not deserve the amount of time that they've gotten. And had they went to prison, they would have had a significant amount of time, but a time that would have set them to know what date they are going to be released in society. So I believe currently right now that there are over 25 acquittees right now under the jurisdiction of the board or have been committed 5 times past their time. I've seen so many numbers come in here, and the numbers are just the numbers that the board has given to all of the acquittees. And I certainly believe that it's kind of outrageous in our state how we're allowing this to happen, allowing to lock away the criminally insane who are here to get recovery. And the PSRBs in our state allowing these high numbers, 120, 110, 40, 60, 80 years for the crimes that does not deserve that amount of time. It's not fair, it's not fairness, it's not justice, and it's certainly not recovery. And the real madness is we're told to tolerate this in our state. Thank you.
Thank you, Mr. Bethel. Comment or question from members of the committee? Comment or question from members of the committee? If not, if not, Mr. Bassel, thank you very much for testifying this morning.
I appreciate the opportunity to express the concerns about the Psychiatric Security Review Board in our state.
Thank you. Patrick Griffin.
Good morning. For the record, Patrick Griffin, Chief State's Attorney. Good morning, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, Representative Porter, and other distinguished members of the Judiciary Committee. It's my pleasure to speak to you briefly today on Senate Bill number 1070, an act concerning prosecutorial accountability. I would note that the division has submitted written testimony on this bill as well. Just briefly before I begin my comments on that, I would just note that New Haven State's Attorney Jack Doyle will be speaking today on sections 1 and 11 of HB 6917. Waterbury State's Attorney Maureen Platt will likewise be speaking on Senate Bill 926, and Inspector General Robert Devlin will speak on Section 8 of 6917. As you're aware, Senate Bill 1070, an act concerning prosecutorial accountability, really can be broken down into 2 sections. Section 1 seeks to reduce the terms of the state's attorneys from the current term of 8 years to 5, and Section 2 seeks to have the state's attorneys appear annually before the Criminal Justice Commission to address criminal justice data collected the previous year. I would indicate to this committee that the Division of Criminal Justice is in support of Section 2 of the bill. We acknowledge, that is, that the division acknowledges the importance of capturing, tracking, analyzing, and sharing data, statewide criminal justice data. The state's attorneys unanimously recognize the importance of making themselves available, not only to talk about data, but really to contextualize data. And what I mean by that is the individual input from the state's attorneys. The division, however, opposes Section 1 of the bill, which seeks to reduce the terms of the state's attorneys. As you're aware, the state's attorneys are constitutional officers, much like Superior Court judges. They have an 8-year term. It's my position and the position of the 13 states attorneys that this term shields the office from undue political or public pressure. I would submit to you that the state's attorneys are in fact the most regulated of all attorneys in Connecticut. They're accountable to the Criminal Justice Commission. As all attorneys are, they're accountable to the statewide grievance panel. They're accountable to the judiciary on a daily basis. We currently have internal biannual peer reviews, the results of which are shared with the Criminal Justice Commission, or will be shared with the Criminal Justice Commission. We also have ethical responsibilities to the accused, defense counsel, to victims, and to the trial court. The division has taken great steps over the last number of years to engage our community. We feel that shortening terms will in fact disrupt the operation of our offices. We think it'll have an impact on the willingness of younger prosecutors to seek this position. As I've indicated on other testimony, the division has lost 21% of the current workforce. We've had state's attorney positions open where we've had 2 applicants. So thank you.
Thank you, Attorney Griffin. Representative Fishbach.
Thank you, Mr. Chairman. Good morning,
Good morning.
Chief State's Attorney Griffin. You're here testifying on section 1 and section 2, you're deferring.
No, we approve of, we support the data collection and having the state's attorneys go before the Criminal Justice Commission. We have no issue with that.
Okay. I'm just concerned in going before the Criminal Justice Commission, that's shown in lines 150 through 152. That would be frontline state's attorneys going before the Justice Commission, correct?
Correct.
And for what purpose?
So as I understand it, given the reading of this bill, currently the data that's collected pursuant to Public Act 1959, those 13 data points, those 13 data points, 3 of which the Division of Criminal Justice is responsible for collecting, prosecutorial diversion, victim contact, and last best offer. All those data points go into a report presented to the Criminal Justice Commission by OPM, at which I currently, as a member, participate. So it's our position, it would essentially be the same data, and we're not concerned about answering questions related to that.
I understand that your office, at least in my experience, has been open and communicative. One of my concerns is opening up a state's attorney to ridicule and public comment before a body like, because I believe they allow public comment and that kind of stuff. The data points, every case is different. Some fall into clumps, right? But looking at data without looking at the macro without looking at the micro is a very skewed thing to do based upon jurisdiction, GAs, right? So, in a particular GA, you may have more larceny cases. In a particular GA, you may have more violent cases. The penalties, fines, and that kind of stuff are going to be all different based upon the case. But I'm reading this data collection is lumping. Am I reading that incorrectly?
Well, I'm not sure how you define lumping.
Well, that the result is in this GA, there were 23 cases that involved assault third. That's a lump, right?
Not to interrupt you, currently it's disaggregated data, so it's at the 30,000 foot level that the OPM reports have generated. Now, down the line, it may get to that point, and certainly the state's attorneys are concerned about, as you put it, facing public ridicule. But we're also, constitutional officers. We're also willing to stand behind the decisions we make. And frankly, I think it would be difficult for me as the chief state's attorney to sit here and say to you, don't cut my terms of the state's attorneys on the one hand, and then for 8 years, don't ask them any questions. And so that's the decision we've made. We're ready to stand up. We're ready to answer questions. I hope there's not public ridicule. When I talk about contextualizing, what I mean by that is that I think the state's attorneys and the chief state's attorney is in the best position at times to discuss what the data actually means, because just looking at the data doesn't give you the full story. And so this would give us a seat at the table. Are we concerned? Of course we are. That this could go further. That if we're asked questions that invade the province of the prosecutorial discretion, then and unfortunately the answers may be that we can't answer certain questions.
And that's my concern, is lumping these things together. What I would have is, a docket number, the charge, the disposition, line by line, if you're gonna do this, right? Because then you can have a discussion about that particular case.
That's not what this says, according to the way I read it.
Agreed.
And I can't speak for OPM, but I don't think OPM is in position to do that presently.
No, but that's the concern. So, because every case is different.
Right.
So, and in this building, in this room, quite frequently we hear anecdotal stuff about, what somebody read in the newspaper, but they weren't part of the process.
Correct.
Right. So now we've got a state's attorney who is part of the process, and they've got 27 assault thirds in their jurisdiction, that the average fine was $200, but another district may be different. So now, the other district that the average fine is $500, that may be appropriate because maybe there was no time served or some other mitigating factor in those cases. But when we look at all of these cases in lumps, you are more inclined to come up with generalizations.
Representative Fishbein, you raise very thoughtful concerns. I will tell you that the last 2 days I've had meetings with the 13 states attorneys, and it really comes down to this: can I sit here and say that we will not answer questions on data that is collected publicly? I don't know how we can take that position, and we won't take that position. Now, if it gets lumped or becomes invades the province of prosecutorial discretion, if we get into an area where we can't discuss an ongoing case or controversy, and I think we're quite capable of saying, respectfully, we cannot answer that question.
Understood. I just think that even section 2, although you support, is bringing us down a road that I know where the advocates want us to end up, but it's incremental in the building. So I thank you, sir, for coming here for your testimony.
Comment or question from other members of the committee, comment or question. Representative Staffstrom, sorry, I was thinking Fishbein again.
Thank you. And sorry, Mr. Chair, and not to get us off topic, but I just wanted to publicly state, Mr. Chief State's Attorney, I know you're not here testifying on the clean slate bill before us, but I just want you to know how appreciative leadership of this committee has been of the work your office has been doing over the last couple weeks, in particular on trying to help with some of the implementation concerns, trying to streamline the process with respect to some of the pre-2000 applications. And I know you're not here testifying on a specific policy before us on that, but I think it should be publicly stated how helpful the Chief State's Attorney's Office has been in helping us get to implementation of the policy of this legislature. So I just wanted to publicly thank you for that.
Thank you, sir.
Thank you, Representative. Question for you. Listening to the conversation you had with Representative Fishbein, do you think though that there is some value as well at looking at the data from the perspective that the bill calls for?
Yeah, as the Chief State's Attorney, I've only been in the office since May. As you're aware, under statute, OPM is required to put together the prosecutorial data report. And so I sat as a member of the commission and as the Chief State's Attorney in that interaction with the commission, and I thought it was helpful. There are times in which, we look at data, a set of numbers, which does not, in our opinion, tell the full story. And I do think it would be helpful at times. And I use the word contextualize because that's the term that a term of art that our data analysts have given me. It allows us to explain perhaps why there's an anomaly or what might appear to be a discrepancy or disparity. We can't always do that, but I do think if we have a seat at the table, we're at least having at bat.
And I think that the question of whether or not the state's attorneys would be ridiculed is a perfectly good thing to think about. But as things currently operate, that happens anyway. And sometimes it has had impact when those 8 years elapse. And I think being able perhaps to talk about things before the 8 years may actually have an impact for the positive, actually, for some of those state's attorneys. So,
sir, we're professionals and we're prepared to stand behind the decisions we make and discuss those decisions, as long as, again, I will state for the record, as long as we don't invade the province of the prosecutorial discretion. We can't be talking about an ongoing case or controversy. I think we'd all agree that can't happen. But beyond that, when we're talking about data, I think it would be helpful. And this is, again, I would just state again for the record that over the last 2 days, the state's attorneys, all 13, myself and the deputy chiefs, we met. We discussed this at length. This is not an easy step for the division. Representative Fishbane identifies areas that are a concern. But on the other hand, I'm going to say it again, we're asking not to cut the terms and saying that we are accountable. It is difficult for me to say that and then say for 8 years, don't ask us a question.
well, thank you for joining us today. I will just say this as someone who is often engaged with your position in not the most friendly way. I do appreciate wherever we wind up that the office has endeavored to make an attempt to work with us on this. So thank you. Next, and have a great day. Next, we'll hear from Senator Looney, if he's here. See him. Mercer May. Mercer May. Wyatt Bosworth.
Chair Staffstrom, Winfield, ranking members Fishbein and Kissel, distinguished members of the Judiciary Committee. My name is Wyatt Bosworth. I'm assistant counsel with the Connecticut Business and Industry Association. Thank you so much for the opportunity to testify on Section 13 of Senate Bill 3. Let me begin by saying that CBIA shares the committee's goal of ensuring our workplaces are as safe as possible for employees, and we are a willing, committed partner with you to safeguard all workers against sexual misconduct in the workplace. However, Section 13 would do nothing to protect employees and would instead unfairly subject employers to severe financial liability for the alleged tortious act of persons who are no longer within their employer under their control. To our knowledge, the mandatory disclosure rules under this section would make Connecticut a national outlier by imposing third-party tort liability on employers for the future misconduct of former employees. Section 13 would effectively require any employee of an employer, think a manager or a supervisor, that gives a recommendation or positive commentary, both of which are not defined under the section, about a current or former employee to another potential employer, so a future employer, to disclose any known allegation of sexual harassment or sexual assault. And known under the section is defined as actual knowledge, which is also not defined under the Act. That has resulted in a filed complaint with CHRO, the EEOC, or a criminal complaint with the judicial system. Should this employer, that manager or supervisor, fail to make this disclosure within 1 year, the employer would be held liable in perpetuity to the new employer that relied on that reference for sexual misconduct committed by that referenced employee. So while clearly the goal of Section 13 is to encourage employers to disclose known instances of sexual misconduct, I can tell you that the practical effect of this is the opposite. Fearing liability and the undefined, vague, and unworkable standards in this bill, employers, especially large ones, will adopt strict policies prohibiting employee recommendations a practice that many large employers impose today. Job seekers, especially innocent parties who are wrongfully accused, would also be negatively affected by this section. It's important to remember that allegations regarding sexual misconduct in the workplace are often complex and not always clear-cut whether it actually occurred. So, for example, it's common for civil cases to settle prior to trial and for CHRO complaints to receive a release of jurisdiction or a settlement. This is not an admission of fault or liability, and it does not necessarily mean the accused party committed the offense. Given the severe consequences for noncompliance of this non-disclosure, even the most frivolous complaints would need to be reported to a prospective employer before the employee even receives full due process guaranteed to them under the law. There's a host of other issues with this section, but given the time constraints, I'll just stop here. Happy to take any questions.
Very, very light on your feet. Representative Fishbach.
Thank you, Mr. Chairman. Good morning, sir. You said you're here in what capacity?
I'm here on behalf of the Connecticut Business and Industry Association. So
Okay.
we represent thousands of employers across the state, small and large.
And if this section 13 was to pass, what would your organization recommend to employers with regard to the new law?
It's tough to say because this new law is very confusing. So as I said, we wouldn't even be able to counsel our employers on what actual knowledge of this sexual misconduct is. We also know employers probably don't have the resources to actively track all CHRO and criminal complaints. So to be honest, I've spoken with a host of employers over the last week since this bill has been filed, and I can tell you, I think the counsel would be just institute a no reference policy, especially given, the liability that's imposed on that employer if they don't comply with this. And even if they instituted a no reference policy, right? Think about an employer with 20,000 employees. That doesn't stop a manager in another state down the line from, not complying with this rule as well. And that would still hold the employer liable.
And I guess, during the pandemic, I had the opportunity, well, it was a learning experience. An egregious employment case came across my desk where the owner of the company was using very derogatory terms with the employee, and that culture was permitted in the workspace, so others started to do that, and it became not only derogative to the gender of this particular individual, but also their race. And it was a horrible case. So, I can understand in the employment aspect, but, certainly there's innocent people out there too, right? So if a business institutes a no recommendation policy and somebody wants to go work somewhere else and there's a no recommendation policy, doesn't that hurt the innocent also?
Absolutely. And I just want to hammer home, we've been shouting from the rooftops that this state has a workforce shortage crisis right now. There's 100,000 open positions. And if something like this passed and employer speech and the ability to share information was chilled, it's going to have an effect on employees' mobility and their ability to move from workplace to workplace.
And then this language also, would it require an employer to track whether or not an EEOC complaint was filed with regard to the employee?
Yes. So under section 13, by default, this duty to disclose lasts 1 year from the time that referencing employee, so that manager or supervisor, has quote unquote actual knowledge of the act, right? And that year period can be cut short, so it could end before the year if a number of things happen. One of them, which you raised, either a CHRO complaint is, I think under the section, it says it's withdrawn. So I'd assume that means a settlement occurs between the two parties, or a finding of no probable cause is found as well.
So you're right, employers would have to actively track the stages of all CHRO complaints because it affects the time frame in which the duty to disclose is active.
And then what about complaints in the employment sphere that are investigated internally and found to be unfounded? What would be the duty to disclose those?
It's unclear. So the section very clearly defines sexual harassment as the definition under the Connecticut Fair Employment Practice Act, and it defines sexual assault under the criminal code, right? So presumably, in order for an employer to have actual knowledge that some act occurred, they would have to draw a legal conclusion on the behavior that that employee exhibited, right? So that employer would be forced to decide whether they think that the law was violated, whether it be criminal law or the Fair Employment Practice Act. But to your point, sexual harassment is a very complex situation, right? Everything from a hostile work environment claim to a quid pro quo claim. It's very fact intensive, and employers just don't have the resources, and it's not their responsibility to make legal conclusions on alleged complaints.
You know, it's interesting you bring that up because the other day in public safety, the chair said that I was cute. And somebody came to me and said, were you just sexually harassed? And I was like, well, I just thought it was funny, but within a certain sphere, one could believe that to be sexual harassment, and you'd have to go down all the paths here. Just another, you had mentioned about the CHRO, the obligation of the employer to know what is going on potentially with CHRO and status of cases. How does an employer get access to that? Because I don't think they're online. How would that happen?
So I'm not a total subject matter expert in the CHRO process, but from what I've learned in the last couple of days speaking to people who are, the employer would likely know that a complaint was filed, and they would most likely be brought in as either like a witness or a party to the action, right? But these CHRO complaints are not public by default, right? So if you have a hypothetical where this employer wants to write a positive recommendation for an employee, they have actual knowledge, which we don't really know what actual knowledge means, and a CHRO complaint was filed, that employer would now share that CHRO complaint with the future employer, who by default couldn't have access to the facts of the information in that CHRO complaint under law today. So essentially, you'd put the employer in a position of either disclosing the known facts or in that CHRO complaint, which may be in a different stage, right? It could be at the MAR stage, it could be at the investigation stage, it could be at the public hearing stage, it could have been released, right, to the courts. They could, I guess, tell the future employer that, or they could just simply say a CHRO complaint is pending. And then the future employer, they'd make the conclusion that this is probably not someone we want to hire, right? Despite that employee who's subject of that complaint, right, the alleged harasser, never actually having due process, right? CHRO has not finished the process. It has not been released to the civil courts. The civil courts have not litigated this yet. So you're dealing with an employee who's alleged to have violated these statutes. And that future employer would become known, right? They'd know about that, but I presume they wouldn't know the details of that.
Yeah, that's of concern. I had a case of CHRO a few years ago, and they didn't follow their internal practices procedurally in the division itself. So I don't even know that one can rely upon that mere disclosure that the complaint is out there. So, but I thank you for coming here today, and I thank you for the exchange.
Yeah, and one more thing, thank you for the questions. Good to see you. Over 50% of CHRO complaints are dismissed every year too. So just something to keep in mind.
Thank you. Comment, question from members of the committee, comment, question from members of the committee. Seeing none, thank you for joining us today.
Thank you.
Next, we'll hear from Megan Scanlon.
Oh. I think, does this your sound? Good morning, Senator Winfield, Senator Kissel, Representative Fishbein, and Representative Staffstrom. My name is Megan Scanlon. I'm the CEO at the Connecticut Coalition Against Domestic Violence. And I'm just joined by my colleagues, Jerry O'Neill Wild and Rhonda Morrow, who are Director of Legal Advocacy, for them to answer any questions.
But you're the one, you're testifying.
Yes,
Okay.
they're just here if there's anything they can add to answers to
All right.
questions.
Are they signed up?
Yes, they are later in the.
Okay, all right.
Yeah.
Proceed.
We're here today to urge you to support Senate Bill 5, which is one of CCADV's priority bills. We'd like to thank Senators Looney and Duff for their continued leadership in supporting survivors of domestic violence. Section 1 of the bill proposes statewide expansion of the state's domestic violence offender GPS monitoring program. The program provides value to the state's overall response to domestic violence, although not all victims choose to participate. As expansion progresses, we do believe, based on our experience with the program, that there is opportunity for system enhancements, which can be assessed and developed by the Domestic Violence Advisory Council proposed in Senate Bill 1118. So we do welcome the opportunity to work with the proponents and the judicial branch on the program expansion. Section 2 of the bill seeks to prohibit abusers convicted of attempted murder, conspiracy to commit murder, or certain Class A or B felonies designated as family violence against their spouse from receiving alimony from their victims. Existing statutory language leaves it to the discretion of the court in entering alimony awards, weighing stated factors. There are situations where an award of alimony should simply never be considered by the court, and this proposal removes those situations from the court's discretion. The prohibition of an alimony award is not sought to limit any power of the court, but rather to eliminate the power of those convicted of crimes from continuing to abuse their victim by use of the legal system. Finally, sections 3 and 4 of the bill propose that funding be allocated to the judicial branch in fiscal 24 and 25 to address the ongoing cuts to the federal funding source Victims of Crime Act. CCADV and several other VOCA-funded nonprofits did testify before the Appropriations Committee in favor of the governor's proposed fiscal 24 allocation of just over $13 million in ARPA funds to cover the VOCA gap. And we are asking the committee to include an additional $20 million in fiscal 25. This funding is needed to keep all victim services whole, which includes approximately $3.8 million for domestic violence services. While we recognize it's not up to this committee to determine the state spending, we did want to point out that these funds do fund critical domestic violence services statewide, including our court-based advocacy, with work with law enforcement, and our statewide domestic violence hotline. A funding loss of this magnitude would devastate our service system, and we're happy to answer any questions.
Thank you. Senator Kissel.
Thank you very much, Chairman Winfield. Ms. Scanlon, nice to see you again. Glad that you're feeling better as opposed to when you were in the St. Patrick's Day Parade.
Yeah, sorry, I do have my voice back.
The other day. I understand we've discussed about a lot of these issues prior there too. Appreciate the initiative offered by my colleagues on the other side of the aisle, the Senate Democrats. I understand the whole financial one. That's not really within our bailiwick. That'll be an appropriations decision. Regarding the little part regarding the alimony, I'm very sympathetic to that, but I'm just wondering, in the great scheme of things, it strikes me that that's probably a narrow. I don't know. Can you just tell us how often are you aware that that occurs? Is that a sort of a growing trend, or is that just occasionally and we just want to take away, just like we did with like the gaslighting and things like that? It's just a tool out there used to harass and harm another, and it doesn't have to be a guy, it can be anyone, man, woman, co-partners, it's anything. That's one of the things about domestic violence. It's not always man, woman. Can you just expand on it?
Yeah, so I can expand, and then certainly would encourage my colleague Rhonda to jump in, but we haven't necessarily had any cases in Connecticut that have reached the court, correct?
That's correct. But we have had other coalitions across the country that do have cases within their court system. So we were simply trying to get ahead of what we see as a trend across other states to make sure that it doesn't become an issue here in Connecticut.
Good morning. Thank you. Rhonda Moore, Director of Civil Legal Advocacy for the Connecticut Coalition Against Domestic Violence.
Ma'am, what number were you what number are you? Oh,
I think that the concern is the legislative abuse, and I'm sorry, the litigation abuse that occurs. We have had a number of contacts with individuals who may accept and agree to lower charges being brought for the sole purpose of trying to get out of the court system and get on with their lives. And then they are stuck with a situation where the other side is asking for alimony for those same acts that they agreed to reduce the charges for. That was a specific phone call that I took that started the initiative and the questioning our end. If the person, the offender, was unsuccessful in their attempts or successful in their attempts and had actually killed the person, they would not be able to collect their life insurance. They would not be able to collect their pension benefits because they're unsuccessful in their attempts to assault or to kill somebody doesn't and shouldn't give them the right to collect alimony.
Okay, and could you just, I don't know if the Senate Democrats collaborated with you folks as far as research and things like that, but are you aware of other states that have passed substantially similar provisions and they're now law?
Yeah, specifically California. California actually did it as a two-step process. And the first step was put it into the court's discretion to prohibit alimony based on those facts. And the case is Ms. Crystal Harris, who was ordered to pay $1,000 a month in alimony and $47,000 in legal fees to her husband, who was convicted of a felony sexual assault against her and was incarcerated. After that case, legislation was enacted for a straight prohibition on certain charges. And California actually goes a step further and adds in misdemeanor as well as other uncharged domestic violence as a factor in the alimony provisions. Louisiana also has it, but it's based on a fault base. So Louisiana is a fault-based state. So in order to collect alimony in Louisiana, the victim would have to show that they are not at fault and that the charge occurred. And that's exactly what we're looking to avoid, is putting the burden on the victim to show under the alimony statutes and the alimony factors under 46B82 to have to prove their victim status.
Okay, thank you for that elaboration. California, interesting. They're always doing things out there on the West Coast, and Louisiana, a lot of their laws based on the Napoleonic Code and that sort of paradigm as opposed to the common law of Great Britain. Thank you both. Thank you, Mr. Chair.
Thank you, Senator. Representative Fishbach.
Thank you, Mr. Chairman. And I'm once again, I think I'm in favor of the bill with the exception of section 2. What is because I know, Rhonda, you have some experience. I think we had a case together.
25 years of experience representing children and adults in family law.
So what is the purpose of a pendenti lite order or a temporary order as referenced in this language?
I'm sorry?
What is the purpose of a pendenti lite or a temporary order in family court?
What is the purpose of it?
Yes.
To provide temporary relief to a party during the pendency of the divorce.
Well, generally is to maintain the status quo as was prior to the action being filed.
If possible.
Yes.
Yes.
So, financially, that's the intent. So I guess we have to play with the scenario. So, so that we can apply that to various boxes. It's a husband, wife, husband commits a heinous felony, family violence upon wife. They've got 2 kids, just for the scenario. Now they're gonna get divorced. He is not incarcerated. He's merely been charged. If this was to pass, would bar a temporary order?
It doesn't apply. It
Okay.
applies only for convictions of those enumerated crimes.
Okay, I just
So it's
want,
only upon a conviction.
yep, just wanted to, and then move to the conviction. So upon conviction, divorce is still pending. They're living separate and apart. They each have their own homes. Ordinarily, pendenti liti on a temporary basis. Let's say he's not working. The court's gonna order some sort of payment from her to him as alimony to preserve that home so that at the end of the divorce, it's still there. It's not foreclosed on, right? Isn't that normally what a pendenti liti order would do?
I would surmise that if he was convicted of a felony sexual assault against his wife, that he would be incarcerated.
Yes, but
So the award of alimony to an incarcerated individual or somebody who is not incarcerated from the person that they assaulted would be unconscionable.
okay, even though there has to be a way to preserve that asset. So ordinarily, the court can fashion orders as it sees fit. They don't have to make her pay him directly. They could say, that through direct deposit, and that may have been the way it was set up prior to the divorce being filed. That money was being funneled into his account by direct deposit, the mortgage was being paid, right? So on a pendenti liti basis, the court very often would say, well, keep on making that payment. That is the alimony there. Wouldn't this get rid of that?
Would she be residing with the 2 children in the home?
There's 2 homes in the
Oh.
scenario, right? He's got his own house, she's got her own house, she's got the 2 kids, right? So now we've got 2 assets that we want to preserve so that the court can divide them at the end of the divorce, right? So he's incarcerated. He's filed a motion for alimony, perhaps a motion for contribution to household expenses as well. And the court says, yes, I'm going to order her to pay him alimony into the direct deposit so that the mortgage can be paid. This would prevent that.
That's
right?
correct.
Okay. Isn't this claim in our scenario, right? Isn't that already baked into the statute? 46B82 gives a long list of things that the court is supposed to look at when they order alimony. We're just getting down to that actual list. The duration of the marriage, the length, the causes of the dissolution. So, he committed this heinous crime against me. He has been arrested. I have realized that this is not going to work. I'm filing for a divorce. In opposition to the alimony, he is a domestic violence abuser. Therefore, don't give him alimony. Isn't that already baked into the statute?
That goes exactly to the 2 points, our main 2 points. One is that it puts it in the court's discretion, which allows for the litigation abuse. So in your scenario, husband gets habeas into court 4, 5, 6, 8 times on a claim of alimony. And the victim has to continue to show up for each and every one of those hearings. And then the victim has to prove that they are a victim despite a conviction for an assault or an attempt to assault against them. That's a felony charge that somebody has been convicted of. So it's not opening the door to add another factor, because the court can always consider it. The court can consider it. Almost every state has a catch-all phrase. And under their alimony factors, any other factors the court may consider or the court in its discretion wishes to consider. This is to eliminate the ability of an abuser to continue to abuse somebody using the legal system when they are convicted of an assault, a felony assault, a felony sexual assault, attempt to commit murder, or conspiracy to commit murder against their spouse who is the victim of those acts.
No, I recognize, and I also recognize that with the institution of the judicial branch's track system, that it has dramatically increased the amount of court appearances on many cases, which has increased the fees and all of that stuff. But, you know, that's the system, right? That was created by the system. But, you know, just the last area I wanted to deal with on this is, what about retroactivity? So what about the individuals that have already paid alimony under the auspices of this? The court took into consideration the fact that, let's say, the husband was incarcerated and was convicted of a crime, and perhaps diminished the alimony award based upon that. How do we deal with those individuals that, you know, potentially make a claim against the state or something like that, should this pass?
Well, currently, we don't have any individuals that have been in this specific situation. So I don't know that retroactivity would have a significant impact. And we're talking about, you know, a handful of cases possibly per year. So not a high volume in terms of the convictions that are listed.
Okay, thank you. Thank you for your testimony.
Thank you, Representative Fishbone. Comment or question from other members of the committee? Comment or question? See none. Thank you very much for joining us. Just briefly, you all are signed up at just to check, 'cause you're not testifying later, are you?
I am not.
Right. So you're signed up at number 72 is one, and then
109.
109. Okay.
Correct.
I want to make
Thank
sure I
you.
got you. Let's see. We have Liz Gustafson. Welcome, and you may testify.
Good afternoon, Senator Winfield, Representative Staffstrom, and members of the Judiciary Committee. My name is Liz Gustafson. I'm the State Director of Pro-Choice Connecticut, and I'm here to testify in support of Senate Bill 3. While abortion remains legal in Connecticut, we are not immune to the efforts of the global anti-abortion movement's attempts to restrict or deny access to pregnancy-related care. And now in this post-Roe world, the serious threat and harm caused by data privacy violations are significantly heightened. Privacy is a non-negotiable and is an essential component of exercising bodily autonomy and reproductive freedom. But the reality is data collection, surveillance, and privacy abuses already disproportionately target and harm populations, including undocumented people, Black, Brown, and Indigenous people, and low-income communities. Now in this new landscape where states are rapidly moving to criminalize abortion care and jeopardize access, data shared between companies, private parties, and the government are already being utilized to surveil, penalize, target, and harass individuals seeking healthcare and their support networks. Conversations that are believed to be private via social media, text messaging, and other digital communication platforms are being weaponized to criminalize and harm abortion seekers and their support networks. For example, last year, a Nebraskan woman and her teenage daughter were prosecuted for seeking abortion care when Facebook handed over their direct messages to police. Just earlier this month, a Texas man filed a wrongful death lawsuit against 3 women for allegedly helping his ex-wife obtain medication abortion pills, and included screenshots of the women's private messages in the lawsuit. Globally, the United States has the largest total amount of data breaches. At the same time, technology continues to evolve and influence how we communicate, seek and share information, travel, work, play, and also document and track our own health metrics. Take cycle tracking apps, for example. While 1/3 of people who menstruate utilize these apps, 78% of those very apps have been found to regularly track, store, and sell consumer data to third parties. In the aftermath of Dobbs, we are no longer speaking in hypotheticals. The question isn't whether or not people who have abortions will be targets of criminal or civil vigilante action. The question is, what are we going to do to ensure Connecticut follows through on its promise to be a safe harbor for our residents and those who seek care within our state's boundaries? Ensuring the privacy of sensitive health information and data should not be a luxury. It should be an ensured and recognized right and reality for every single individual seeking comprehensive reproductive health care, and a standard practice for an industry that has been left unregulated for far too long. People should be able to make personal healthcare decisions and access the care they need with privacy, safety, security, and dignity. And we urge the committee to support this bill. Thank you for your time and consideration.
Thank you. Comment or question from members of the committee? Comment or question? If not, thanks for joining us again.
Thank you.
Bernadette Nwokji.
Greetings, Mr. Chairman and members of the committee. My name is Bernadette Okeji. I am a student and I am a resident of the Second Chance State, Connecticut. I am here today to support Senate Bill 1233. Often, justice is not served by incarceration. Rather, justice is often impeded by incarceration. Incarceration greatly affects communities because loved ones are removed from their households, and the carceral-induced separation causes these households lasting trauma. More than 1/2 of Connecticut's prison population are parents, many of which are primary caretakers. Parental incarceration has been recognized as an adverse childhood experience because children of incarcerated parents tend to experience greater disruption and instability in their lives. And then for elderly and disabled individuals, losing the support of their primary caretaker often entails financial hardship and disruption. Senate Bill 1233 alleviates these effects by offering primary caretakers alternatives to carceral sentencing that are community-based, such as substance abuse rehabilitation and family counseling programs. Notably, community-based alternatives to incarceration decrease recidivism rates, which not only aligns with the goal of a second chance state like Connecticut, but also reduces incarceration costs for the state. Thus, not only does Senate Bill 1233 help communities heal from the negative impacts of mass incarceration, but it also produces cost-effective solutions to mass incarceration for the state of Connecticut. In conclusion, I urge you to vote yes on Senate Bill 1233 to strengthen Connecticut families by providing smart alternative sentencing options that limit primary caretakers' separation from their household, allowing dependents their right to grow up in a safer, more stable environment. Thank you for your consideration.
Thank you. Thank you for your great timing too. And sorry about mispronouncing your name. Comment or question from members of the committee? Comment or question from members of the committee? If not, Ms. Nwokji, I think that's closer. Thank you very much for joining us.
Thank you.
Next, we have Anthony Dias.
That's correct. To members of lawmakers of the state of Connecticut and the Judiciary Committee, my name is Anthony Dias. I'd like to speak on behalf of Raise Bill 926, the elimination of the recommitment under the Psychiatric Security Review Board for the state of Connecticut. The current mental health system in this state is not a healthcare provider at all. I mentioned the fact that our system of mental health services cannot be patched up with a bunch of Band-Aids. It just would not work. We need to go all the way back to the drawing board and dictate how we want to help those with mental health and addiction issues. This system is like a drunken gazelle, stumbling into buildings and smashing people along with their hopes and dreams. The families of those in this system suffer without their loved ones for years, even if they don't represent a danger to themselves or to others. This mental health gazelle leaves no light at the end of the tunnel. Like a roach motel, it's almost impossible to break free. To put it simply, they warehouse those that are considered mentally challenged for decades. Those making the mistake of pleading insanity are likely to remain for life. Those that did not cause a loss of life will spend decades under the Psychiatric Security Review Board, decades away from family, decades from gainful employment, decades from following their dreams, decades from intimate adult relations with a partner of their choice. Decades. None of these realities are healthy. I asked about 7 different psychologists to fill out a survey explaining what happens to a person when they are deprived of adult contact and normal social interactions. Not one of them returned this anonymous questionnaire to me. It was anonymous. They didn't even have to put their name on it. And none would explain how this could hurt people that need help. In 2007, the Justice Department said, we have no step-by-step movement toward discharge. And it remains that way 16 years later. So this mental health Godzilla tramples the city for 25 hours, then stops. He falls asleep, then wakes up and tramples people for another 3 hours. That seemed not to be good enough. Again, he stumbles and crashes and tramples.
Mr. Dice.
5 hours.
Mr. Dice.
Then he tramples, sir. I'm almost done. Then he tramples, sir, for another 4 hours. He finally sees the ocean, but they attack him. And he returns and tramples an additional 5 more hours. Now, those hours are actual years, and that is what the Psychiatric Security Review Board has done to me.
Thank you, Mr. Dice.
That's how many times they added years to me. Those hours are years.
Thank you.
Thank you.
Comment or question from members of the committee? Comment or question from members of the committee? Not Mr. Dice. Thank you for joining us. I know it's difficult to join us remotely as you are, but we appreciate your testimony. I'm going to turn over the meeting to Representative Staffstrom, and we will next hear from Phil Kent.
Good morning, Representative Staffstrom, Senator Kissel, Representative Fishbein, Representative Howard. Appreciate the time today in front of the committee. My name is Philip Kent. I'm here on behalf of Congregations Organized for a New Connecticut, or CONNECT, where I serve as a board chair and tri-chair of our criminal legal reform team. And I'm here in support and asking for your support of HB 6918, an act concerning erasure of criminal history records. As you know, Clean Slate became law in 2021 and leads our nation in forging a pathway to automatically expunging criminal records for those eligible to help them break down barriers to more stable housing, better jobs, and better access to education so they can rebuild their lives in a meaningful way. As we know, without Clean Slate, in 1 year after leaving prison, 60% of formerly incarcerated people remain jobless. And so Clean Slate offers redemption and hope that a second chance is truly possible in Connecticut. Clean Slate also works better than job training alone to increase wages and reduce recidivism. And we know that Connecticut loses an estimated $1.2 billion annually in economic activity under the current system without Clean Slate. We also know it addresses racial inequities because people of color are up to 9 times more likely to be incarcerated. And the existing pardon system here is too onerous and expensive and only serves about 3% of those who are eligible for a pardon. So we passed Clean Slate in 2021 with an implementation date of January 1st of 2023, which allowed the state a year and a half to make Clean Slate a reality for some 250,000 people on day one. But to date, several months after that implementation date, that has yet to happen. And that's why we need to pass HB 6918. This bill will clarify eligibility under Clean Slate to ensure the maximum number of formerly incarcerated people who are eligible will qualify for clean slate. And that will help those individuals, their families, their communities, and by extension, our entire state by lowering recidivism and driving economic success. The bill will also ensure that commercial data buyers, such as background check companies, will comply with the law and will modify their paid databases to reflect that records of erased convictions are in fact removed within a reasonable time of someone being cleared under clean slate. The bill also fixes technical issues in the existing law that stand in the way of the intricate behind the scenes data systems work or the information technology work needed to make sure that clean slate is implemented smoothly and in as timely a manner as possible. And so we urge you to vote in support of HB 6918 so that our clean slate law, which you already passed, can become a reality and start improving lives and improving Connecticut. Thank you.
Thank you, Phil. Questions from the committee? Representative Fishman?
Thank you, Mr. Chairman. Good morning, sir. One of the things that you said popped out, you gave a statistic of 3% with regard to the Board of Pardons and Paroles. Can you just unpack that? What is that?
That's, when we did our research in the campaign from 2018 through 2021 to get the law passed, our understanding from the data that's coming out of the Board of Pardons and Paroles is that only 3% of the people in Connecticut who would be eligible to go through that process are actually going through that process and obtaining their pardon.
So that's merely talking about the people that have taken the initiative to actually file.
Yes, I believe that is correct, if I recall correctly. So these are things that we've, of course, already talked about prior to passage of the law.
Okay, so it's 3% of what? Of the population? We're talking about a subset of individuals, I guess anywhere in the world, because you could get a conviction here and move to New York, and then look to get it pardoned that are applying. So I'm just trying to figure out what component ends up with the 3%.
My recollection is that is of the people who actually apply. No, I'm sorry, not the people who apply, the people who are eligible to apply, who then end up obtaining that pardon. So there are, I think in any given year, there are, maybe 1,500 people that might apply, and only a subset of them then go through to a certain level of the process, and then only a subset of them actually get their pardon as well.
So then the component of the calculation is all persons that have been convicted of a crime that is pardonable, which I would think is a very large number. And then it's the portion of those people that actually get a pardon or applying for a pardon. I'm just trying, because if then you're dealing with the end, which is of that subset, the individuals that actually are successful, right? That would be a different standard. Because certainly going before the Board of Pardons, there's different factors. I've been before the Board of Pardons. I see the questions, the applications, the work that they do. So we're just talking about 3% of the individuals that could possibly apply are applying, or 3% of the individuals that are applying get a pardon. But there's a difference.
No, I think it's 3% of those who are eligible who ultimately are able to go through that process and get, I think it's 3% of pardonable offenses is what, to use your language. But if you look at, the data is there, we could look it up and I could send it to you if you want to look at that. I mean, obviously the pardon system is not affected by the clean slate bill that's already passed. So I think that
the pardon system is quite affected by the clean slate that was, now we have self-preservation, it appears, and we don't need to go down that road today. But certainly as a result of clean slate, many applications that could have been submitted to the Board of Pardons are never going to get to the Board of Pardons it doesn't matter the underlying, those convictions are being erased. So there was a dramatic aspect, effect upon the amount of pardonable offenses, right?
Well, I would say that what the purpose of this bill, because that's a very I mean, I know I've seen you down there at the pardons office for hearings. You know how onerous it can be, and for people who haven't the means to go through that process, how expensive and difficult it can be even to transport themselves for a hearing. So when I say, what I'm saying is it doesn't affect the rules of the pardon system. Those systems for those people who would still have to apply for pardon, that's still going to go under the exact same system that was there, prior. So yeah, does it alleviate some of the burden on that system? Yes. Does it alleviate the burden on the individuals who would otherwise have to go through that onerous system? Absolutely.
Oh, I agree. That's the policy shift that we end up with, but thank you for your testimony here today.
Thank you.
Further questions or comments? Mr. Kent, I just real quick for you on section 4 of the bill. I think Representative Fishbein explored this line of questioning earlier with the Commissioner of Public Safety, and I know we've received testimony from the judicial branch, which I tend to agree with, on sort of the unworkability of section 4 as currently drafted. This is the section that allows for the $10 per record fine for records by a credit reporting agency that are not erased, and it allows the judicial branch to impose that fine. And I think I know the branch is correct that there's really nowhere else in our law that we put the onus of imposing a fine on the branch as opposed to the branch being the arbiter. And there is sort of a due process concern, I think, with this section is currently drafted. And so, man, I don't want to put you on the spot right now, but I know from our previous conversations that something like this has been important to your membership. But I think this section's got to get reworked. Otherwise, it's not going to be, we're not going to be able to implement it. And we're going to run into a similar issue. So I'd ask you to take a look at that again. And if you have any additional thoughts on that, happy to hear them now or offline.
Well, I will tell you that does it have to be the judicial branch that enforces that? No, but there does need to be accountability for these private data buyers whose practices could lead to many situations where someone whose record is erased, then suddenly it pops up when they're trying to get an apartment or trying to get a job or trying to go back to school. So somebody has to be able to hold them accountable, and that's the point of that provision, right? Is to create a real incentive for the data buyers to use the information that they're getting from the state once they know that there's an erased record, and then actually adjust their databases to reflect that, so that that's not popping up.
Sometimes the way we address kind of similar issues like this is giving the Attorney General the authority to bring a cutback action. Would that satisfy your needs, do you believe? So in that regard, you maybe put me on the spot, but we do think that it may be something that ought to be enforced with the Attorney General's office. I don't want to put you on the spot, but we got a deadline to vote bills out next week.
I
So
understand.
your deadline's short. I appreciate you highlighting the economic urgency of getting this vote passed, which is why I am kind of putting you on the spot, and I am pushing you on this. Interestingly, I received an email last night from an outfit called the R Street Institute, which from my research is not exactly a left-leaning group by any stretch of the imagination. They seem to be sort of some right-leaning DC think tank, and they had actually published just yesterday a really I think thoughtful study on sort of the economic and public safety benefits of passing clean slate. And so I just want to kind of point that out as we go through our discussion today, because I do think it's something members should take a look at. And keep in mind, particularly as, we heard testimony on a different bill already today from the CBA on the worker shortage in the state.
Right.
And certainly passing clean slate sooner rather than later, I firmly believe or implementing clean slate sooner rather than later is really one of the biggest economic drivers this legislature can pass this year. So.
Yeah, I would agree. I haven't seen that study yet. Obviously, it just came out, but I'd love to see it. That sounds very consistent with what the Michigan law study concluded and with what some of the other data that we've seen in the past as well. So, and if you're talking about pathways to jobs, I think that this is a very important bill because it opens those doors to fill many of the jobs I think that the state of Connecticut is looking to fill.
Thank you.
Thanks
Appreciate
so much.
being with us. Representative Fishman would like to go again.
Yeah, you started it. Thank you. Thank you, Mr. Chair. Just going back to the fine aspect of this. From time to time, internet search engines show somebody got arrested, somebody got convicted. Are we assuming, because it's unclear from this language, that we are going to require Google, YouTube, Yahoo, and all of those entities to scrub their systems also?
I don't think that's what the language says. I think if it's a commercial data buyer who's purchasing that data from the state of Connecticut. So I don't know if those entities do that, but I assume there are a number of others that do. And the fine is directed at those types of agencies, as I understand that language.
Well, I'm reading at line 159. It says, if any person, which has been extended to companies and that kind of stuff, including but not limited to a consumer reporting agency, data, that stuff. So at least I'm reading the language. It is not exclusive. So that's of concern to me. I understand the intent, the policy, but now we're going to, if someone emailed to someone else about something like this, and that email was posted on somebody's Facebook page, let's just say, are we going to require that Facebook go through, which may be a good thing, I don't know, but that clause gives me pause.
Well, what I would say, Representative Fishbein, is that it goes on to say that that person must have received notice from the state. So presumably not everybody is getting that notice, right? The commercial data buyers are getting notice because they're getting a regular feed of information from the state of the erased records and of the people who've been convicted, right? When they get all of this data, it's both people who got convicted of something as well as people who've now have an erased record. So it doesn't literally apply to any person. It applies to people who got notice.
And section A has to do with the notice. And what are the confines of the notice? Because I read that to be, it could just be posted on the state's website. Does it require?
Well, I don't think that's how that notice works. But that's a little beyond, that's a little beyond my knowledge in terms of how that works between the state and the folks who get notice.
Yeah, sure. But to make it clear in the due process issues, you would have actual notice to someone and then have them be held in violation of that notice if it gets to that point. But merely posting someplace that one doesn't have a duty to go to check, which I read this language as having no confines and no restrictions and no hurdles. It gives me pause, but thank you. Thank you for the exchange.
Further questions or comments? Seeing none. Thanks for being with us.
Thank you so much for your time.
Ray Boyd.
Good morning to the Judiciary Committee, Senator Porter, Representative Porter. How you doing this morning? My name is Ray Boyd, and I'm from the city of New Haven. I'm the co-founder of Next Level Empowerment Reentry Program in New Haven. I'm also employed by Yale Law School and the Racial Justice Center as a project manager. I'm here in support of the Senate Bill 952 to broaden eligibility for parole to include the individuals serving long sentences for crimes committed before the individual was 25 years of age under certain circumstances. And my reason for supporting this bill is because I was released 16 months ago by parole under Public Act 1584. And I know the importance of giving individuals a second chance at life. Someone mentioned earlier here today that Connecticut is the second chance state. And however, I believe that most of the individuals haven't had a second chance and haven't had a first chance at all. But I believe that if this bill were to pass, it would give light to some of these individuals having their mitigating circumstances evaluated. And I believe that the Board of Pardons and Parole is fit to deem whether one is ready for society or not. So I'm in support of this bill to go through.
Thank you. Questions or comments? Representative Porter?
Thank you, Mr. Chair, and thank you, Mr. Boyd, for being here today. Can you tell me, do you personally know anyone who this bill, if passed, would impact?
Oh, I've only been home 16 months, so I know plenty of individuals that will benefit from this bill going through.
And if I was to ask you to speak to the character of those people, I mean, because there is a concern about people, right, being
Yes.
released, especially
Mhm.
people for violent crimes.
Yes.
And I would imagine with that kind of time, there would be some violence attached to that.
Yeah.
So I'm just wondering about if you can speak to the rehabilitation piece of it, the punitive piece of it,
Yes.
and why would it benefit not just the individual, but us as communities, as families, and as a state as a whole?
Well, speaking for myself as well as most of the like-minded men that I surrounded myself with throughout my term of incarceration, they contributed a great deal to my maturation while I was in there. When I entered the prison system, I was a 7th grade dropout. I was reading on a 3rd or 4th grade level just prior to my incarceration. So I contribute a great deal of my maturation to the men that I served out my time with. They were several years older than me. Some were a little bit more my senior, but they're great men. They surround themselves with like-minded individuals. They're not a disruption to the Department of Correction. They're of benefit. Most of these men that I've grown with have begun to develop programming within the institution to help individuals that are coming through, such as myself. When I came through, there weren't any mentorship programs in the Department of Correction other than the designated programs that you would have to go through. So I think it's these guys are well fit, from my understanding, to be back in the community. And most of us that are coming home after long terms of incarceration are less likely to reoffend for the crimes that we have committed and more likely to be livable citizens in our community, tax-paying citizens in our community.
Thank you for that response. And just for the edification of the conversation, how old were you when you were convicted and incarcerated?
I was 19 when I was convicted and incarcerated. I was 17 when I committed this crime, and I came home at 49.
Okay. Well, I do appreciate all the efforts that you've made in showing us that there is some realness to having faith in people and having faith in a second chance society. And I thank you for coming home and putting the tools that you've learned to use and for reaching back and lifting people as you climb. So thank you very much for your contribution to society.
Thank you very much.
You're welcome. Thank you, Mr. Chair.
Thank you. Further questions or comments? Further questions or comments? If not, appreciate being with us.
Thank you very much.
Next up will be Christine Foster.
Good afternoon, members of the committee. I am a domestic violence advocate with Safe Futures. Safe Futures provides life-saving services to victims of domestic violence in Southeastern Connecticut. And we are a member organization of the Connecticut Coalition Against Domestic Violence. I'm here today to urge you to support Senate Bill 5, which is a priority for Safe Futures and for the Connecticut Coalition Against Domestic Violence. Section 1 of this bill proposes statewide expansion of the state's domestic violence offender electronic monitoring program, which the Judicial Branch Support Court Services Unit has been already operating at 3 sites in Bridgeport, Danielson, and in Hartford. What I can really speak to are the experiences of the victims that I work with. I have a client whose abuser has a protective order in place, and yet he showed up at her child's daycare and assaulted her in front of her children. And so that is why programs like this are incredibly important for ensuring victim safety. Section 2 of the bill seeks to prohibit abusers convicted of attempted murder, conspiracy to commit murder, or certain other Class A or B felonies designated as sexual or family violence against their spouse from receiving alimony from their spouses. Prohibiting an offender from receiving alimony in these instances will benefit victims of domestic violence by eliminating the fear to leave an abusive relationship for certain victims, allowing funds to remain at the disposal of the victim to support themselves and their children, and eliminating litigation abuse in these situations. And I've been asked to share a story with you of a client whose husband is currently incarcerated. He wrapped his hands around her neck and stopped her ability to breathe, which I think sends a pretty loud message that your life has no value. And so when she's now trying to get a divorce from this individual, and he's requested alimony. And so she has to repeatedly show up to court, which she says is re-victimizing to her, and face the man who tried to end her life. She says it is disgusting and that it's something that no victim should have to go through. And she was really adamant that I share her story with you here today.
Thank you. Questions or comments from the committee? Representative Fishbein?
Thank you, Mr. Chairman. Good afternoon. Thank you for coming here to offer your testimony. The case that you were just referring to, we had heard from other advocates this morning that indicated that there were no cases in Connecticut that this would apply to. Can you tell us what judicial district that particular case is pending in?
The case is out of Norwich Court. The conviction happened several years ago. I don't want to share too much identifying information to respect her privacy, but she has been trying to divorce this person because she wants to relocate before he is released. There is a standing criminal protective order, but she does not believe that he will, honor that, and she would like to get her and her children someplace safe. And these proceedings are really just elongating that process for her. I think she is open to speaking to people individually. The public speaking is a little overwhelming for her, but if anyone would like to speak to her one-on-one, I'd be happy to help arrange that for you.
And do you know how long the divorce has been pending?
I don't, but I can find out and let you know.
Okay, no, I do this stuff and I know cases are taking a while. Do you know how many times she's been to court on this alimony issue?
I don't know exactly how many. The last, she does have another hearing coming up in April. And I know she's been at least 2 other times before that.
Okay, when you say she's got another hearing, are you saying that the court has already heard her on the issue, or you're not sure, or she just had to like meet with family relations, or you're not sure?
Yeah, I'm not sure, but I can get the details and follow up with you if you'd like.
Okay, that would be great. Thank you. Thank you, Mr. Chairman.
No problem.
Further questions or comments from the committee? Further questions or comments? If not, thanks for being with us. Deborah Martinez.
Good morning. My name is Deborah Martinez, and I am here to discuss with you Bill 952. I'm here as a victim of a violent crime in this state. When I was 14 years old, I was raped. I didn't know at the time, but that one moment would forever change the course of my life. Lots of things went wrong in my case, including the police department giving out my home phone number to my offenders' families. The next 4 years of my life were a living hell. Everything about my life changed. How I saw myself, the way I interacted with my family, my friends, my pursuit of education. I experienced a level of self-loathing that no one can ever truly describe in words. I would go on to be repeatedly bullied and raped in the hallways of my high school throughout my high school years, until one day I decided a suicide attempt was my only option. The only long-term relationships I had before the age of 22 were abusive and resulted in extreme domestic violence. In the cases of my offenders, they were either arrested or given a jail diversion program or incarcerated. I am 46 years old today, and although I have spent most of my life in therapy and working through the horrific trauma I experienced at the hands of someone else's choices, it still affects me. It affects the decisions I make as a mom with my 3 boys. It affects the way I interact with people. It affects my sleep. And some days I can still feel it like a tidal wave of emotion and flashbacks that take my breath away and bring me to my knees in tears. My journey to healing, a survivor's journey to healing, is long and difficult and filled with pain. It is also very difficult for every survivor of any violent crime and very different. The common theme, however, is that nothing will ever make you whole. My offenders can never give me back what they took, what they stole. If they were incarcerated, that might have made me feel safer for a period of time, and I might have even thought for a second, now they've lost something. That last statement, however, that's revenge, not justice. But feeling whole again, that was up to me, because nothing was going to change what happened, not even someone's incarceration. As I got older in life, I grew up and I had my own life experiences and came to realize that people are not born with the intent to cause harm. That's learned and that's taught. It is with time and life experiences and growth that we become the adults who we choose to be. It has also become clear that my offenders were not born with the intent to cause harm to me. They were teenagers and early adults who made poor decisions that happened to cause harm. Those choices are a part of their journey in life and their growth. Those choices and consequences have made them who they are today. 2 things in life can be true at the same time. My offenders caused me great harm, and they have grown up. They have made better choices, and they deserve to be seen based on who they are today, not what they did 20 years ago. Nothing is going to change the choices that may have been made, but people can choose who they grow up to be. Many of the people that Bill 952 will affect have done just that. Many of them have lived longer in prison than out here in the real world. Despite their prison sentence, despite being defined by an inmate number, they have worked to better themselves and give back, many working on healing their own trauma as young kids. Further incarceration of people who are not a danger to society is fiscally irresponsible. Allow Bill 952 to do what it's intended to do and see the whole person.
Thank you. Further questions or comments from the committee? Seeing none, appreciate you being with us today, and appreciate you sharing your story with us. Prince Asiji.
Hear me?
Prince
Hear me?
Asiji. Yeah. Go ahead, sir.
Dear Chairs Winfield and Stratstrom, Vice Chairs Flexer and Quinn, Ranking Members Kissel and Fishbein, and members of the Judiciary Committee. My name is Prince Osaji. I'm a resident of New Haven, and I'm here to express my strong support for Senate Bill 1233, which would ensure that families of convicted individuals are not devastated by that individual's conviction. This bill would allow for a community-based sentencing alternative as opposed to jail time if the convicted individual is a primary guardian of one or more children. This would help prevent the vulnerable position spouses, and especially children of incarcerated individuals, are forced into. Studies have shown that children of incarcerated individuals who are under 18 when separated from their convicted parents are more likely to do worse in school than their peers, engage in drug abuse, engage in criminal activity, and eventually be imprisoned themselves. The relationship is most commonly attributed to the absence of the incarcerated parent, which can be emotionally damaging towards the child and can drive them down the wrong path. It can also be emotionally damaging to the other spouse, making them more stressed, more distant, and in some cases, even abusive towards the child. Incarceration has created a vicious cycle where families are trapped within the same pattern of imprisonment. This bill would help break that cycle and allow children of incarcerated parents the same opportunities as their peers to thrive. Furthermore, similar bills have been successfully passed in other states as well. For example, Oregon passed the Family Sentencing Alternative Pilot Program in 2015, which allows parents of under 18 children to serve their sentence at home while continuing to be a parent. This program prioritized rehabilitation and treatment, and as a result has already successfully kept 212 families together, keeping 391 children from entering the foster system, which is awesome. In conclusion, I urge you to protect our families from this vicious cycle of incarceration and pass this bill. Help ensure that children can stay with their parents and not suffer the academic, emotional, and physical consequences of having a parent in jail. Every child deserves an equal chance to thrive outside the system. And with this bill, we would be taking a strong step to making that happen. Thank you.
Thank you, sir. Questions from the committee? Seeing none, appreciate being with us. Sheila Hennessy. Sheila Hennessy with us?
Hello?
Yep, go ahead, ma'am.
I beg your pardon.
Ma'am, we've got
Good afternoon, Representative Staffstrom, and distinguished members of the Judiciary Committee. I am Sheila Hennessy, the chairperson of the Psychiatric Security Review Board. Prior to my service on this board, I was the probate judge for the District of Newington for 16 years and presided over commitment and probable cause hearings at Cedar Crest Hospital. I am here today to address Senate Bill 926. This bill would eliminate the present right of the state's attorney to request that the Superior Court continue the commitment of an individual acquittee who has been found not guilty of an offense by reason of mental disease or defect and committed to the oversight of the board for a certain term of years. The probate courts are not involved in this process. All of the patient acquittees under the board oversight have committed serious and sometimes violent offenses. While under the board's oversight, the acquittees have a series of hearings, including an initial commitment hearing, at least a mandatory review hearing at least every 2 years, as well as additional hearings concerning temporary leaves and conditional release. The state's attorney is present for all hearings concerning the acquittee and reviews all periodic reports concerning the course of the patient's treatment and progress, and has the opportunity to question the clinicians concerning these matters. And as a result, the state's attorney is well informed concerning an acquittee's response to treatment. When the board considers a petition for continued commitment, all of the acquittee's due process rights, such as notice and right to counsel, are protected, just as they are in all hearings. If the board determines that the petition should be granted based upon the patient's condition and history, as evidenced by reports and by testimony, it will make a recommendation to the Superior Court, which will determine whether continued commitment is appropriate. If the court does make that determination, it is granted for a certain amount of time, and all services provided to the acquittees concerning housing, treatment, and support groups will continue. The process in place allows the board to properly honor its mandate to protect the public interest, and also to provide for the well-being of the patient who continues to need the support that the system, only this system can provide. I don't wish to be duplicative, and you are going to hear from the executive director of the board, Ms. Cardella.
Ma'am, we're
I
at
think,
the 3-minute mark.
I'm sorry. I'll thank you for the opportunity, and if you have any questions, I would be happy to respond.
Questions from the committee? Representative Fishbein?
Thank you, Mr. Chairman. Good afternoon, ma'am. I just, in your introductory remarks, you indicated that this law, if it was to pass, or this revision, would remove the ability of a state's attorney to make an application. Did I hear you correctly?
Yes, that is my understanding, yes.
Okay, what is that understanding based upon?
The initial copy of the bill is proposed. I'm just
Okay.
looking for my copy here. Don't know that I have it.
That would be helpful if we could work on this together.
All right.
You have it?
No, I don't have the actual copy.
Okay, so
I just have notes from the discussion among the board.
okay, so I'm looking at lines 23 through 28. And I'm just gonna read it to you, since you don't have the language in front of you.
Thank you.
No problem. It says, if reasonable cause exists to believe that the acquittee remains a person with psychiatric disabilities or a person with intellectual disability to the extent that the acquittee's discharge at the expiration of the acquittee's maximum term of commitment would constitute a danger to himself or others, or is gravely disabled, the state's attorney may make application for commitment of the acquittee to a hospital for psychiatric disabilities, so on and so forth. So that language would appear to say that the state's attorney can make the application. Why are you claiming that it says something different?
The application to the hospital?
Well, it says they may make application for commitment of the acquittee to a hospital for psychiatric disabilities. So that would mean, like, in my review of the language, it would permit a state's attorney, if they believe that the person constitutes a danger to themselves or to others or is gravely disabled, to seek through a procedure affording due process, the ability to hold that person, although not in a before the purview of the PSRB, but at a hospital for individuals that have such infirmities.
Well, it was my understanding that the oversight of the board may not continue.
Okay, yeah, I believe that the oversight of the board may go away, but the person wouldn't automatically be let out if the state's attorney filed the application, pursued the application, and was successful in proving that the person was of danger to themselves or to others or were gravely disabled. So I'm trying to figure out your objection as the chair of the PSRB to what's before us.
Again, my understanding of the original bill was that the oversight of the board would be lost, the services would be lost, and the application as described would be made through the probate court system.
Okay, I thank you for coming here and your testimony.
Thank you, ma'am.
Thank you.
Next would be Joseph Thompson. Joseph Thompson with us. Daniel Tanner.
Good afternoon, distinguished members of the Judiciary Committee. My name is Daniel Toner, and I'm a local business owner and immediate past vice president of the Bail Association of Connecticut. I'm asking you at this time to take no action on House Joint Resolution 261. I am deeply involved in two national organizations that oversee the bail bond industry. I appreciate the opportunity to provide testimony to you today. It is with a heavy heart, though, that I appear before you. We have attempted to work diligently with this legislature, with the Sentencing Commission, and thought there was a much better understanding of the hard work and benefit that bail agents provide to the citizens of Connecticut. The proposal to amend the state's constitution, in my opinion, is premature and truly does not reflect the findings of our collective studies of the state's pretrial justice system. We have consistently demonstrated that reasonable bail does not fail. I have studied the Sentencing Commission 2022 report on pretrial justice, which articulates data from several states that have already or are attempting to revamp the pretrial process by eliminating cash bail. There's very little long-term data to review. They investigated Illinois. I beg you to study Chicago's murder rate prior to making changes on behalf of Connecticut citizens. DC, it's only a 68 square mile area. They had 10,000 arrests last year. I'm sorry. Yes, they had 10,000 arrests last year, and Connecticut had 111,000 and covers 5,500 square miles. The comparison is too different to really analyze with Connecticut citizens. New Jersey eliminated bail 6 years ago, which is cost excess of $550 million. And I beg your pardon. The report clearly indicates that New Mexico lacks data to improve their bail reform. New York, quite frankly, speaks for itself. We've all heard about the increase in crime since the reform, and the taxpayers are footing the bill for increased supervision. The report indicates that Alaska has already repealed many of their reforms, fueled by rising crime rates.
So do nothing, sir. That's.
I am asking you at this point.
So it's your testimony, the bail system in Connecticut is just absolutely perfect. No changes are needed to the bail system in Connecticut.
I think that there are certainly, we've always had the ability to work with people and have tried to work with people. It's an imperfect system, and we certainly have the ability,
Okay,
but
so
to make
when,
it to.
so when are we going to make changes to it then? If it's an imperfect system?
I think we've been trying to make changes for the last 17 years. I've been coming up here and trying to work with people. And I just don't, I think that there's certainly an imperfect system, but I truly believe that we could.
But part of the reason we have an imperfect system is because we have an imperfect constitution. Right?
But it's important not to throw the baby out with the bathwater.
No, the constitutional provision is very clear. The constitutional provision basically says unless you're charged with capital murder, which we don't have in Connecticut anymore.
Correct.
You're eligible for bail.
Correct.
Right? So I asked somebody before, if you brutally rape someone or out on bail, you brutally rape someone else again, you get out on bail, you brutally rape someone again, that person is allowed bail a third time, right?
Correct.
Okay. If Adam Lanza had walked out of that school in Newtown, he would have been entitled to bail, right?
He would have been entitled to bail. However, that we have a judicial process in place a judge could have put a bond on him so large that he could not have been released.
Not according to our Supreme Court. Did you read the most recent decision about a year ago?
Not sure if I have or not.
Okay. You can't. You can't set excessive bail in order to get around the constitutional provision. Supreme Court's been pretty clear on that too. So we have this. I think what you were essentially testifying against is allowing this legislature to have the authority to fix what you admit is an imperfect system.
I empathize with your thoughts, and I certainly think that we have the ability to truly work on it. And would be happy to provide additional.
Look, I hear it all the time from folks, right? There are too many folks in our state who are being held for low-level charges on low-level bail that they can't afford to post. And there are not enough folks being held without bail because they've committed egregious crimes. So maybe the system is working somewhere in the middle there, but it's not working at the top and it's not working at the bottom. And part of the reason it's not is because our Constitution prohibits this Judiciary Committee from having an honest conversation about what a realistic bail system that would work for Connecticut would be.
Well, we certainly would want to be a part of that conversation as the industry. I think it's important that as a stakeholder in the industry who really matters,
and
I
no
think
one
we
said,
can
and no one
provide
said you
some
wouldn't.
answer.
But do you know how long it takes to change the Constitution in the state of Connecticut?
I am aware it is a heavy lift, yes.
Right. So it's between 2 and 4 years before this Judiciary Committee could even have a conversation about what it would look like. You know, we started talking about a constitutional amendment to allow early voting in this state 10 years ago. This legislature still has not adopted what that is going to look like. We're debating it now after the voters finally approved it last year.
Right.
So you're talking 3 years down the road, 5 years down the road, we can begin to have a conversation about what a new bail system that gets out from the constitutional restrictions are going to look like.
Well, I think it's important that before we do that, we get it right. And I think that having it.
You can't, because I might not be here 2 years from now. Representative Fishbein might not be here 4 years from now. You might not be here 3 years from now. And in fact, the Constitution also prohibits one legislature from tying the hands of the next. So we can't put in place a statute now for what happens if the Constitution is changed. You have to do the Constitution first, then we can have the discussion you want to have.
Well, like I say, I certainly want to be a part of any conversation. I think it's important. I think the citizens of Connecticut deserve it. All of your constituents deserve it. And, you know,
Well, if you want to have that conversation, I look forward to your support in this constitutional amendment. And we can have it as soon as we get a new constitution in place. It allows us to have that conversation.
Thank you, Kevin.
Thanks for being with us today.
Thank you very much. Any other questions or concerns?
I think we're good.
Thank you
Monty
very much.
Radler.
Representative Sastrom, Representative Fishbein, and other honorable members of and Representative Doucette and other honorable members of this committee. I'm here to testify in favor of Senate Bill 926, an act concerning persons committed to the jurisdiction of the Psychiatric Security Review Board. My name is Monty Radler, and I recently retired from the Division of Public Defender Services after 37 years, which started in 1985. From 1998 until approximately October of 2022, I had the privilege of serving as chief of the Psychiatric Defense Unit located on the grounds of Whiting Forensic Hospital in Middletown, Connecticut. Our primary function was to represent insanity acquittees under the jurisdiction of the board within the legal structure of Connecticut's criminal commitment statutory scheme. This involved advocating for acquittees' custodial movement from maximum security confinement to medium security confinement from medium security confinement to community transition involving day treatment, overnight residential treatment, and conditional release, and ultimately to unconditional release. I worked closely on a day-to-day basis with the very individuals this bill would affect, and also interacted on a daily basis with the wide range of professionals tasked with treating equities in both the hospital and community-based settings, as well as with the administrators of the PSRB and the state's attorneys tasked with handling criminal commitment proceedings for the state. I know all of these as human beings and not statistics and numbers. Since December of 2022, I've volunteered as a pro bono attorney on a part-time basis with the Connecticut Legal Rights Project, basically to continue my advocacy on behalf of my former public defender clients in dealing with these specific issues. Given my unmatched years of legal and institutional knowledge with this unique group of people and systems, I felt it would have been morally responsible to simply walk away when I retired from my public defender position. In the interest of full disclosure, I'm currently an appointed member of the working group established by Public Act 22-45 to examine the PSRB and determine whether it should be abolished and/or modified in its function. The interrelated but critical issue also is the dysfunctional culture of Whiting Forensic Hospital, the nature and duration of which is fully documented by the Whiting Task Force report. Sorting all this out is a complicated question of whether the PSRB in its current iteration, the hospital, or a combination of the two is responsible from where we are today. You will be hearing from a state's attorney later.
Thank you, sir. Questions from the committee? If not, appreciate being with us. Vincent Artizone.
Yeah.
Sit there.
Hi, my name is Vinny Artizone at Dutcher North 3. I feel that this is a life sentence here, and they just justify it with their notes. I have 5 doctors that know me very well, and they say I'm not a danger or a threat to society, that I should be discharged from the board, and that falls on deaf ears. I've been here 31 years, and I've known people under the board that had a sentence of 5 years, and they did 30 years to life here. I'm just worried that my time is up 4 years from now, and they're going to try to recommit me for no violence, just rule violations, and that's how they justify my stay here. But I really feel that something needs to be done, and that it's a very corrupt system all the way through Connecticut. So I'm hoping that this bill is passed for people who deserve to relive, to have a chance and get their life back. Thank you.
Thank you, sir. Questions from the committee? If not, appreciate you being with us. Leslie Roy. Leslie Roy. Julio Martinez. There you go, Ms. Roy. Okay.
Sorry about that. Good afternoon. I am Leslie Roy. My claim has been pending since April of 2019. I'm a 33-year employee with DCF, having risen through the ranks in child protection and never experienced any discipline or received any form of performance-based counseling throughout my career. I've recently retired from DCF at the level of Director of Contract Management and have been asked to continue to support the department for 2 consecutive TWR contracts as the state continues to address the staffing crisis. On April 4th, 2016, I was terminated from state service based on a difference of opinion regarding a case I managed in my role as an investigation manager. The parents placed their newborn with a relative weeks before the department's involvement, and that placement was in question. I was involved with the case for 10 days, at which time I was reassigned to another office due to organizational needs. Because that transfer was midway through the investigation, I was not aware of how this case or any of the 350 cases under me were concluded. 3 months following my reassignment, I was notified that an investigation had taken place through HR. A total of 6 DCF staff were placed on administrative leave, including myself. 4 of the 6 were union members, and they successfully prevailed at their Laudermill hearing, having proven the final investigation report was inaccurate, detailing false, misrepresented, and fabricated facts. They were returned to their full status that same day with no record of the investigation in their file. One of the non-union managers prevailed at step 2, and she returned to work. The manager who replaced me reviewed, approved, and signed off on the final investigation, received absolutely no discipline. I was the only manager fired. My termination was reversed just prior to the start of testimony before the Employee Review Board. Rather than testify on record, the former administration at DCF offered me a settlement to return to work at my former level and to agree that I would accept no assignment I would accept a reassignment outside of child protection. I had no option but to accept the offer as I exhausted all of my financial resources and couldn't continue to risk fighting a termination that was unjust and a basis that was never made known to me to this day. It was clearly an example of people in power abusing their own power. My effort here today is to simply recover the portion of the financial burden the department's actions against me and its impact to my family. I was forced to sell my home and use a large portion of my daughter's college savings to cover the exorbitant legal fees and basic living expenses needed to survive and provide for my children. I'm not asking for compensation for the public humiliation and damaged reputation this ordeal caused, because there's no dollar amount that will ever repair that damage. Just Google my name. I dedicated my career to following procedures, protocols, and best case practice while ensuring the safety of children. I was placed on administrative leave, terminated, and offered my job back with no explanation of wrongdoing, and it cost me thousands and thousands of dollars. My summary today doesn't fully reflect the details of the egregious misuse of power by the former administration, but I have submitted my written testimony that fully explains my statement.
Thank you. So, Ms. Roy, let me, that was the bell. Let me just ask.
I'm done.
Okay. So the matter before us, I believe this is item 54 on our agenda. It's House Joint Resolution number 233, correct?
Yeah. Yes.
And the matter before us is not the underlying merits of your claim, but whether to allow the claims commissioner additional time to decide it.
Yes.
Is that correct?
Well, I'm glad that you asked me this because the letter that I received from the Claim Commission was that my case was referred to the Judiciary Committee. That was it. So I did, I guess I figured that out over time, but I had already submitted my name for testimony and I just thought I'm going to put it out here.
Okay. Okay. All right. Yeah, because we can't, again, that crazy thing called the Constitution I keep coming back to today. Won't allow us at this point to sort of just grant a right to sue. That would be a public emolument. So essentially the question before this committee is whether to give the claims commissioner additional time to decide your case. And I will represent to you that you were one of a number of folks who are in a similar situation, and we're transitioning claims commissioners, and certainly very hopeful that with a new claims commissioner on board, they'll get to your claim sooner rather than later. So thank you for questions from the committee. If not, appreciate being with us today.
Sure. Thank you.
Julio Martinez. Tenevia Carter.
Hi,
Go ahead, ma'am.
good afternoon, distinguished members of the Judicial Committee. My name is Snivet Carter, and I am giving testimony in favor of Bill 952, raising the parole eligibility for incarcerated under the age of 25. Just a combination of my life experience with my loved ones, as well as people that I've grown up in the inner city who were prematurely incarcerated simply because they were in survival mode for most of their lives. Unfortunately, it ended for them to be behind bars before they were even fully developed mentally, as well as emotionally, and unaware of their actions. I feel as though to put them in a position now where they can be eligible for parole at a sooner time, a lot of them have gone through processes, including like programs and educational systems where they have not only learned, but they've also developed and become different versions of themselves. I believe a lot of people who were incarcerated before don't come out the same people that they are today.
Thank you. Questions or comments from the committee? Questions or comments? If not, appreciate you being with us.
Thank you.
Donald Freitag. Donald Freitag.
Can you hear me?
Yep. Go ahead, sir.
Hi, good afternoon, members of the committee, officials. It's my first time doing this, so my respect to each one of you. My name is Donald Freitag. I'm in favor of Bill 952, which is focused on expanding the parole options for young adults under the age of 25 who have been sentenced to lengthy sentences. My son is one of those who have been sentenced to a lengthy sentence. He's serving 30 years, which he's completed 10 years of it. The incident happened when he was at the age of 21. He had testified at a murder trial, which ended up in a acquittal, and he ended up on a gang hit list with 7 people, 3 of who have been killed. So my son had feared for his life every day after several years of being pursued by a gang. And after many years of being pursued and fear for his life, he made a mistake at 21 years of age. The point today that I'm bringing up and want to emphasize, not because of him being my son, but because this is a truth that has been established nationally, internationally, in regards to the prefrontal cortex, which has been determined to not be developed in males to the age of 26. That's now has been proven. The Connecticut court's decision is that the age of 18 is the age of demarcation between juvenile and adult. The national and international experts and policy groups acknowledge that continued maturity is gained well after the age of 18. And I want to bring to each official's attention that the World Health Organization defines adolescence as the age of 15 to 24 years old currently. The United Nations also defines youth as a person between the ages of 15 and 24 years old. These organizations and agencies extend the end of adolescence and onset of adulthood to be between 20 and 25 years of age. My son is remorseful and accountable for the mistake he has made. I don't say this just as a father, but saying this truthfully. He has presently served 10 years incarcerated. He has completed most of the certification programs that have been available: Prison of Peace, Kairos Ministry, He's currently was one of 15 selected to participate in the Quinnipiac College course, of which he has completed and is continuing.
Mr. Freetag,
Yes.
your time has elapsed.
Oh, okay.
Oh, it's okay. It happens. I
Okay.
just want to make sure that you know, and we will check the committee to see if there are questions or comments in response to you. Are there
Okay.
questions, comments from members of the committee? Questions or comment? I don't see any. Thank you very much for joining us today and telling us your story and your son's story.
Can I just say one closing thing, sir? I guess not.
If it's a sentence or less.
Okay, but the passing of this bill provides young offenders serving long sentences a reason for hope and to continue to develop, grow, and work to the future.
Thank you.
Thank you.
Next, we'll hear from Michael Brown.
Good morning, members of the Judiciary Committee. Or good afternoon. It's afternoon now. Obviously, I'm nervous. My name is Michael Brown. I'm one of the formerly incarcerated citizens who has served a lengthy sentence and has re-entered society. As a different and better person than when I went into prison. Currently, I'm a paralegal for attorney Alexander Talbus in New Haven. I'm also a fellow in the second cohort of Yale's Access to Law School program. Before that, I was Connecticut prison inmate 231-451. In 1996, I made a big mistake. I took someone's life. It wasn't intentional, but it happened. And, I got a long sentence for it. And so, I'm here today. Everybody talked about the science. I heard it talk about the science. And, I'm just here to tell the committee that I'm evidence that, what you guys have learned from Milligram or, the science behind Milligram, I'm evidence of that, right? I fired a gun at somebody, right? With the intention of harming that person without giving a 1 second thought to the possibility that I might kill that person. This is what happened. And this is the definition, or this is one of the hallmarks of impulsivity, right? This is one of the hallmarks of immaturity, which is impulsivity, right? I was impulsive. I did something impulsive, irreparable harm. But just like the last gentleman that just spoke, I'm here to testify or support Senate Bill 952 because it will give gentlemen hope. Men and women that serve sentences, it will give them hope, right? And that's one thing that is desperately needed in prison. If I didn't have hope, I wouldn't have done the things that I did while I was in prison. I earned 3 degrees while I was in prison. I got a degree from Wesleyan, I got a degree from Charter Oak, and I got a degree from Middlesex, right? I motivated myself to, strive and try to achieve those goals because I always thought, right? I was sentenced to 32 years. Recently, I got a sentence modification. I got out after doing 25 years. But I always believed, right? I went in, I was 21 years old. So I could outlive that sentence, 32 years going in at 21, I would be 53, right? So I rationalized it and I said, okay, I can make it. And I need to be better when I get out. I need to be able to earn a living. I need to do these things. So I made sure I took every advantage that was given to me and I took advantage of it. And I'm here now. And so it's many guys in prison that are, I think I'm smart. And it's guys in prison that amaze me with their intelligence, right?
Thank you. Thank you, Mr. Brown. Representative, don't go yet.
You got questions for me?
You've seen this process. You know how it works.
Okay.
Representative Fishbone.
Thank you, Mr. Chairman. Thank you for coming here today, and I thank you for sharing your story. It must be difficult. You're on camera here and all that stuff. I want to address hope also. I have hope that my family members can go to the store. My family members can walk down the streets of our cities and come home alive. You obviously made a choice at one point, and public policy shifting to say that taking of a life should be treated in a minimal manner or a reduced manner is not something that I take lightly. The message should be do unto others as you would have others do unto you at its core. I don't want our kids to be out there saying, well, it doesn't matter if I, shoot somebody because I'm going to get a lighter sentence because judge has got to let me out on bail because the Constitution says if I'm under the age of 18, I'm getting out. You can't hold me. And once I'm sentenced, which is of solace to the victims' families, to say that that is going to be set aside. And I totally understand the rehabilitative nature of our penal system. But there's another side to all these cases. So I do have hope. I have hope for your future. I have hope for the safety of everyone in the state of Connecticut. I'm listening. I'm weighing. And I thank you for coming here today.
Comment or question from other members of the committee. Comment or question, Senator Kissel.
Hi, thank you, Chairman Winfield. You're clearly an intelligent individual, and you said that you made a tragic mistake or an act of impulsivity when you were young. I'm just wondering, and I don't expect that you're doing anything regarding this in your new life, but what can we as a legislature do better about stopping this from happening in the first place? I mean, I know there's lack of opportunities, there's lack of father figures, there's all this sociological data we have, economic data, but given your life experiences, what could you tell us about stopping people from even pulling out a gun and when they're feeling threatened or it's gang violence or whatever? Just, while we have you here and you have turned your life around, is there anything that we should be doing better with our young people to stop them from following into this life course in the first place?
The easiest answer I can give you is to change the culture, right? You got to make things even. So if you got kids in the suburbs, right, who have a certain way of living.
Sit closer to the microphone so we can hear you.
Yes. So, I mean, you have to have a level playing field, I guess, right? And I see things all the time, and like throughout my undergraduate academic career, whatever, I read the information always with an eye towards like my personal life or things that I could see, tangible things, right? And so I can take you back to 1990 or whatever, right? I grew up in Hartford. I was born and raised in Hartford. I grew up in Hartford. I was in Weaver High School. And, so I started selling cocaine when I was 89, 88 is my first experience with having cocaine. Because, they had open air drug markets in North Ann Arbor. So this is what I saw growing up. Hardworking parents couldn't afford to buy me designer sneakers and, all the other things that people had. So I went and I sold drugs to get it, right? That, creates this, vicious cycle, because now what's involved with drugs? guns come with drugs, you know, different things come with drugs. You guys say this all the time. And so my mom saw the writing on the wall, and what she did was she moved. She moved to West Hartford, right? We went to 147 Dover Road, right off of Farmington Avenue and Burn Street. Some of you probably know it. And so she, you know, she did that to help me. She took me out of Hartford, moved us to West Hartford. But by that time, I was already into the culture of Hartford. So meanwhile, I had a dress there and I went to school there, I still went back to Hartford. I was in Hartford. And so the point I wanted to make to you is I went to Hall High School with the culturization that occurred in the inner city or in that particular environment. And so one of those things was cutting class and smoking weed, right? I tried to get some of my, fellow students or my classmates at Hall to skip with me and smoke weed. They didn't want to smoke weed. That wasn't the cool thing to do. It's the cool thing to do over there, but not there. So the point is, there has to be a changing of the culture. And, that's how we do that. I don't know, right? Because the media pushes a lot of crap out there that people latch onto and, just becomes, a way of life for people or a perceived way of life for people. So I don't know. I don't know if I answered your question or not, but culture has to change. People have to have opportunities. And, in prison, that is, giving people hope. So, providing programs in prison. Rep. Fishbine's talked about how rehabilitative prison is. Prison is not really that rehabilitative unless you want to rehabilitate yourself. So, if this legislature passes 952, right, you have the opportunity, you give the pardon board or the parole board the opportunity to look at individuals who serve lengthy sentences. I was in there for 25 years and it was like everything in me every day at a certain point, it was like I had to fight to be like, I had reached like my apex of transformation. It was like I was gonna start going backwards now, right? I made it out just in time. And so yeah, those opportunities need to be put into the prison. And because you said, how do we stop these things from happening again?
Yeah.
You stop it from the people who have influence. Some people in prison have influence. And so if they're there without hope,
I got you.
then yeah.
I appreciate it. And even within West Hartford, Hall High School versus the other high school, they compete with one another. I get it. But until we actually stop this at its inception, we haven't accomplished all of our goals. So I appreciate your testimony. Thank you, Mr. Chair.
Thank you, Senator. Comment or question from other members of the committee? Comment or question? Seeing none, Michael, thank you for joining us. I know that I know you personally, so I know that you're doing work in and for the community at this point, and I think that's a good thing. Thank you.
Thank you.
I inadvertently missed the first person on the second page. So Tamira Serdaika. I hope I did not butcher your name.
Good afternoon.
Good afternoon. You may testify.
Thank you. My name is Tammy Serdaika. I'm here to support Bill SB 952. I have personal reasons for also doing that. My son is incarcerated. He has been there 15 years, 4 months, and 28 days as of today. He went in just after his 19th birthday, and listening to everyone before me, I don't want to muddle things up. There's certainly been a horrific thing that has to take place for this to happen. And here we are, 15 plus years later. I've watched him go from an immature child to a grown, responsible, accountable man. And that's not just from a mother's viewpoint. Every inmate I've ever encountered in this 15 and a half years, guards, teachers, counselors, all have high regard and respect for what he's become at this point. He's looking at another 20 years. He was, like I said, a child when this happened. I am taking nothing away from the victim, but all families are destroyed in this situation. I mean, he's had to be in there. I am a single mother. I worked, and he's been away through death, sickness, my own sickness. I've had cancer 3 times. He's been a support system for me from in there, and still managed, bucking the odds, to bloom and grow, treat other people with the respect that he feels they should be treated with. And I'm seeing the responses to that. He's had charities from prison that he's taken over. He's started a food bank, Soaps for Hope, where when I was homeless, he's taking that information. The inmates are gathering things from commissary, soaps and whatnot, and I distribute them to homeless shelters, women's shelters, because that's part of his life experience as well. The part that brought him to this point, he's grown past that. He's owned it. He's remorseful about it. He's gone beyond what my expectations or hopes could have been under the circumstances of being incarcerated. And it would be so beneficial to the community for him at this point. He's got so many things going that already help people on the outside as well as his brothers in the system. He's mentoring, he's doing so many other things that are good for himself and the community, but he's honestly, like I said, building character. He would be an asset to any community that he ends up in. And like, you know, losing family members, he's had people born and died and buried, and the whole COVID thing going through it. It's been very hard. And I just believe that it's a great opportunity to look at people for a second time and to see where they're at, if they've grown, and the progress they've made.
Thank you.
Okay, thank you.
Comment or question from members of the committee? Comment or question? If not, Ms. Sadika, thank you very much for joining us this afternoon. Aaron Ramsey.
Hi, how are you? So I'm here my name is Aaron Ramsey. I'm here to testify about Bill 926 that would prevent the courts from extending people's commitment times to the PSRB, and instead would allow them to civilly commit somebody at the end of their sentence. The main point that I want to stress here, and this kind of answers the other person's question of preventative measures, is the whole point of giving people a not guilty by reason of insanity plea was, 1, to protect society, and 2, for the person to receive treatment. Now, there's about 200 beds in this hospital, and they've basically been clogged up. I've been here over 10 years getting treatment. Some others have done 2, 3, 4 decades of treatment. The vast majority of people are not the ones who are dangerous or even mentally ill anymore. The people who are at much more serious risk of committing another tragedy are the people who have not received the treatment out in the community. So the best way to protect society is to free up some of these beds, move people out, and take up less resources of people being overseen in the community as well that are under the PSRB, and to free up those beds and allow people that have not had the chance to receive treatment to come here. People can recover fairly quickly, their delusions, and come back to reality within a few weeks or even months. It does take some more time, maybe a couple years, to really establish a base of reality. But as far as 5, 10, 15, 20 years, it is counterproductive, and it's preventing people that could actually need the treatment from coming in these beds and getting the treatment. I put some statistics on the website from my written testimony. You're welcome to go look at it. But the basic point is, a study was done by multiple doctors assessing the insanity equity recidivism rate in Connecticut. And basically, it states that it's less than 5% for somebody to have committed a crime after they were discharged. So they were completely free, and the most violent one was a 3rd-degree assault. And as far as people who get committed civilly to the hospital, there's still numerous layers of supervision. We have mental health associates associating with us on the daily, doctors, social workers, different review committees. They have independent consulting psychiatrists who interview us. So it wouldn't solely be just group. Yep, I'll end. So move people out of the hospital, lessen the resources out in the community, and let people come into the hospital and get the treatment they could use more than us.
Thank you. Comment, question from members of the committee, comment or question? If not, Mr. Ramsey, thank you very much for joining us. I recognize the difficulty with joining us from where you are. Tahiba Bain. Good afternoon. You may testify.
Good afternoon. How are you guys doing? Greetings, Chairman and members of the committee. My name is Tahiba Bain. I'm the founder and executive director of Women Against Mass Incarceration, WAMI. I come here today as a constituent of the 130th District of Bridgeport, Connecticut, the second chance state, in support of Bill 1233. Many of Connecticut children have parents in prison. Incarceration breaks apart homes, communities, and the social construct of humanity. The collateral damage of removing primary caretakers from their households by carceral-induced separation causes families immeasurable pain and lasting trauma. Family displacement weighs heavily on the economic security of all families. If we were to reimagine life with alternatives, all the inner city communities could have a chance of living life outside of cages, which negatively impacts the well-being of the children. Many of our children sit in DCF custody due to a war on poverty, for many who are on constant survival mode. And if a person gets arrested in this way and is away from their child 15 out of 22 months because they cannot afford bail, their parental rights could be terminated, regardless of the outcome of their case. This is called neglect. We, as a second chance state, have to be better equipped with alternative to incarcerations for primary caretakers. Senate Bill 1233 mitigates these effects by offering primary caretakers alternative to incarcerations, including substance abuse rehabilitation and family counseling programs that address the immediate trauma. In conclusion, I urge you to support and vote yes for Senate Bill 1233 to strengthen Connecticut families by providing smart alternatives to incarceration options that limit primary caretaker separation from their children and loved ones. Thank you for your time and consideration.
Thank you, Ms. Bain. Comment or question from members of the committee, comment or question? If not, I want to thank you. I know how involved you've been in getting us to this point to even discuss the bill. So thank you for the work that you've done.
Thank you.
We have Magib Ali Brennan. I don't. Ricardo Pagan.
How you doing, guys? Can you hear me?
Yeah, they can.
You want me to start now?
Yes.
My name is Ricardo Pagan.
May begin.
I'm here today to testify on behalf of the clients here. And I've been in the system for 23 years altogether right now. And my focus is the bill of after the patient's done doing their time here, how they go back to court and add up more time for the clients to continue being here. And other things I would like for y'all to look into and investigate, really investigate what's going on in the system for the many years here. They continue making cases on clients here to continue holding them here. Like right now, I'm on North 3. I've been in North 3 for going to 7 months. They got a new thing now that supposedly the patients keep coming back testing positive for fentanyl. And they got 2 clients in my unit right now. They was in TLs. They started TLs. They've been in the system for too long now. And supposedly they tested positive twice for fentanyl, and now they took all their TLs again. They took their level, they're making them start all over again. And it's not only the passing the bill for the, I can't get the word right now, sorry, I got problem reading and writing and disability of learning a lot of things. I've been, like I said, I've been in the system too long. And I'm not here only to advocate for myself. I would like to advocate for the rest of the clients here, because I heard somebody testimony that had to do with another victim family. And they've been judging us for the longest, saying that we so dangerous, we so criminal, we so psychotic. Some of us not really psychotic. Some of us want a life back. Some of us don't take medication like me. I don't take medication. I don't hear voices. And we like to have a chance to walk out of the system, to have a life out there. For like I said, I've been here 23 years. I started a life in here. I even got married in here, and now my marriage is being destroyed through a lot of other different situations right now. It's not fair that after the patients finish doing whatever time they give them, they would take them back to court and recommit them again for more time. And that's one thing that your prior defenders that's handling your case when you first come here, they don't tell you that. They put you in here blind without knowing what you're facing. My prior defender, the one that stuck me in here, I was the first case that she dealt and putting me in writing, going injure a ride, not knowing what the system was about. All she told me that I would come in here, I go to Whiting 2 years later after I get recommended to come to Dutch, and before I know it, I'll be back out of the community. They gave me 40 years under the board. And like I said, been here 23 years, and it's not fair to a lot of the clients. I know some clients might need help, might need.
Mr. Pagan, I'm not sure if you can hear it, but your time has elapsed. So we're going to see if there are any comments or questions from members of the committee. Are there comments or questions from members of the committee? If not, Mr. Pagan, thank you for sharing your story with us. Recognize how difficult it is to do the testimony from where you are. We will hear next from Marie Kenny.
Hello. Good afternoon, distinguished committee members. I work at Safe Futures, where we provide a wide range of services to victims of domestic violence throughout southeastern Connecticut. I have submitted written testimony in support of SB 5, but I would like to provide some context today for why this is so important. I grew up blissfully unaware of domestic violence. I became a state trooper in Massachusetts, where I eventually specialized in the investigation of domestic violence investigations. During this work, I was stunned by how overwhelming an ordeal it is for someone to try and break free of an abusive partner. And now, as an advocate with Safe Futures, I know it's imperative that you understand why we must do everything we can to create systems that empower survivors to break free and that do not allow abusers to keep their hold over their partners. Let's begin with SB 5, Section 2. On its face, it seems preposterous that we would need legislation to prohibit a person convicted of attempted murder and similar offenses from seeking alimony from the person they've been found guilty of trying to kill. And yet, this bill is before you because this is exactly the type of thing abusers do to continue to harass, intimidate, and control even their former partners. In one case I investigated, we had a voicemail message where a former spouse said, "I will keep you in so many courts on so many dates, you will go broke and you will lose your job." Another case, the former partner, 7 years after their divorce, while he was living with another woman to whom he was engaged, left a voicemail message, "You are still my wife." These examples bring into full display the lengths to which abusers will go to relentlessly litigate and interfere with their former partner's ability to move on, to punish them simply for having the unmitigated gall to leave. We must help survivors break free and remain safe. And this is why I urge you to also support SB 5, Sections 1 and 8. GPS monitoring can enhance our capacity to hold abusers accountable to the conditions and restrictions placed on them by a court who has deemed them a danger. The support of a lawyer greatly improves a traumatized victim's ability to articulate the basis of needing a restraining order. Our advocates cannot give legal advice, and yet those we work with would often benefit from that kind of guidance in this process. I also encourage you to support filling the federal VOCA funding gap for 2 years and to continue the DSS funding for our child and family advocates. At Safe Futures, we serve approximately 800 children a year, and we all know they are the key to breaking the intergenerational cycle of abuse. I thank you for your time and your consideration.
Thank you, Ms. Kinney. Question, comments from members of the committee, question or comment from members of the committee? Seeing none, thank you very much for joining us.
Thank you.
We'll next hear from Mark Tazaris. Mark Tazaris. Joan Martin. Good afternoon.
Good afternoon. Senator Winfield and distinguished members of the committee. My name is Joan Martin, and I live in Farmington, Connecticut. Thank you for the opportunity to speak to you concerning House Bill 6918, an act concerning erasure of criminal history records. I have been following and supporting the clean slate legislation since 2020. This bill appears to address a number of concerns raised by the Criminal Justice Information System Governing Board in their November 2022 letter concerning the clean state statutes and the development of automated processes for erasure of certain criminal records. I applaud the governing board for their work to implement the requirements of Public Act 2132, specifically their work to create a very complicated computer program to address the requirements of that legislation. In reading HB number 6918, I came across an addition to the original bill that concerns me deeply. On page 3, line 69, there is a very troubling additional language barring record erasure of a person as follows. C is not the subject of a pending state criminal charge. I have always believed that the legal standard is persons are considered innocent unless and until they are convicted in a fair trial. This new language treats the person in question as guilty before any trial, simply because he or she has been charged. Is it not possible that the attorney for the state will decide not to take the case to trial, either due to lack of sufficient evidence or due to new evidence pointing to another person, or the person charged will actually go to trial and be found not guilty? This new language will certainly create the need for a new and likely complex computer program linking charging records to the existing program being developed to erase criminal records and requiring the computer program to revisit again and again the criminal record charges multiple times on the case until the case is dropped or resolved. Would it not be both fairer and simpler to erase the person's existing record and start a new criminal record if and when said person is convicted of the pending charge? Thank you for listening to my concern.
Thank you very much, Ms. Martin, for joining us to express your concerns, your perspective. Comments, questions from members of the committee? Comments or questions from members of the committee? Seeing none, thank you very much for joining us and your advocacy.
Thank you.
Jordan Fairchild. Good afternoon.
Good afternoon, Senator Winfield, Senator Kissel, and distinguished members of the Judiciary Committee. My name is Jordan Fairchild. I am the coordinator and community organizer for Keep the Promise Coalition, which is a grassroots group of Connecticut advocates with lived experience of mental health conditions, addiction, and co-occurring disabilities. I'm here today to testify in support of SB 926, which would align the end of term procedures for people committed to the Psychiatric Security Review Board with the procedures for people sentenced to the Department of Corrections. In doing so, this would address a long-standing injustice against people with psychiatric disabilities, which subjects them to lengthy and indefinite commitments at Whiting Forensic Hospital. We have to remember that Whiting is a hospital and not a prison. And the equities under PSRB jurisdiction are by definition not criminally responsible for the acts that they committed. The state's attorney would still be able to file for civil commitment in the probate court if they felt that someone really posed a risk. This bill would simply end the practice of recommitment by the PSRB. The reason that we commit them to the hospital in the first place is for treatment, not we don't send them to prison for that reason. We recognize that they should be afforded the opportunity to recover. But the current PSRB system completely contradicts this purpose. Equities are subject to the very likely possibility of recommitment at the end of their term by the PSRB, whereas even people in the traditional correction system are released at the end of their sentences. What is the purpose of working so hard to recover? If you know that at the end of the day, the PSRB is going to force you to remain in the hospital, and in spite of that, I have to say, so many people in Whiting have put in the work to recover. You heard earlier from Anthony Dias. Last year, he gave one of the most powerful testimonies that I've heard before the Public Health Committee about how the PSRB system has kept him locked up for years beyond his original commitments. We gave him an award for that testimony. And in spite of knowing that he and others like him are very likely to be recommitted, in fact, he has been, Tony and so many others have put in the work to recover. The question that you all have to ask yourselves when voting on this bill is whether Connecticut will recognize their recovery and give them the chance to return to the community, or if it will continue to use Whiting as a prison under the current PSRB structure. In its report to the legislature, the CVH Whiting Task Force recommended the abolition of the PSRB, something that we're not talking about this year. But Arizona, one of the other two states that has a PSRB structure, is slated to do away with theirs in July. That would make Connecticut one of two states to have this structure. And I hope that we can have a conversation in the future about Connecticut not being the last to do away with ours. Thank you, and we support this bill very strongly.
Thank you. Comments or questions from members of the committee? Nobody on that side. Comment or question from members of the committee? Seeing none, thank you very much for joining us this afternoon. Next, we'll hear from Andrew Reynolds. Good afternoon, Mr. Reynolds.
Good afternoon. I just have to pull up my testimony on the phone. My name is Andy Reynolds, as many of you know. My niece was murdered in 1989 and stabbed 33 times by an escapee from CBH. I'm here to testify strongly against SB 926. SB 926 negatively changes the way those found not guilty by reason of insanity are managed by removing the Superior Court and the PSRB from reviewing cases. This bill would remove the ability to protect victims and the acquittees because it wouldn't include any notification when an acquittee, sorry about that, is released and the potential danger it could pose to victims, and also the maintenance of protection of the well-being of the acquittees. Also, last year, there was a public act resulting from SB 450, which created a working group, which I'm a member of, to review the PSRB. This could include the dissolution of the PSRB, the maintenance or transformation of the PSRB, why change things until the final report is finished? There is also another item in the bill that calls for a no to it, but I want to note some of the testimony that was already done. The district attorney will no longer apply or review with Superior Court. It would move to probate court, and there is only one probate judge and one probate court that would have this testimony given it to it without training and without any experience on the matter. Also, Arizona was brought up. Arizona was asked to model their PSRB after Connecticut. There were several resignations and they were not followed. And they also have a guilty by mental defect law. I would also like to bring up that would remove the right for the state attorney to request continued commitment and proposes a civil commitment clause. Commitment to the jurisdiction of the PSRB is the only way a person can be ordered to comply with treatment and the only way one can ensure access to service for equities. I want to thank you for support of victims, maintain the current status of the PSRB, District State's Attorney, and Superior Court. If there's any questions, I do have more testimony, but I'll hold off until you have any questions.
Thank you. Thank you. Senator Kissel.
Thank you very much, Chairman Winfield. I just have a quick question, but first of all, yeah, my deepest sympathies on your loss. I'm very happy for the folks that have reformed their lives, but we don't often get a lot of testimony from victims or victims' families. So thank you for taking the time. On the board that you're on, or the study group, I'm assuming that was created by statute. And when is the final report due to be released?
I believe September, but I'll be corrected on that if I'm wrong. There's other people that will be testifying on that.
Okay,
but it is a committee that has full membership of every person involved in the procedure, including victims and equities.
Okay, thank you. Thank you, Mr. Chair.
Thank you, Senator. Comment or question from other members of the committee? Comment or question from other members of the committee? Now, Mr. Reynolds, thank you for joining us this afternoon. I also want to thank you for the work that you did to make it possible for you and I to have a conversation about what we're doing here. Some people would not like the push that you put on me, but I appreciate it. It is important to hear everybody's perspective on these things.
I also appreciated speaking to you. Thank you very much.
Thank you. Have a good afternoon.
Good.
James McGinnis.
Good afternoon, Chairman Winfield, Chairman Staffstrom, Ranking Member Kessel, and Ranking Member Fishbein, and members of the Judiciary Committee. My name is James McGinnis, and I am the Executive Director of the Criminal Justice Information Systems Governing Board. As concise background, the CJIS Governing Board's statutory charge includes the development of plans, maintenance of policies, and provision of direction for the efficient operation and integration of criminal justice information systems. The CJIS Governing Board is composed of stakeholders from across the criminal justice system, and staffing is provided by a combination of state employees and contractors. Its primary focus is the development of the Connecticut Information Sharing System, known as SIS, a comprehensive statewide IT system providing the ability to electronically share information within Connecticut's criminal justice community. I'm speaking on behalf of SB 927, an act concerning the state's criminal justice information system. SB 927 would enable the CJIS Governing Board to create minimum technical specifications for third-party vendors that manage police departments' electronic record management systems, providing criminal justice information to SIS. This bill will ensure vendors develop specifications upfront that are compatible with SIS digital workflows and search tools. The legislation will enable the more efficient delivery of SIS technology to credentialed criminal justice professionals. This policy change will capitalize on the significant state investment in enabling credentialed professionals to conduct cross-system searches. Registration for access to SIS is available at no cost to law enforcement units and other criminal justice system stakeholders. I'd like to describe a scenario this bill will prevent and enable SIS resources to be made available to criminal justice professionals more efficiently. A police department enters a contract with a third-party vendor that introduces technical specifications to the department's record management systems that are incompatible with other departments in terms of connection to SIS. In response, the state of Connecticut must allocate personnel and resources to create SIS compatibility, leading to delays in SIS digital workflows and search implementation. Consistent RMS specifications is an urgent and critical need to support rollout of this technology in as cost-effective way as possible, since new vendors are appearing in the local market on a regular basis. Under this legislation, the scenario I described would not take place because third-party vendors coming online in the future will need to maintain specifications consistent with those selected by the CJIS governing board. There are several compelling reasons to support compliance by third-party vendors to state information sharing system specifications. First and foremost, this connection will enhance the interoperability and sharing of critical data between government agencies and private organizations. By requiring vendors to connect to state systems, government can ensure that essential data is readily available to those who need it, including local and state law enforcement, judicial branch, Division of Criminal Justice, Department of Correction, Boards of Pardons and Paroles, Department of Motor Vehicles, and other criminal justice agencies. Because this policy will provide significant benefits to government agencies, I strongly urge passage of SB 927. Thank you for the opportunity to testify.
Thank you. Senator Kessel.
Thank you very much, Chairman Winfield. Mr. McGinnis, good to see you again. Hey, why is this taking so long? I mean, I remember we put this process in motion when the triple homicides took place in Cheshire. That was under Governor Rell. We've gone through Governor Malloy. We're under Governor Lamont's second term. And, you know, I was part of this when it started, and we looked at other states that had a program up and running, and, you know, Connecticut decided we're going to do it on our own, as opposed to like lifting something that was already being utilized in another state and trying to put it in ours. And it just, I'm not blaming you. You've just got on board recently, but is there a light at the end of this tunnel?
Absolutely. The implementation really took place in two phases. One is a search capability, a Google-like search that allows a user with appropriate access to search all the various criminal justice related databases amongst state agencies. That was put in place and operationalized back in 2019, 2020 timeframe. So currently right now, we're rolling out phase 2, which is the digital workflows, basically electronic transmittal of documents, uniform arrest records, and other things that would normally be handled through paperwork and police officers driving these to courthouses for clerks to enter into systems. So that's phase 2. So that's just underway right now. We've got about 18 police departments that are currently using the level 1 arrest notification, which is the introductory step to that. And then we're rolling out the transmittal of the detailed arrest packets right now with 3 or 4 different police departments. And we're currently working with Connecticut State Police for rollout later this year. So we're well underway in that phase 2, and there is absolutely a light at the end of the tunnel.
Well, just from the senator's point of view, if there's anything you can do to expedite the development and implementation of this program and process, the Connecticut, you know, information system, that would be great, because as I look at it, it's well in excess of 12 years now. And that just seems like way too long. So thank you. Thank you.
Thank you, Senator. Representative Howard.
Thank you, Mr. Chairman. Good afternoon, sir. What is the holdup? I guess I don't understand the need for legislation. I would imagine if a police agency was going to a new RMS vendor, that they would choose an RMS vendor that's got software that's compatible with CJIS. Is that not happening?
That is currently not the situation right now. There is not really a standard out there for the vendors to do the upfront design of their systems to be compatible with CJIS and our SIS information system sharing system. So what this legislation would do would basically mandate compliance with the SIS specifications by these RMS vendors. The current state is a new vendor will come into the marketplace. We're actually talking to two of them right now, and will indicate that they've signed a contract with the police department. Do we need to connect to your system? There's a lot of ambiguity around this. This will really clarify the requirement and ensure that those new vendors are connecting to our system. So we don't have really these gaps in the data and the arrest data that's coming in and being shared amongst the different agencies.
Okay, and then, so as it's drafted, would an agency and a municipality who has an operating RMS system and isn't up to their SIP replacement yet, would they or the vendor incur potentially significant cost to comply with this if it's existing?
Well, the ones that we've been working with 3 or 4 of them, and there's been some state funding in the past that's been provided to these vendors to help with the integration. So the vast majority, I think, of the current state would be covered. It's really addressing any new vendors that are coming into the marketplace. I did look at some industry standards in the RMS space. And there is an organization called the IGIS Institute that has put out some industry standards around RMS specifications, and interoperability and sharing with state systems is a best practice that they recommend. So, I think some of the macro factors are influencing the RMS vendors are at play here. And I think, there's other states that are looking to stand up these types of systems as well. And the feds certainly have their own standards. So this should be nothing new for the vendor base to accommodate. It's just really getting our specifications front and center in terms of a compliance that they'll need to consider when they enter the marketplace.
And have you engaged like CPCA or a cost or any of them to sort of lay out, these are the vendors that can comply, and these are the vendors that if you switch to a new RMS system, if you're up for a new one, that are going to be problematic for the state? Because I would imagine that there's not a police chief in the state that doesn't want interoperability when it comes to record sharing. Although maybe there is, but there probably shouldn't be, at least. But so is that, I guess that's what's troubling to me. I don't understand what the obstacle that you're hitting. It would seem to me that CPCA would engage with you and say, all right, well, if this vendor is not meeting the standard in Connecticut so we can share data, then we'll go to a different vendor. But are they not doing that because some vendors are more cost effective for them? Some vendors, basically are, I won't say reticent, but it doesn't seem to be a high priority for them when they're engaging with the local police departments. It's almost an afterthought to connect to SIS. And I'm working with CPCA to, better understand and keep, very close with them and help them understand what we're trying to do to, make sure we have the bulk, if not all, of the arrest data coming into the system. Because if we don't have the RMS systems plugged in, yes, the arrest data can still get in there, but it's through a manual process of the police officer driving the records to the courthouse, and the court clerk will then enter the data, and the case management systems are connected to SIS. So we'll eventually get the data. This is about getting the data a lot quicker, getting the notifications of arrests into the system to aid decision-making. Okay. I think I might follow up and just try to understand this a bit better in the interest of everyone's time today, because I just want to make a bit more sense of it. But I thank you, Mr. Chairman.
Absolutely.
Thank you, Representative. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none, thank you very much for joining us, Ms. McGinnis. Alex Zarkov. Good afternoon.
Good afternoon, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and members of the Judiciary Committee. For the record, I'm Alex Zarkov, Executive Director of the Connecticut Sentencing Commission, a permanent statutory commission consisting of Connecticut stakeholders in the criminal justice system. I'm here to testify on 3 bills. First is Senate Bill 952, an act concerning parole eligibility for an individual serving a lengthy sentence for a crime committed before an individual reached the age of 25. In 2015, the General Assembly passed Public Act 15-84, that was based on a recommendation from the Connecticut Sentencing Commission. That public act established alternative parole rules for an individual who committed a crime while under 18 years of age and who received a sentence of more than 10 years. SB 952 builds on Public Act 15-84 and raises the age of eligibility to 25. The Commission proposed an alternative draft that raises the age of eligibility to 21. Second, I would like to briefly comment on House Bill 6917, an act concerning various revisions to the criminal law and criminal justice statutes. Section 5 and 6 would give judges an ability to depart from the 90-day minimum mandatory sentence for certain motor vehicle offenses. Section 9 and 10 would fix the statute of sexual assault in the 4th degree. We propose substitute language in our written testimony. Finally, I would like to comment on Resolution 261, proposing an amendment to the state constitution on bail. Resolution number 261 would allow the courts to deny pretrial release to the accused under certain conditions. Connecticut Constitution guarantees the right to be released from jail through reasonable bail to virtually all defendants, except in capital cases where proof is evident and the presumption is great. As a result, under our state constitution, judges are barred from detaining a truly dangerous defendant with the financial resources to post a high bond. While the goal to move to a more transparent intentional detention mechanism is laudable, what is missing is the enabling legislation that details what the system of release and detention would look like if the amendment is adopted. For example, who would be eligible for pretrial detention? What would be the legal standard for detention? What would the detention hearings look like, and what kind of evidence would be accepted? Another critical question remains on the role of money bail if the constitutional amendment is adopted. In short, to be effective, the proposed constitutional amendment would need to be supplemented by a comprehensive statutory structure. Thank you for the opportunity to testify.
Thank you, Mr. Zarkov. Senator Kissel.
Thank you very much, Chairman Winfield. Alex, great to see you here in person. And I just want to extend my appreciation for all the hard work of yourself and the Sentencing Commission. It's invaluable. Sometimes it takes a while to move down the path that you chart out for us, but it's not for lack of a lot of research and a lot of thought that goes into the recommendations that you make. So thank you. Thank you, Mr. Chair.
Thank you.
Thank you, Senator. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none. Thank you very much for joining us today.
Thank you.
Ingrid Justin.
Good morning. Good morning, and distinguished members of the Judiciary Committee. I'm testifying against SB 926. My name is Ingrid Justin. I am the mother of Johanna Justin Hinich, who was a student at Wesleyan in Middletown, Connecticut, when she was murdered serving coffee at the College Cafe in May 2009. The gunman is currently housed at Whiting Forensic Hospital. In his journal, he made threats against Wesleyan students, Jews in general, and Johanna's father in particular. In my previous testimony to the Public Health Committee in April 2022 concerning SB 450, I made it clear that as a parent of a victim and a family physician, I absolutely support addressing the profound harms done to patients housed in rundown facilities with abusive and inadequate staffing. The psychiatric hospital should be a place that provides caring, effective treatment to patients with a long-term goal of allowing their return to communities, not punishment. On the other hand, the current bill, SB 926, sidesteps the goal of the PSRB, which is to ensure that patients successfully transition into the wider community. This transition requires supervision. Psychiatrists can only recommend care, they cannot ensure it after discharge. The general courts, already overloaded, have minimal experience with this process and would likewise not ensure follow-up care. Supervised transition of patients into the wider community is a win-win for all involved, patients, victims, and community members at large. I remind you that in the 1960s, when many psychiatric hospitals were abruptly closed due to a rightful horror of the abusive conditions there, patients were often left stranded and unsupported. That error is being repeated by SB 926, which concerns itself with a population with a known history of violence. The outcomes are predictable: suboptimal or no patient care because under SB 926, care cannot be enforced or supervised. Untreated illness harms patients. Lack of patient supervision may lead to further harm to victims and to members of the wider community. SB 450 established a working committee to review the PSRB in 2022. That committee includes members who have personal experience being patients victims, community members, as well as other experts. I urge you to allow the committee to finish its work. Please table SB 926 and use the committee's report to inform a well thought out and effective bill that includes supervision of care by the PSRB. Thank you.
Thank you. Senator Kissel.
Thank you, Chairman Winfield. Thank you so much for your very thoughtful testimony, and you have my deepest sympathies on your loss, but certainly doing much to turn that really horrific event that hard to make any justification for at all, but your work and your thoughtfulness is well taken. And you raised implicit in there or explicitly, you know, when we released everyone, and you said it very clearly, more artfully than I am, from the horrific circumstances that had previously existed. And I stumbled onto the property of one of those Mansfield Training School when I was in college. And actually, because I was just taking a hike through the woods, I actually came through and saw it from behind, probably past all security. And I saw the deplorable conditions and what was taking place to certain people outside. So yeah, that was a situation, and those institutions could not persist, but to just wholesale release people without any support structure was a disservice as well. A previous speaker had indicated that your group's report will come out. He thought September. Do you have better information on that? Is that correct?
Actually, I'm not part of that committee, and so I do not know, but I suspect other speakers coming up will be able to help you with that.
Okay, but that's the report that you want us to wait for.
Yes, that is the report I'm referring to. Thank you.
And that group was created by statute?
That I don't know about. It was created by the Public Health Committee.
Yeah, the chairman said the chairman
under SB 450.
Yes, so I got my answer. So I appreciate your testimony, and again, you have my deepest sympathies on your loss. Thank you, Mr.
Thank you, sir.
Thank you. Representative Fishbach.
Thank you, Mr. Chairman. Good afternoon, ma'am. Thank you for coming here today. You shared portions of your particular situation. I just wanted to get a little bit more perspective on that. Do you recall when the individual was determined to be held by the state?
So that occurred probably before when his statements were reviewed, but at least during the trial.
Call it year?
I would guess 2010 or 2011.
Okay. And at the time of disposition of the matter, what was the term of sentence?
Sir, I don't know the answer to that. I made it. I know that it's at least, it may be longer, but at least because he didn't kill two people, it wasn't a life sentence. So I don't know exactly how long it was.
Okay. So do you know how old the individual was at the time of the sentencing?
I believe he was in his 30s.
Okay. And
he had been stalking Johanna for 2 or 3 years before and had a long history of stalking prior to his connection with her.
no, I understand. And I'm just trying to get information here because it appears that what I'm wrestling with.
Yes.
A court at some point determined that this individual was going to be penalized for a finite number of years. And while we don't know what that is today, the jurisdiction of the PSRB falls within that finite term of years. So let's just assume that it's 30, okay? So that means based upon the sentencing that at 60, the sentence is over. So as opposed to a life sentence, which we know what that is. So the language before us today doesn't permit at the end of the 30 years or the end of the finite term for the doors to be open and the individual to be released, it permits the state's attorney to file a petition to continue for the state to hold that individual. So I'm trying to understand, and I think you may have testified to it, that you believe that the services under that alternative holding is not the same and therefore it's insufficient. Is that what you're saying?
No, what I'm saying is that people who are released into the community need to have follow-up care. And in a situation where they have a known history of violence, that follow-up care needs to be supervised. Otherwise, they may or may not get it. Whether that, as far as I'm concerned, if the decision is made to hold someone longer because they are ill after the 30-year period, that's a medical or psychiatric decision. If it's shorter, then it needs to be reviewed. But no matter what, providing adequate follow-up to prevent harm both to acquittees and to the community is very important in my opinion.
Oh, it's important to me as well, but just trying to get your perspective. So thank you, ma'am.
Thank you.
Thank you, Representative. Comment or question from other members of the committee? Comment or question from other members of the committee? Seeing none, I want to thank you very much for joining us today. And just to answer the question, I believe that the working group was convened on January 1 of this year, and that they will report to the committees of Judiciary and Public Health on January 1 of next year. So
thank you.
Just to clarify that for all who keep asking that question. You, Senator Kissel, yes. Okay, thank you. So we will hear next from James Jeter.
Good afternoon to the distinguishing co-chairs of Judiciary and to the ranking members. My name is James Jeter. I am the co-founder, co-director of the Full Citizens Coalition. The Full Citizens Coalition is a Connecticut-based action group focused on undoing the unjust harms caused by felony disenfranchisement and ensuring that every citizen is respected as a full citizen. Over the last 6 years, I have been a student at Trinity. I've been a policy analyst, an organizer. I've worked with at-risk youth on understanding how policies and legislation affect their life. I've helped structure the Yale Prison Education Initiative and started another program at Yale called Civic Allyship with peers, incoming freshmen with grassroots organizations in the city of New Haven. I've become a husband, and I'm active in my community. But prior to those 6 years, I was inmate number 256742. And this very committee had to make a decision 18 months prior to my release to decide on whether or not they were going to raise the age of those who will qualify for parole who came in as juveniles. And so I'm here to give my support to SB 952 because you're here faced with the same decision. I went to parole at the age of 36, but I came to prison at the age of 17. And the parole board was tasked with a very hard decision. They had to weigh the extent of my time with the productivity of my time, the time I actually did, and the pain of a family who was still grieving. And they had to make a hard decision to do what was right for the community, what was right according to what was presented to them, and they granted me parole. And so everything that I've mentioned came as a result of having that one opportunity. Coming to prison out of Connecticut's urban centers, it's a very broken process. We come from very broken communities that are still suffering from the same issues. According to HUD data, New Haven, Hartford, Bridgeport, Waterbury, the neighborhoods that are most incarcerated are also the neighborhoods that suffer from the lowest school proficiency. are neighborhoods that suffer from the lowest labor market index. They suffer from the highest amounts of poverty, and they suffer from the highest amounts of housing burdens in the state. So we are coming from communities that are impacted, and then as youth, coming in with traumas from our home, coming in with underdeveloped brains, all the stuff that you heard before and past and had to make very hard decisions around. The difference now is that you have proof. You have proof of concept. You have proof that people can come home, that given the time to develop, they can come out and do well and do right. The majority of us who have come home off of this legislation are active in our communities around reform, around healing in our communities. I implore you to raise the age and to allow more people to come home and be a part of their communities for the betterment of it. I had a judge tasked with the same.
Mr. Jetta.
It's time. I'm gonna stop.
Yeah.
All right.
All right, comment or question from members of the committee. Comment or question from members of the committee. Representative Porter.
Thank you, Mr. Chair, and thank you, Mr. Jetta, for your testimony today. I'll say the same thing that I said to somebody that came before us with similar testimony, that it's just really validating for you to be here and share that experience so that we have, right, the lived experience. It's not just the black and white that's on the paper, the bill that we're reading. These are real people. You are real. And I'm sure, no, I'm not going to say I'm sure. I will ask the question. Are there people that you know that would benefit that are currently incarcerated from the passage of this piece of legislation?
Yeah, I grew up in prison, so there are a lot of people who I know that would benefit from this passage. I think that the age differentiations in our communities don't look how they sound on paper. 17, 21, 25, we all kind of are in the same pot. We all suffer with the same arrested development prior to prison. And so there are those in prison who have been very productive with their time and are very conscious of their communities and who they are, who they become. So they would definitely benefit from this.
And because you grew up in prison, you spent decades there. Would you say that you have seen some of these same people that would be eligible if this is passed, make the same kind of strides and positive?
They look forward to it. Like they're encouraged to see so many of us come home and do the things that we talk about while we're still incarcerated. So they look forward to be able to walk in the steps that we've laid.
And is it safe to say that there is a strong support system awaiting these folks when they are, or if they are released?
Oh yeah, we've built it.
Okay.
Those who have returned, the supporters, those in legislation who have made the way by passing certain bills, it's been built and it's being built.
And they say build it and they shall come. So let's hope that is the case. Thank you again for your testimony and for the positive contributions that you continue to make to our community, our beloved community.
Thank you.
Thank you, Mr. Chair.
Thank you, Representative Porter. Comment or question from members of the committee. Comment or question from members of the committee. If not, Mr. Jetta, but thank you so much for the things you do outside of this building and the things you do in this building. Next, we will hear from Bridget Kessner. Good afternoon. Welcome back. You may testify.
Thank you. Good afternoon, distinguished members of the Judiciary Committee. My name is Bridget Kessner, and I'm testifying on behalf of the Connecticut Alliance to End Sexual Violence in support of SB 5. We also want to voice our support for SB 3, which would protect places of employment from issues of sexual harassment, as well as SB 6918, providing clarifications to Clean Slate, which you can read more about in our written testimony. We support and want to draw attention to sections 3 and 4 of SB 5, which would help fund victim service agencies, including the Alliance, facing a 50% reduction in Federal Victims of Crime Act, VOCA, dollars in fiscal year 24 and 25. Each of our organizations serve unique populations with various needs, so I'm here to share with you more about sexual assault victims and our support for them. Here are some examples of what we do with those funds and what we have to lose in Connecticut without them. Child advocates supporting victims of sexual abuse and their families every step of the way as they attempt to navigate complex systems while still reeling in the wake of a devastating trauma. Rape crisis counselors driving to the hospital in the middle of the night to support a victim who has just been sexually assaulted so that they can explain what's going to happen next, advocate for their needs to the staff, and literally stand by their side. Bilingual advocates, ensuring that a victim of sexual assault who speaks limited English can still access safety and services and has guidance through already complicated systems in which English is the primary or exclusive language. Post-conviction advocates, reassuring victims of sexual assault who call them terrified as the person who harms them is being released from incarceration, reminding them that they are right there to advocate for that victim's safety to probation or parole. Victims' rights attorneys advising and representing victims who otherwise felt lost and unheard when attempting to navigate overwhelming legal proceedings on their own. Our services are free and confidential. Our 24/7 hotline never stops running, and victims never stop calling. Over the last decade, I've held a couple of these advocacy positions myself, and I work with these advocates every single day. I can tell you firsthand that the support they provide is invaluable. VOCA is currently the largest funding source for the Alliance and our centers, and its loss would be devastating for communities across Connecticut. We're urging this committee to prioritize SB3, particularly sections 3 and 4, to further this bill and demonstrate Connecticut's commitment to victims and investment in their services. Thank you very much for your time.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? If not, thank you for joining us again.
Thank you. Good afternoon.
Mac Young.
Good afternoon, Mr. Winfield and the board. My name is Mac Young. Before I say that, I'd like to commend Mr. Jeter for what he's done. I've known him since he's been in prison, and the man's outstanding. I'm here today to speak on SB 952. I'd like the board to know that before I came here 7 months ago, I was number 96389. I served 27 years in the Connecticut prison system. I met you, Mr. Winfield, the clean slate on Windsor Street. And I'd like to just read something that I wrote, me and a friend of mine. I'd ask that you support Senate Bill 952 because it's right to wrong of over sentencing practice in the justice system from the 1990s, and it follows best practices in line with the well-known research and brain science. When we sentence a young man to prison time without addressing a lack of resources in the punitive system, it doesn't make sense. We should follow brain science and work with young men or young people who need help and guidance the most. In my professional field, I have learned about evidence-based approaches to raising successful and confident children. Having been in the justice system myself, I can tell you that young people have often failed through various systems, in addition to not having the full ability to make sound decisions. Young people have often experienced severe trauma with no support or lack of supportive systems. When we throw away a young person's life by sentencing them to lengthy sentences, what does that say about our society throughout the world? We all want safer communities, therefore we need to create better systems to help young people with less punitive measures, but rather evidence-based approaches throughout every system point of contact. I don't know if the board knows about the True Unit in Cheshire. I was a member of the Cheshire Mentoring Group, and also was a member of the True Unit. I watched young people that got the right guidance and right teaching tools. That came out their box, they came home, and they used every tool they had to be productive today. I've also watched people sit in their cells with no help from the prison department because they don't care about the kids in themselves. If you don't get up and do it yourself, they let you rot in themselves. They don't give you a job. They don't care if you take a shower. They don't care nothing about that unless you stand up for yourself. And me, myself, I stood up for myself, and God willing and God blessed me to get a commutation last year. And since I've been home, I've worked with young men and women that came home to help them get jobs and training and housing and things of that nature. I represent the Connecticut Harm Reduction. I represent Connecticut Community Practice, Partners in Practice, in Action, and also represent Best Chances. Anything I can do to help any of these young men come home or young women come home, all they got to do is call me or notify me, and I stand beside them. I stand with them. And if I have to, I stand in front of them to protect them from anything else that happened to them. I only come here for one reason. I'm gonna leave now because his bell just hit me, but I'm gonna leave, but I'm saying this. When it comes to people from my communities, we don't get, he was in the wrong place at the wrong time, or he's with the wrong people. In the other community, in the suburbs, it's always an excuse.
Mr. Young.
Oh, my son's in the wrong place or the wrong time.
Don't just jump up because it may be a comment or a
Okay.
question. Let me at least check first. Comment or question from members of the committee. Representative Porter.
Thank you, Mr. Chair. And I don't have a question. I just want to thank you for what you're doing, and for taking something that was definitely negative, and turning it around for a positive, and then coming home and making sure that you pay it forward and that you're helping our youth in very desperate times, changing the measures at which they can imagine what their future looks like. So thank you for your commitment to community and for turning your life around and being a productive citizen.
Thank you, ma'am.
You're welcome. Thank you, Mr. Chair.
Thank you, Representative Porter. Comment or question from other members of the committee? Comment or question from other members of the committee? If not, Mr. Young, thank you very much for the work that you do. And it's good to see you. And thank you for joining us today.
Thank you.
Next, we'll hear from James Maroney, who I accidentally skipped. Good afternoon. You may touch it.
Good afternoon, Chairs Winfield and Staffstrom, ranking members Kissel and Fishbein, Vice Chairs Flexer and Quinn, and distinguished members of the Judiciary Committee. My name is James Maroney. I shouldn't have to look at my paper to know that, but and I represent the 14th district, which includes Milford, Orange, West Haven, and a tiny piece of Woodbridge. Today, I'm here to testify in strong support of Senate Bills 3 and 5. On December 6th, 2022, in Milford, Julie Minogue, a 40-year-old mother, was brutally murdered. She was in her home while 2 of her children were present. She was murdered by her ex-boyfriend, despite having both a protective order and a restraining warrant against him. She had done everything within her power to protect herself, and yet she was still lost her life. This event shook our community and her family. You'll hear later today from community members who can talk more about the impact on our community, and you'll hear later from her father, Jerry Minogue, who can talk about the devastating effect on their family. But I'm here today to testify in favor of the piece of Senate Bill 5, well, the entirety of Senate Bill 5, but especially for the GPS tracking. Advocates had come to the Milford delegation, so I'm testifying on behalf of not just myself, but the entire Milford delegation, Representative Kennedy, who I believe testified earlier, Representative Smith, and Representative Ferraro, to expand a pilot program of GPS tracking that had previously been in only 3 judicial districts across the state. We believe that if that had been in existence at the time, it may have saved her life. And that's something that we would like to see expanded throughout the state. In addition, I'm here to testify in support of Senate Bill 3. Senate, specifically the portions regarding the protection of children's data privacy and healthcare data privacy. Just last year, we had passed Senate Bill 6, a comprehensive data privacy bill, but we're here this year to do stronger protections for children and for the reproductive healthcare data. One of the things we know about children's data is that the average parent posts 1,300 photographs of their children on social media before the child turns the age of 13, and the average child makes 17,000 posts on social media before they turn 18. We don't know that that's harmful, but we don't know what's going to happen with that data and what that impact will be long-term. So we're here today to make sure that we give stronger protections to children. The suggestions in this bill are modeled after the UK Age-Appropriate Design Code and the California Age-Appropriate Design Code. With that, I thank you for your time and your dedication to these issues.
Thank you. Comment or question from members of the committee? Comment or question, Senator Kissel.
Thank you, Chairman Winfield. Senator Maroney, it's always great to see you, and you don't appear before this committee as much as you should. So you're always welcome here. And having the pleasure of serving with you on the General Law Committee, can I assume that Senate Bill 3 dovetails with what we passed last year, that you spent probably the greater part of your adult life working on regarding data privacy, because it's so complex. And now that we're taking another step regarding young people, and the statistics you just quoted are mind-boggling. I have done my children a disservice because I don't think I posted anything out there. So I'm 1,600 pictures behind. But did you work on the proposal to craft it to make sure that it all works together as a cohesive whole?
Yeah, and that's one of the things. There's, as with a lot of things, it's a work in progress. We still do need to look at pieces, but yeah, the children's data, we're looking to go with what we had done last year. And one of the things we had done is we banned targeted advertising for children up to the age of 16, unless they opt in. We're looking at going up to the age of 18 this year and prohibiting the sale of children's data up to the age of 18 unless they opt in and give permission. But there are a few other features. So since we had passed that bill, California had passed their age appropriate design code, so they had raised the age to 18. But some of the other features of the age appropriate design code are not allowing features in the design to extend the use. So for example, like auto replay on videos. If you watch one video, they used to auto replay at the end. YouTube has stopped that because of the UK age appropriate design code. Again, we don't want to have features that are getting our children addicted to watching their devices and staying on. I think they're, fortunately, most of them are, or not most are, but a lot of them spend a lot of time on their devices. We want to look at our data protection assessments and require them to look specifically at any risk of harm to children. And then if they find any, to mitigate that. And that's product liability, right? You can't fly a plane unless it's been tested to be safe. And there's different requirements for testing versus for a plane versus a car, right? And it's looking at what are the levels of risk to children. Another thing that we want to prohibit is if you are an adult and there's a messaging service, so let's say Facebook Messenger or direct messages on Twitter, that you couldn't contact someone under the age of 18 unless you had an existing relationship with them. Again, looking at what are some additional features we can put in this bill to protect children.
And I guess my last question, and my son who's 19, my youngest son who's 19, jokes with me because I guess I'm the one addicted to Instagram, but he says that the algorithms are designed to get the dopamine rushing so that you just want to stay there, because he'll take off and come back and he'll say, Dad, what'd you do all last half hour? And I say, I was just on Instagram. He goes, man, you're hooked. You got to put that out. But part of the dilemma is if a parent wants to intervene, they may have to provide some of their own personal data to actually access a network to protect their minor children from accessing things that the adult or the guardian says, well, I don't think I'm comfortable with you looking at this stuff. Have you got, I mean, on that one, and I guess the other subpart is California, UK, are we going more with the UK, more with California, or is it a blend? So it's sort of two different questions, but I'm combining them so that I don't take too much time.
Yeah. Thank you for your questions as always. And we are looking at, California is based off of the UK. So Five Rights Foundation authored the bill in the UK, and we've been in contact with them. The California bill is being challenged on constitutional grounds. The case Reno versus ACLU in Nevada. And so what we have done is we've looked at the issues in that challenge to the law and tried to address them to make sure that the bill is constitutional and would hopefully withstand any challenges. So we did take out some of the features of the bill, namely the age verification piece. And we used the standard that we had in our bill last year, which was actual knowledge or willfully disregards, because that was a standard that had been agreed upon last year.
Great, I very much appreciate it. And it's my understanding that the UK model was actually emulated also by the European Union, so that we're in good company. So thank you for all your hard work on this. You're an expert in this field, and thank you very much, Chairman Winfield.
Thank you.
Thank you. Thank you, Senator Kissel. Representative Fishbone.
Thank you, Mr. Chairman. I just want to point out that the U.S. Constitution derives from our separation from the UK. So I would hope that we're looking at our constitution when we're looking at these things. You know, I do disagree about YouTube. You know, they may have attempted to prevent the successive showing of videos, and I think their attempt was done by trying to infuse an ad in between videos. However, I use an ad blocker on almost every machine that I have, and that blocks their ads. So I get right to, so anybody with a device that has an ad blocker would get around that. The age verification piece, can you just explain what was removed in that area?
Yeah, so we didn't require age verification in our bill, so we went with actual knowledge, so you know, or willfully disregards, or should have known that someone is under the age of 18. Because I guess the issue with that, the court case that I had cited was on content moderation. So we're not looking at necessarily moderating the content. We are looking at the privacy rights of the children to make sure that those are protected. And as for the YouTube, the auto replay, they shut that off for those under the age of 18, I believe. And that's what I was told. And they said that they did that across the world because of the UK age appropriate design code. So, you know, we do have some benefits despite the fact that we're not in the UK from that.
Well, I think that then would be tied to Google, because Google runs through YouTube. So if I signed up my Google account and I said I was over the age of 18, then it wouldn't apply at all. So,
correct.
You know, I think the best filter here is perhaps parents. We heard a lot today about mistakes made as children, you know, but parents, but section 13, which appears in SB 3 that you're testifying in support of. Did you hear the testimony this morning from the CBIA with regard to section 13?
No, I did not. And I was more involved with sections 1 through 8. So I am not as knowledgeable or knowledgeable at all, to be honest, about section 13.
Yeah, that's why I was a little surprised about your widespread support of the bill, because my inquiry was, you know, what does the senator know about that area? So I'm to take it that your support is a little bit more tempered, that you're just here on sections 1 through 8.
I can answer questions on 1 through 8. Yes. Happy to answer
I
questions.
appreciate it. I don't want to waste time with stuff that, no problem. Thank you, Mr. Chairman.
Thank you.
Thank you, Representative. Comment or question from members of the committee? Comment or question from members of the committee? If not, thank you very much for joining us, Senator Maroney.
Thank you.
David Marcus. David Marcus. Let's see, Jordan Wilson. Good afternoon.
Hi. Good afternoon. My name is Jordan Wilson. I'm with the Connecticut Justice Alliance, and I'll be reading one of about 50 testimonies from the True Unit in Cheshire Correctional Institution. Dear Chair, Senator Winfield, Representative Staffstrom, and members of the Judiciary Committee. I, Nicholas Ryan Holm, am submitting this testimony with the support of the Connecticut Justice Alliance to communicate my strong support for Senate Bill 952, an act concerning parole eligibility for an individual serving a lengthy sentence for a crime committed before the individual reached the age of 25. The approval of Senate Bill 952 is a life-altering opportunity for individuals who are incarcerated before the age of 25. When evaluating a bill that would create a rippling controversy among citizens who are against early release of incarcerated persons, the brain science proving lack of development in the prefrontal cortex must be taken into consideration. In reality, the only thing being afforded to the incarcerated people that would be affected by Senate Bill 952 is the chance at parole. There is still a case-by-case evaluation on whether or not the incarcerated person who goes for parole is accepted. Therefore, the passing of SB 952 is only going to affect incarcerated individuals who have demonstrated change through action during their prison term. My entire life, I have struggled with addiction. 3 months after my 18th birthday, I was arrested and subsequently sentenced to a 30-year prison term. In no way whatsoever do I deflect my accountability because I was abusing substances before my arrest.
but I do have to take into consideration in order to continue my search for understanding how a tragedy like this could occur. Moving on, I want to emphasize how there are many incarcerated individuals who take every possible opportunity for self-improvement during their sentences, including myself, and that these are people who should be giving a second chance at life. I am housed in the True Unit. I take Wesleyan College classes and work doing graphic design for vendors outside of prison. I and many others will not stop improving ourselves until the day we are released. I ask, when taking SB 952 into consideration, that you think of incarcerated people as redeemable human beings who are striving for excellence and take their lives very seriously. Thank you.
Thank you. Comment, question, Representative Porter.
Thank you, Mr. Chair, and thank you for your testimony, Jordan. I'm just curious, how many people did you get to talk to?
We got to talk to both units inside the True Unit. And when we got to Cheshire, there were people that had already had typed written testimony for us. And then there were people that we got to craft testimony with. So kind of help them, formulate their thoughts, figure out exactly what they want to say without over exploiting themselves, including too much personal information. And then we took them back, reviewed them, and typed them up and submitted them to the committee today.
I want to thank you for doing that work. How many of those folks that you spoke to do you believe would be impacted by this piece of legislation?
So many of them. There were a lot of them that asked us, how can we continue doing this mentoring role that we're doing in True on the outside? And so we're looking forward to connecting them to various organizations so that they continue bettering themselves and continuing to do mentorships and impacting the community, but all of them.
And approximately how many would you estimate that being?
I want to say maybe 80, 90 people.
Okay.
We had two groups of like
Okay.
50 people. Yeah.
All right. Thank you. And
No
thank
problem.
you for the work that you're doing.
Thank you.
You're welcome.
Always
Thank
a
you,
pleasure.
Mr. Chair. Likewise.
Thank you, Representative. Comment or question from members of the committee? Comment or question from members of the committee? If not, Jordan, it's good to see you here again.
You too.
Thank you for your work.
Thank you.
Ramon Garcia. Good afternoon.
Greetings to co-chairs Winfield and Staffstrom, ranking and distinguished members of this committee. My name is Ramon Garcia. I'm a resident of Hartford, Connecticut, and today I'm testifying in support of Senate Bill 952, an act concerning parole eligibility for individuals serving a lengthy sentence for crimes committed before the age of 25. I think it is from justice to give second chances to people serving lengthy sentences, especially those who unfortunately became products of the societal ills within their communities across Connecticut. Oftentimes, people are caught up in a vicious cycle where poverty, drugs, and violence is the norm. Personally, I was caught within the same cycle as a young adult, which ultimately led to my incarceration. I was housed in every maximum security prison within the state and crossed paths with many others who were caught up within the same vicious cycle. The only differences we really had were the prison sentences that we were serving. It was during this experience that I began to broaden my outlook on life, and I realized that life was bigger than the streets. As I often describe my transformation, I went from a street corner mentality to a global mentality. A huge factor in my transformation was connecting with and learning from some of these other individuals who were serving these lengthy sentences. Many of them remain within our state's prisons after having already served decades inside. Without doubt, if given a chance to return back to their communities and society at large, they would be great assets to this state. Never in 1,000 years, I would have thought that I'd be sitting here before you as part of the legislative process, working with youth in schools and helping people within the community. Please support this bill and give some of these folks the opportunity to return to society and contribute to making Connecticut a stronger and better state. Thank you all very much for your time and enjoy the rest of your day.
Thank you. Comment or question from members of the committee? Comment or question, reporter?
Thank you, Mr. Chair. And I just want to say thank you, as I have done with the ones that have come before you. And just really want to thank you for being a real life example that this works, right? The second chances do work and that people deserve to be redeemed when and if possible. So thank you.
Thank you.
You're welcome. Thank you, Mr. Chair.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none. Ramon, that is good to see you again.
Good to see you. Thank you all.
Ibelis Carrera. Ibelis Carrera, saw her earlier. Gaylord Salters. See one, Gaylord Salters.
I'm unmuted, am I?
Yeah, you are.
Oh, I thought
We can't see you, but we can hear you.
all right. I wanted to get that video up for you. I'm not sure how I do it.
All right, well, if you
But-
can. Go ahead.
All right. So I won't waste any time. Good afternoon, Senator Winfield and members of the committee. I'm testifying in favor of two bills today. I'll start with Senate Bill 952, which is an act concerning parole for persons serving lengthy sentences after arrest as a juvenile. To disregard the scientific implications that form the basis of Senate Bill 952 would be the equivalent of making a conscious decision to continue throwing people away. I was thrown away by the system, but I worked on myself and made a significant comeback while in prison. I spent 20 years inside, and during that, I started a company, published a total of 3 books on my company's imprint, and I also closed a global distribution deal for my company from the confines of my cell. The reason why I'm so proudly sharing this information about myself is to place an exclamation point behind the truth. We should not be throwing people away. Please support Senate Bill 952. With respect to Senate Bill 1070, which is an act concerning prosecutorial accountability, I spent 20 years wrongfully convicted because of a corrupt prosecutor. Therefore, I wholly support Senate Bill 1070. In fact, it was Chief State's Attorney Patrick J. Griffin who shipped my case off to the Chief State's Attorney's Office for an integrity review so that the state themselves may exonerate me on their own. However, while I may disagree with some of the things that Mr. Griffin testified to this morning, I commend him for his willingness to support placing prosecutors before the public to answer questions. That being said, both of these bills are significant and directly affect myself and people who come from what I come from. I do hope that you will vote for these bills. Thank you for your time.
Thank you, Mr. Salters. Comment or question for members of the committee? Comment or question for members of the committee? If not, Mr. Salters, it's good to hear from you and hope you have a good day. Rodney Moore. Rodney Moore. It says Doug Quanta. Is that correct, or is that Chris? It's Doug? Okay. There's Doug here. Okay. Olivia Rinkus.
Thank you, and good afternoon to the members of the Judiciary Committee. My name is Olivia Rinkus from the town of North Stonington, Connecticut. Thank you for the opportunity to testify. I'm testifying on several bills today, so I'll be brief. I would first like to testify in strong support of SB 926, an act concerning persons committed to the jurisdiction of the Psychiatric Security Review Board. I'm strongly supportive of this bill and any steps taken to reduce the stigmatization and criminalization of individuals with mental health needs. These reduce access to and the willingness to access resources that could be otherwise beneficial. I ask legislators to please pass SB 926 out of committee and begin taking steps to go further and eliminate a carceral response to mental health needs and instead put taxpayer funding back into communities and ensuring mental health resources are accessible, affordable, and consensual. I'm also testifying in strong support of SB 952, an act concerning parole eligibility for an individual serving a lengthy sentence for crime committed before the individual reached the age of 25. In support of SB 1233, an act establishing community-based sentencing alternatives for primary caretakers of dependent children and other eligible caretakers, as well as HB 6738, an act concerning compassionate or medical parole and credits awarded for release during an emergency declaration. I'm strongly supportive of the reducing of the criminalization of children and young adults by ensuring the ability to reduce long sentences of individuals who entered the criminal justice system as children and whose sentences negatively impact their reintegration into society due to the many barriers that prevent them from accessing employment, housing, education, and more upon release, as well as reducing the sentences of individuals with health needs that need to be addressed, and those who were released during the COVID pandemic due to limited space and had to return despite COVID still being present in Connecticut corrections facilities and still presenting a danger to people who are incarcerated as well as staff. In addition to all other measures that legislators can support that will reduce the over-reliance on harmful carceral systems and the disruption of families and communities by replacing them with community-based sentencing options or altogether reducing criminalization and use of jail sentences and other preventative measures could be utilized, or by putting more resources into communities. I'm also in support of SB 1070, an act concerning prosecutorial accountability, as prosecutors are state employees and need to be held accountable the same way any other state employee when their decisions have negative impacts on an individual's freedom and ability to live a successful life and access resources. I'm also in support of SB 1230, an act expanding access to public defender services, as legal defense is a civil right and should not be unattainable for someone for financial reasons. I'm also in support of HB 6916, an act concerning the Correction Advisory Committee. While members of the corrections departments can offer valuable insight into the system and how it works and what needs to be addressed, they also may represent potential biases during votes and thus should be non-voting. And finally, I'm in support of HB 6918, an act concerning erasure of criminal history records, which present a huge barrier to individuals re-entering society and who are in need of resources such as housing, employment, education, healthcare, and more. Thank you.
Thank you. Other comments or questions from members of the committee? Comments or questions from members of the committee? If not, Ms. Rinkus, thank you very much for joining us today. Matt Schwartz.
Co-chairs and members of the committee, thank you for allowing me to testify today on SB 3. My name is Matt Schwartz, and I'm a policy analyst with Consumer Reports. Recognizing that the legislation before us is very complicated, and we're only beginning to assess some of its more novel provisions, especially those relating to platform accountability measures relating to children. We're going to refrain from discussing those and focus instead on the health privacy aspects of the legislation. With that said, we do appreciate the general direction this bill is heading in, though we think strong data minimization requirements are the best thing that legislators can do to protect consumer information from unwanted processing activities, including secondary uses and sharing. We respect that Connecticut has kind of already gone the opt-out path with CTDPA and is now looking to create enhanced protections for certain types of sensitive health information. The definition of consumer health information is very strong and significantly widens and improves protections compared to the sensitive information category under CTDPA. As you may know, there are all sorts of sensitive health-related data that individuals may believe is either protected by HIPAA or now protected by CTDPA, which is not actually subject to default enhanced protections. For example, it's not clear that all reproductive health information would be subject to the sensitive data opt-in requirement under CTDPA. We also support the prohibitions against geofencing healthcare facilities to identify, track, or collect consumer health data. In the wake of Dobbs, this information can be weaponized against women who are seeking certain reproductive health services and should be limited as much as possible. However, we do suggest several tweaks to improve the protections of this bill. These include prohibiting secondary uses beyond what's reasonably necessary to provide a service, and prohibiting businesses from selling consumer health data full stop. In our view, there's very little benefit that can flow to a consumer from agreeing to allow business to sell their personal information or process it for secondary uses. We think privacy law should protect consumers by default and attempt to root out some of the more socially detrimental data marketplaces that create the potential for harm down the line, such as discrimination or data breaches. The bill should also clearly state that businesses may not unfairly discriminate against consumers that use their rights under the Act, including by charging a different rate to consumers who do not opt in to sharing or selling of their personal data. A right's not really a right if you can be punished for using it, so we urge drafters to include that protection. And then finally, as with all privacy legislation, we suggest that the drafters supplement AG enforcement with a private right of action so that consumers can hold businesses accountable, even if the AG declines to take up a case. So thanks again for allowing me to testify, and I'm happy to answer any questions you may have.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none, thank you for joining us.
Thank you.
Senator Looney.
Good afternoon, Senator Winfield, Representative Zastrom, distinguished ranking members, and members of the Judiciary Committee, where I was privileged to serve for many years, both as a Senate and House member. I'd like to testify this afternoon in favor of 5 bills on your agenda. I am Martin Looney, Senator from the 11th District, representing parts of New Haven and Hamden, and would like to testify in support of Senate Bill 3, Senate Bill 5, Senate Bill 952, Senate Bill 1062, and Senate Bill 1230. First of all, on Senate Bill 3, we are seeing that there is a crisis in what is happening to young people in our state and in our nation, and much of it is connected to their overexposure to what they are seeing and engaging in over the internet, and that the CDC reported that 57% of high school girls in 2021 reported feeling persistently sad or hopeless over the previous year, up from 36% 10 years earlier. 30% of high school girls seriously considered attempting suicide in 2021, up from 19% 10 years earlier. And social media use by teens has taken off greatly and just grown exponentially during that time. And it has had a number of negative effects. So the problem is multiplied in ways by which tech companies, not just social media, use personal data of minors in manipulative ways, and parents cannot keep up. And Senate Bill 3 would make Connecticut a national leader in forcing companies that process personal data of minors to protect them from what the tech companies know are risks to minors, such as financial and reputational harm, intrusions of privacy, other online situations. Integration of more technology also affects adult lives in deteriorating our privacy and creating new risks. People falsely believe that their health information data is private because HIPAA has kept information between individuals, doctors, and insurance companies private. But today, data processors are selling information about people's depression, anxiety, other mental illnesses in unregulated markets to anyone willing to pay. And that's the world we live in now. Senate Bill 5 is also very important because it would continue our commitment to protecting victims of domestic violence. Violation of a restraining or protection order is a red flag that really screams out for intervention. When we know who are at a heightened risk of harm from their abusers, we have a duty to protect them. The expansion of the GPS monitoring program under this bill will certainly save lives. In addition, members of the committee, I think that we should recognize that there are other bills on the agenda that may relate to different subjects, but are also critically important. Senate Bill 952 concerning parole eligibility for an individual serving a lengthy sentence, and stating that someone who was under 25 at the time the sentence was imposed should have the possibility of a parole, just as we established some years earlier with those under 18. Brain science studies have shown that up to age 25, there is a lack of maturity that should be taken into account in terms of eligibility for parole after serving many, many years of a sentence. So it's to some extent, I call that the Shawshank Redemption Bill. If anyone's ever seen that movie and seen the character played by Morgan Freeman in that bill, someone who developed wisdom and maturity over a long prison sentence and was certainly ready to be a responsible citizen by the time he was released.
Thank you, Senator.
Senate Bill 1062, provision of emergency medical services to an individual who's in direct contact with or custody or control of police, would of course mandate that the police pay attention to a claim of illness or injury. It's highlighted obviously by what happened last year in New Haven to Randy Cox. It would not happen under this bill, which we did pass last year in the Senate. And Senate Bill 1230, an act expanding access to public defender services. We know that the worst place to be in Connecticut, if you're charged with a crime, is to be just above the income threshold for eligibility for a public defender. And this would raise that threshold and bring more low-income people within the purview of eligibility for public defender services. Thank you very much.
Thank you, Senator Woody. Representative Howard.
Thank you. Good afternoon, Senator. Thank you for being here. Great to see you.
Good afternoon.
The first bit of data that you pointed to with high school students and their mental health, certainly social media has had an impact. Do you attribute any of that to the COVID shutdowns of the 2020, 2021 school years?
Yes, I think that that we have seen that school attendance was disrupted. We've seen a significant decline in school regular attendance and an increase in absenteeism since then. Students have come back to school in some ways not really ready to be there in the way they were before. So there were a number of factors that go into this, social media being one.
All right, thank you. I appreciate that acknowledgement. Just that quick question for him. Thank you, Mr. Chairman.
Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Mr. Senate President. Focusing on SB 3, I believe. SB 3. Section 13 of that. Are you here testifying in favor of that section?
You know which what lines that might be?
Sure.
Representative?
929 is where it starts.
929?
Yes, sir.
What's the particular issue in that that section that you're referring to?
Well,
Having to do,
it's a concept, sir, having to do with allegations of sexual assault or sexual harassment in the workplace.
right. So you're saying that in the after the definitional section, are you referring to if an employer knows that a person is evaluating the candidacy of a current or former employee or employer that information be disclosed in the recommendation? Is that
Well,
what you're-
the initial question is whether or not you're here in support of that particular section.
I'm supportive and here in support of the bill.
Okay, well, because we had somebody before who said they were in support of the bill, and then when I asked them about section 13, they said, no, I'm only here on sections 1 through 8. So I just
Oh, okay. Yes.
want to be clear that section 13. So I don't know did you hear the testimony of the CBIA with regard to that section earlier this morning?
No, I did not. I was not up here this morning and not monitoring the hearing.
Okay, so the concern that was expressed, one of the concerns that was expressed is the liability for a former employer for someone to do a bad act at their future employer. You recognize that is actionable under this language.
It may or may not be successfully actionable, but obviously somebody could assert a claim potentially.
Okay, and the concern that one of the concerns that stems from there is that businesses may just institute a no recommendation policy. We don't talk about any employees. We don't care whether they were good or bad or whatever. That's our policy.
I believe, Representative, there may already be some employers who have done that in order to avoid any question of liability coming back to them.
Yes, because they look at the kind of laws that Connecticut passes in this regard and they're being proactive. But the concern that I have from that, and I hope that you would share, is that, you know, there are certainly good employees in this state. And good employees sometimes for their subsequent employment may be disfavored because their prior employer wouldn't give them a recommendation because of that policy. So I'm trying to wrestle with if that is a fallout, why I would be in support of this particular provision that's unclear, but we're not going to get there right now, and may be harmful to innocent individuals.
Well, I think that's a policy debate about this section as to a weighing of those factors and seeing which one you decide to give more weight to. Is there a greater disadvantage to the meritorious person who may, in effect, miss out on accommodation, as opposed to on the other side of flagging those who might be predators in the workplace? I think that's a judgment that would need to be made in determining whether to support this section.
But the individuals that you typify as being predators in the workplace, that judgment against them, that criminal activity, sometimes those cases rise to a criminal, that's all discoverable through other means. The concern is that this language puts an onus on the employer to notify if it's a future employer potential of, you know, let's say a claim was made and it was adjudicated and it was dismissed. It was unfounded. And this would also require disclosure of that. Is that of concern?
Well, I think that it's a matter of how serious we perceive the problem to be. It certainly is a concern, but whether it is compelling enough to override the extra protection to future coworkers of that potentially dangerous worker, I think is a question for the committee to consider.
Sure. Then moving on to 952. My understanding, my reading of this would be if, let's say, a 24-year-old is sentenced to first-degree murder or convicted of first-degree murder, and they are sentenced to a term of imprisonment without parole, that this law would allow that individual 5 years after incarceration to apply for parole if at the time that they committed the offense, they were of the age of 24.
No, my understanding is that the intent would be that for somebody who was sentenced to life without parole, that we would interpret that as being at the minimum of 30 years, and that after 30 years, they would be eligible for a parole hearing. So that the person should be 54 years of age before being considered for possibility of release.
So can you point me to the portion of 952 that distinguishes that?
Well, that's what it should be, whether it says it or not. That's the policy that we are, that I'm certainly advancing. That what we did in the, of course, there was a U.S. Supreme Court case that compelled us to make the change in our statutes regarding those who were under 18 at the time they were convicted of a crime that gave them that that life without parole sentence. Well, the purpose of this bill is to extend that to up to age 24 and 364 days to treat somebody as recognizing the brain development studies indicate lack of maturity, especially among males at that point. So my recommendation is that the sentence that the person would have to serve 30 years if he had been sentenced to life without the possibility of parole, that there would be, of course, no guarantee of release, but an eligibility after 30 years to demonstrate that he has learned, that he has developed remorse, maturity, and is no longer a threat to society and is a different person than when he began serving his sentence.
So I think perhaps in line 16, maybe that's where you're pointing to, that such person shall be eligible for parole after serving 30 years. Is that what you're referring to?
Let me just find that. Line 16.
Yes, sir. I think that only applies if the sentence is 50 or more years.
Well, I would say that it should be that the 30-year requirement be for either those serving who are being sent either to 50 or more years or life without the possibility of release. So I would use 30 as the threshold for the amount of time that somebody would have to serve before being eligible for a hearing.
Okay, thank you for your testimony.
Thank you.
Thank you.
Comment or question from members of the committee, Representative Porter.
Thank you, Mr. Chair, and thank you, Senator Looney,
Yes,
for
thank you,
your support on these bills. And I just really wanted to especially thank you for introducing Senate Bill 1062 in light of what we are currently dealing with in New Haven around Randy Cox in that case. So I just wanted to say thank you for that, especially.
Thank you, Representative. And that bill I see is actually protecting the police as well.
Yes.
Because then they would not be in a position of having to try to determine on the scene whether somebody actually does have an injury that should result, instead of having them being taken to the lockup, being taken to the hospital first. We just establish the policy up front that if someone is complaining of an illness or injury at the time of arrest, that they get medical attention first. And that I think is because police are not medical professionals, and it would relieve them of having to make that judgment that they might turn out to be incorrect on.
Absolutely. I do see that as well. And I thank you for raising it because it is something that needs to be put into law. There was a policy that wasn't followed. And I think that's why it's extremely important that we get it done this year. So going forward, not only are the police protected, but those that are entrusted to their custody are also protected as well. So thank you again.
Thank you, Representative.
You're welcome. Thank you, Mr. Chair.
Thank you, Representative. Comment or question from members of the committee? Comment or question from members of the committee? Seeing no more, thank you very much, Senator Looney, for joining us this afternoon.
Thank you, Mr. Chair. It's always a great pleasure to appear before this committee and to engage in dialogue with the committee members.
Next, we will hear from Doreen Coleman, and I'm going to turn over to Representative Quinn.
Ms. Coleman, if you can unmute, you can testify for 3 minutes. There you go.
Good afternoon. My name is Doreen Coleman. I would like for you to support this, I would like for you to pass this bill on number 1062 about the emergency medical services when someone is incarcerated. My son, Randy Cox, is paralyzed from the chest down, and we have to help him eat and drink when the staff at the nursing facility is not around. The officers refused to listen to him when he said, "I can't move." I think everyone should have medical help at any point in time. They proceeded to humiliate him and not treat him as a human. If someone's telling you that they can't move or they can't do anything with bodily function, why are you not listening? Your first aid training, your medical training, if you have any, should be the first thing that comes to your mind. Whether they're playing, whether they're faking, and if they're not, none of those above, then it should be taken seriously to the heart that you need to get medical help. I think that's it.
Okay, thank you very much, ma'am. Any comments or
Thank
questions
you.
of the committee? Representative Porter.
Thank you, Mr. Chair, and thank you, Ms. Coleman, for your testimony. I don't know if you saw, but right before you, Senator Looney actually testified on this bill as well. And I just want you to know that you have my full support on moving this forward. And I'm really sorry for what you and your family are having to deal with right now in caring for Randy in his current state. But I am also praying for a miracle and that one day he will walk again. So thank you. Please give Randy my love and my regards. Thank you, Mr. Chair.
Thank you, Representative.
Thank you.
Any further comments or questions from members of the committee? Seeing none, thank you, Ms. Coleman.
Thank you.
Next up, we have Nancy Peters. Welcome, Ms. Peters. You have 3 minutes.
Thank you. Good afternoon, distinguished leaders and members of this Judiciary Committee. My name is Nancy Peters. I'm a resident of Norwich. I write to communicate with a number of women incarcerated at York Correctional Institution. Today, I'm going to read the testimony on behalf of one of those women. My name is Chastity West, and I'm incarcerated at York Correctional. Thank you for the opportunity to be heard on Raise Bill number 952 concerning parole eligibility for an individual serving a lengthy sentence for a crime committed before reaching the age of 25. Thank you so much for the opportunity to be heard on this bill, a bill that offers hope to so many people like me who came to prison as an emerging adult. 24 years ago, I knew very little about myself, much like most young adults. Growing up, right and wrong were prescribed in black and white between the pages of my leather-bound Bible. Once I began taking my first tentative steps into adulthood, I quickly learned that there were gray areas, lots of little daily decisions that couldn't be made by thumbing through scriptures. I wasn't prepared for that, and life wasn't sympathetic to my naivety. At 20 years old, I found myself in a situation with an older man who decided things for me. Accepting this situation propelled me towards a world where I'd be told what to do and when to do it, down to the most mundane details, such as what I'm to eat and where I'm to shower, sleep, walk, sit, everything. What I didn't realize then is that was preparing me to go from one prison to another. Being sheltered to the degree I was denied me opportunities to make little decisions and then learn from my mistakes, from which I would have gained valuable decision-making skills. As a result, I was inept in thinking for myself. So when I did, my impulsive, emotion-driven decisions led to the senseless death of a child and a lifetime of grieving for his family. Not a day goes by that I don't feel the full weight of responsibility for the terrible consequences of those actions. At the age of 23, the state of Connecticut essentially threw me away by sentencing me to life in prison. Even though Connecticut had given up on me, my first major decision was to not give up on myself. As I began to mature, I began to participate in rehabilitative programs that little by little transformed me into a thoughtful, responsible, intelligent young woman. From my own experience, I realized that despite the pronouncements of a judge, we're all capable of remarkable change, growth, and beauty, and that so many of these transformations occur in the simple process of growing up. By passing this bill, I hope that all people in the interests of justice, humanity, are able to have another opportunity to contribute to our society. Thank you very much.
Thank you, ma'am. Any comments or questions from members of the committee? Seeing none, thank you very much.
Thank you.
Attorney Doyle.
Representatives, thank you very much for having me here today. I know they stepped out, but Senator Winfield, Senator Representative Staffstrom, Senator Kissel, Representative Fishbein, Senator Quinn, Representative Quinn, other members of the committee, and good afternoon, Representative Porter. My name is Jack Doyle. I am the state's attorney for the Judicial District of New Haven, and on behalf of the State of Connecticut Division of Criminal Justice, I am here testifying on behalf of the division in support of Section 1 as well as Section 11 of House Bill 6917. Section 1 happens to deal with some proposals here regarding the statutes dealing with sentence modifications. As noted in our written testimony, there's a proposal to limit the time in which an individual can apply for an additional modification following the denial, granting, or granting in part of a motion. Secondly, that at the time of the filing, that any of the materials provided by the defendant or his counsel also be and sent to the court also be provided for the state in order to be able to review and address and use at that hearing, look into and then be able to take the position at that sentence modification hearing. In regards to Section 11 of House Bill 6917, this addresses the section of those statutes dealing with the Board of Pardon and Paroles in regards to hearings and applications applied for a commutation or a pardon. And what the State of Connecticut Division of Criminal Justice is seeking is that the Board of Pardons and Parole provide the state's attorney's office for the judicial district in which the underlying incident occurred. Upon written request, the materials pertaining to that application for that commutation or pardon in advance of a hearing that's held by the Board of Pardons and Parole, especially in regards to commutation, and to permit the state's attorney to appear at such session for the purpose of making a statement for the record concerning that commutation. By background, currently there is a policy that's been established by the Board of Pardons and Parole where if a prosecutor or state's attorney would like to address the board at a proposed commutation hearing, that the Division of Criminal Justice or the state's attorney has to file a Freedom of Information request to get a copy of that application, that packet, and the materials supporting that. That's something that we're looking to have this particular legislation address and fix. I will say on behalf of the Division of Criminal Justice in regards to sentence modifications and commutation hearings, both are different types of hearings. Obviously, one before the court, one is before the Board of Pardons and Paroles. The Division of Criminal Justice, that through its prosecutors, are in a unique position of having handled those underlying cases, those trials, those plea bargains, those investigations, where we can provide both the courts and the Board of Pardon and Paroles relevant information from the position of a prosecutor and positions of victims and positions of being the individuals who handled or negotiated or tried those cases and have information in our office. So we think these are appropriate bills, appropriate proposals, and we urge this committee to pass them and send them through. I thank you for your attention and thank you for having me here today, and I'll be happy to answer any questions that any of you may have.
Okay. Thank you, Attorney Doyle. Any comments or questions? Representative Fishbein.
Thank you, State's Attorney Doyle. Thank you for coming here today. Spent a lot of time over the weekend watching you at many of these commutation hearings. I think your service to the state has been very good in that regard. Can you just explain, because you know this commutation thing took a shift about 2 years ago, which I think you recognize, that internally the board determined that it was going to open the floodgates to this process, and you recognize that there's an issue with discovery, exchange, information. Can you just explain, you know, what the process is absent these guardrails presently on someone who is, let's say they're committed to a term of 50 years without the possibility of parole, and then you learn there's a commutation. How do you get up to speed on the file?
So Representative Fishbein, what I shouldn't let you know is I've been a prosecutor for almost 25 years. It has only been the last 8 months where I've had the privilege and honor of being appointed the state's attorney for the Judicial District of New Haven, area where I was born and raised. When I took office several months, it became to my attention that there was an increase in the number of commutations that were being filed. As you're probably, I know this whole body and this whole building is aware with the number of state employees that have moved on and transferred. When I came to New Haven, I had to, reassess the office and take on a lot of different new responsibilities. Commutations, as you've noted, there was a large increase in applications that were coming through, especially in the Judicial District in New Haven, which I'm sure you're aware covers 13 towns in a large area. When I came into office, there were about good 25 of them pending or that were calendared. We are notified by the Board of Pardons and Parole that somebody has applied and has a hearing. I believe, you've heard about the process where there's a screening process. I'm talking about the process where somebody's already been screened, and then now I'm notified as the state's attorney for New Haven that a hearing is being scheduled. There's no doubt what I do is try to find our old files. Some of these may be 15, 20, 30, 35 years old. Some of them are not digitized. Some of them may be with our appellate unit in Rocky Hill or post-conviction units, and I have to locate them. But then we seek to review them and look at them. And unlike with the sentence modifications, where applications are filed with the court and most attorneys send us a courtesy copy, the commutation packets were not sent to us. We don't know what's in that packet. When I arrived in office, I made a request to the Board of Pardons and Parole to get those packets, to see what's in there, to assess it and take a position on, do we have a position? Will we take a position? Do we need to get the victim's input? And what was met with, and I talked to other states' attorneys, was that we would have to make an FOI request through the Freedom of Information request, make that to the Board of Pardons, and they would consider it, and then they would at some point send us information thereafter. That was, I will say, for the on behalf of the 13 states' attorneys, it's quite surprising to find that we would have to make an FOI request to get those materials.
And the screening process, am I to understand, based upon what you told us, that you do not even find out that a commutation application has been filed until the matter is screened and a hearing is scheduled?
That would be correct. As a prosecutor, I've had a few cases where the victim's family have called my office and have indicated they were notified that somebody was being pre-screened. But as far as being known by the board, it is usually only when somebody's actually been set up for a hearing. And it's usually anywhere from 3 to 4 weeks prior. Sometimes a couple times it's been about 2 months prior.
No, and that's one of the problems with, a group making their own rules, because, we would make it balanced, because what we have heard is that upon the application, the victims are notified. And, even pre-screen, they're notified. And then, I can understandably they get worked up, and then the thing could be screened out that it's not going to have a hearing, and then 3 years later they get the notice again. But I think it's really important that you be part of the system at the beginning. If a notice, we're talking about not notifying the victim's family until the pre-screen, but I think it's more important for you to be notified so that you have time to prepare. So does this language before us cure that aspect? Because I didn't see that in here.
This language here is indicating that written requests specified materials pertaining to an application. As an attorney, I'll indicate it probably, if it was going to be for the pre-screen stuff, maybe it should say pre-screen or the pre-application, but I guess a reasonable interpretation also as well is this is an application, whether it's a pre-screen or whether it's the one that's actually going to go forward to a hearing. I don't know the exact number. I do know some of the numbers. I know there were over 300 applications made over the last, at least in 2022. I think I know that in the end, there were 80 hearings and there were 70. I think they had 80 live hearings, and the ones that are for the New Haven Judicial District, myself or my predecessor were notified about those. So I think it is important that we were notified absolutely when it would get to a hearing. I would defer to this body's decision on what to do in regards to the pre-screening process, because somebody might never, at least from my understanding, they may never get to the actual hearing.
And with regard to some of those commutations that have already happened, can you tell us about any of those cases that you were unable to get the prep documents so that you could present a possible defense on behalf of the state?
What I would indicate that the biggest concern for the Division of Criminal Justice would be in prosecution, at least in my experience. Most of the time, I'm able to get documents that I need, pre-sentence investigation reports. I'm also able to get the incident reports or arrest warrants, depending on how old the case is. Depending on how old the case is and how the judicial branch is doing with transcripts, I may or may not be able to get a sentencing or a trial transcript. Obviously, this body addressed that 10, 12 years ago when transcripts are in order now as a matter of right, as outlined in our documentation where we request it. But it does take time to locate that. I also, if I determine through the victim advocates that are from judicial, that are assigned to the Board of Pardons, and the victim advocate that's assigned in the judicial branch to the New Haven Courthouse, if they're not able to locate a victim, then I make an affirmative effort to locate representatives of the victim's family to get their position.
And then are you permitted access to, I haven't seen an actual commutation packet, so I don't know what is actually required. It says you can apply, right? And applications and backup come in various forms. I know that the legislation deals with you getting what was submitted as part of the application. But I also know that through some of these hearings, the conduct of the individual while they're incarcerated is very important if you're going to do a commutation. So do you presently, in defense possibly, or even affirmation of a commutation, do you have access to get their incarceration record, how many tickets they've had during their incarceration? Can you get that stuff now?
So as a prosecutor for the division, as a state's attorney for the Division of Criminal Justice, I have access to certain records from the Department of Correction. Travel movements is that I can get access to, say, for example, how many tickets somebody may or may not have received while they're in custody. But let's just say the information that might be in a commutation packet as to say how that occurred or why that occurred or programs or things that the individual's done, I don't get access to that or be able to review that unless I get the commutation packet.
And unless it's in there also.
And unless it's in there, yes.
So those sorts of things, unless they're in there, you do not have access to. So I thank you for that information. I thank you for coming here today and giving us, because we're going to be discussing a lot about this aspect of the Board of Pardons and Parole. So thank you, sir.
Thank you, Representative.
Thank you, Representative Fishbein. Further comments or questions? Senator Kissel?
Thank you very much, Vice Chairman Quinn. Attorney Doyle, great to see you here this afternoon. I'd like to just flesh out a little bit more about why you were denied access. When I was a special public defender, probably over 20 years ago now, because I had so many cases before, it was essentially GA-13 up in Enfield, but established a rapport with the state's attorney's office, open file system. We had to move the business, and playing games with procedures didn't get us anywhere because we had to resolve, are we going to reach an agreement on these matters or not? And so that's how it goes. And I'm just wondering, what exactly transpired either between you or representatives in your office with the Board of Pardons and Paroles such that access was denied, and then all of a sudden you had to go through FOI, which we're all state agencies, we have a mission to accomplish. Did they feel that they didn't have the right to open their files, or how did that go down? Because I find that really problematic.
Senator, I honestly don't know. And it wasn't just a New Haven problem. It's a statewide problem it's a statewide issue for all the prosecutors. And you touched upon something that's also, I think is important to note, is that This is probably June or July of this year, and I know that in, in 21 or 22, at least the forms that I've seen, it looks like in September of 21 is when some of the application that's filed for commutation changed a little bit. But I will tell you, as you talked about, a lot of criminal justice agencies, okay, whether it's police agencies, prosecutorial agencies, public defender's office, corrections, probation, and parole, there is a lot of exchange of information. And I know this morning you were questioning the representative from CIS about that system that's being developed, that everybody's part of it, and will be great when it's completely online and we share this information. But I will tell you, it was very ironic to me one day to be told by a representative by the Board of Pardons and Parole that if I wanted I got notice of a commutation hearing coming up, that if I wanted to get a copy of the packet, that I need to make an FOI request. And now what was very ironic is that on the end of my desk is the state's attorney. A lot of things come across my desk. And here were requests from the Board of Pardons and Parole to get copies of arrest warrants, pre-sentence investigation report, and transcripts for cases that they were screening or looking at for commutation. So I thought that was, I will admit, I have to be honest, I thought that was very ironic that you're asking my office, and by the way, that was sent out probably within the hour. And then I have to make or any other state's attorneys have to make a request for information. Because this, I think it's important for me to point out that whether we're talking about sentence modifications, commutations, I've been here all day. I've heard a lot of individuals speak here today about opportunities and second chances and rehabilitations. And what the Division of Criminal Justice is asking is just to be a part of this, to be able to weigh in whatever type of relief is being sought by an inmate or individual. Some it may be appropriate, some it may not. But prosecutors are in the very unique position of whether it's 5 years or 30 years later, we have the resources to look at the case, bring it to the attention of the court, or in this particular, bring it to the attention of the board, who I know we're looking at an application. And it's wonderful, a lot of the things that some individuals done to rehabilitate themselves. I've met Mr. Jetter before. I've met Mr. Boyd before. I met Mr. Boyd and I spoke at a presentation to young offenders a couple of weeks ago. So when we look at this, what we're saying is prosecutors, we want to be part of that process to hear what's happened, hear what to say, and perhaps give some assistance and some guidance to that board, especially, when it comes to modification is one thing, but a commutation hearing, to try to explain to the board members what this case was about, what it meant to the victims, and even some of the procedural history of it. What happened at the trial? What was presented before a judge? Why perhaps maybe a judge made a decision to sentence this way? What happened at the appellate court, the Supreme Court, sentence review, all these other procedures before. And we can't adequately do that without knowing what's, been presented to the Board of Pardons and Parole.
And I really appreciate your detailed answer, State's Attorney Doyle, and I appreciate all your hard work. And, we understand that there was a giant shift because of policies that we implemented regarding essentially retirement benefits that caused so many folks to retire. So a lot of institutional memory left, a lot of people that could pull files, go to systems. That shifted this summer. The CJIS system, I'm going to say it. I think it's dysfunctional, this process. It's taken way too long. I think the state of Connecticut should be embarrassed by its pokiness. It's not doing the public any service. I don't understand, and I'm very frustrated by that, but the new executive director there said that he's going to move it along, and I really hope so. Rep. Howard had some good points regarding that. When it comes to the commutations and our discussion yesterday with the governor's reappointments and the two new appointees, with the chairman and I know Chairman Giles, I've known him for a decade. I like him as a human being, and it's one thing to discuss policy. And I agree with Representative Porter. We have embraced the Second Chance Society mantra, and we want to take the lead with that. And we have policy debates that we have to have as a legislature as to what part of a sentence should be punishment and what should be rehabilitation, and at what point has a person served an appropriate amount of time. And that's something I think belongs in the bailiwick of the legislature. But setting that aside, the other giant issue that was raised with great dexterity by Representative Fishbein in yesterday's hearing with Chairman Giles is this due process notion that, okay, if you're going to go down this path and have a sea change regarding commutations and go for 1 or 2 a year to 76, and that's just the beginning of the tidal wave regarding commutations, because if you draw your guideline at 10 years or above, you're going to have everybody who meets those initial qualifications making the application. Let's face it, inmates talk with one another, and this word's going to get out like wildfire. Okay, if you're going to do that, what in God's name is causing you to cause the states of attorneys to have to jump through FOI hoops to just get enough information to represent the situation in these hearings? We have a system. It's not victim versus defendant. It's the state of Connecticut versus defendant.
That's correct.
And so I'm aghast that somebody there at Board of Pardons and Paroles answered on the phone or related through an email, sorry, can't do it. And I wouldn't have known till today, till you just said it, that irony of ironies, sitting on your desk are requests from them, that what would they say if you said, hey, sorry, pound sand, you have to go through FOI to get our information. Whereas you said it was provided probably that day. So do you have any documentation, emails, letters, anything that would indicate who at the Board of Pardons and Paroles told the Division of Criminal Justice, we can't give you any of this information, you have to go through FOI?
I don't know who directed it, or I have emails from parole officers. So just when I requested the information that I
It's
would have.
really important,
Yeah,
Attorney Doyle, if you could go and see if there's an email, any phone message, I want to know who made that decision. I want to know who implemented the decision, because that's important to this discussion. Because I got told a set of facts yesterday by Chairman Giles under oath, and I have no reason to doubt him. But nowhere along the line did this issue come up. And now this is another piece of the puzzle. And I think it's important, because if we're going to have a meeting, and we're scheduled to have a meeting sometime in the next week or two with all the stakeholders and representatives of the governor's office, and hopefully we can implement some changes. Maybe we're going to need some legislation or a debate on policy. That's one thing. But I think that just internally, we can set up fairer rules, especially within parts of our government. Then I need to know as much information as I can get as to exactly what transpired, because I will go to the last dog dies on this one. That is not fair and not appropriate, and it is not due process. And no one, whoever decided that, I don't know who they thought they were, that would go to you and say, you can't get XYZ information, but we're demanding of you ABC information. I'm just, some things just cause me to get, this is going to sound stereotypical, my Irish up, my ire. But I got to be honest, this is one of those. And so anything that you can provide me, I'm not trying to get anybody fired or penalized, but I want to know what was the rationale for this. If they can point to a statute and say, we didn't think we had the ability to do this, that's one story. If someone just said, we're not going to do it, that's a different story.
I can tell you, Senator, I do not know who made the decision on that.
Well,
All I know is I've made the request, and the parole officer indicated this was.
If you
the
can
policy.
relay my concerns to the chief state's attorney, if he's no longer in the room, I would appreciate the cooperation of the Department of Criminal Justice in trying to get to the bottom of this issue.
Okay, I will send that request along to him. Senator.
Thank you, sir. Thank you,
Thank
Mr. Chairman Quinn.
Thank you, Senator Kissel. Representative Howard.
Thank you, Mr. Vice Chair. Good afternoon, Attorney Doyle. I
Good
just
afternoon.
want to, I think Rep. Fishbein was sort of alluded to this point. Well, you've been a prosecutor for 25 years, you said?
This summer, yes.
So
Yes.
anecdotally, how many cases that you prosecute did the defendant have underlying mental health or substance abuse issues?
I would say, I mean, I don't have a definitive answer to that, but I do recognize that there were cases where individuals did have underlying mental health issues. Recent trials that I've had individuals with those types of issues. There's no doubt about that. There's some kind of level of that in a good number of cases.
So in a good number of cases, and a lot of the success stories, I'll call them, when folks had their sentences commuted, they had those underlying issues and they got those worked out during the rehabilitation, and that's why they're productive members of society today. So when you go to argue this on behalf of the state, are you privy to information as to what, if anything, those defendants did to alleviate their underlying mental health and addictions during their incarceration?
I would say that in regards to the commutation matters, I probably would not always get some of their medical or mental health situations, unless I would say that they put that into play in the application, or if it's part of the argument or part of their petition or their request to commute the sentence. I know that sometimes they might bring it up as part of their application process or their argument process, but I wouldn't necessarily have copies of those documents. You know, I mean, in other words, underlying medical or treatment records. It could be referenced in the application, to which I know that may be an issue. But I won't always have their underlying, and I'm sure they would raise some privacy concerns unless they really wanted to make that an issue that they wanted the board or a court to consider. Now, I would represent, I would indicate as a prosecutor that if that is something that's going to be presented, and not going over to the situation with a judge in court, it's a little bit different there. But if there is something that's being provided to the Board of Pardons and Parole that's going to be part of a basis for why somebody wants, in this situation, a commutation, I would think that it'd be something that would be provided to us. I mean, I am an attorney. I understand obligations in regards to privileged material. And if I was provided documentation such as that, I wouldn't necessarily bring it up in the hearing unless the individual seeking the commutation or his attorney brought it up as part of a basis for it. And, you know, depending on, and part of this process that we're seeking to make sure that we're part of, and you know, I know you heard a lot of testimony today. Obviously, it's about an offender attempts to rehabilitate himself, looking back at the crime and what seriousness and how serious it was, and also the position of the victim and how the victim feels about this. You know, except for one of them, all the commutation hearings that I've attended have been for murders and manslaughters. And they've been, some of them been very serious cases. You know, we're not talking about, I don't want to stereotype, but a young man who committed a couple armed or strong arm robberies when he was young. These are murder cases. And I think there are some documents and there's some things that there may be efforts at rehabilitation that somebody's effort to take that may be something that changes my outlook or my perspective. It could also change the victim's outlook or perspective. Okay? I've been at commutation hearings where victims are very adamant about the sentence not being reduced. You know, the sentence the defendant got was 50 years. The judge told me it's 50 years. Your predecessor told me it's 50 years. The victim advocate told me it's 50 years. What do you mean it's getting commuted to 25 years now? But I've also had ones where people have been very sympathetic, you know, whether because the defendant is found rehabilitated himself or found religion or whatever the case may be, and somebody may be forgiving, but perhaps the board or even a judge may not be as such forgiving. Every case is individual and unique. We all know that. And so I think there are sometimes the more records and information that we can get to assess that, the better for us.
So I guess my question is, does the legislation here, and specifically section 11, does it go far enough to make sure that you are getting all the information that all sides have, right? Because so we've had discussion with the public defender's office where, you know, there's been, you know, some question as to whether or not they're getting all the information from that the state has when they go to trial. And I've always argued that all sides should have all the information to present a good argument. So in the commutation hearing, I would say that all sides should have all of the same information to present good arguments. I don't know why I understand that the Board of Pardons and Paroles is not a court. I get that, but you're still making an argument on behalf of the state, presumably as an attorney making an argument on behalf of the defendant, in this case.
Yeah.
So does this legislation go far enough to make sure that you have everything that the other side has?
Well, I think there is some, if I just may have a moment, I think there may be still some language in here.
Well, I'll tell you this, attorney, it's been a long day and it's, you know, I'm looking somewhere in, you know, lines 415 and somewhere in that vicinity. So certainly if, you know, you don't think it goes far enough to overcome the hurdles that you're facing to make sure you have the information, if you could provide some additional follow-up to me
Yes.
or certain leadership in this committee, so we can look at that, because in order to have a fair hearing or trial in this state, whether, and it doesn't matter what side you look for, everybody has to have the same information. That's, to me, that seems to be, pretty elementary. So if you could take a look at that, I'd appreciate it. And
Yes,
thank
I'd
you,
be happy to.
Mr. Chairman.
Thank you.
Thank you, Representative Howard. Further questions? I know Representative Porter, you had your hand up earlier. Are you all set?
Thank you, Mr. Chair, and thank you for being here today.
Thank you.
I've been listening intently because I am not an attorney and I'm trying to keep up. So I'm asking some questions for clarification.
Sure.
So it's my understanding that the Public Defender's Office supplies the BOPP with client information when they go for a commutation.
If they represent that
Yes.
individual, they may, I'm sure, yeah, I'm sure
Absolutely.
they do, yes.
That's what I'm talking about.
Okay.
So is this information, because you talked about procedural information and things that you think would be pertinent to the Board of Pardon and Paroles to have when making these considerations, is the information you're talking about supplying them different from what the public defender?
To an extent, I'm sure that it might be, because if I was a defense attorney on behalf of, say, a public defender attorney or a criminal defense attorney in these either, we'll just say sentence mod or even commutation package, which may be similar. I'm going to talk about the rehabilitative efforts of my client, his background and history, whether he's remorseful or acceptance of responsibility. What has he done to improve himself while he's been in custody? And that be part of their packet. On behalf of the state, I want to be able to point out what the underlying offense is, what the history was, what the background, what led to this crime, what other courts might have done in the past. And if I'm able to locate or get the position, the victim also provide that as well. I don't think perhaps a defense attorney in advocating for their client might not want to, have some of that information, or might not feel it's relevant because they're advocating from one point of position where we might provide some other additional information. And again, as one of the other, as Representative Howard said, it's an exchange of information that then whichever body it is, whether it be a court or a parole board, can decide that. And so the information that I gather as well, okay, in doing these hearings, and I can't speak for every other state's attorney, but I'm sure it's the same, even in the post-conviction matters, they're going to share that with the defense counsel, transcripts and things of that nature, especially from court proceedings.
So with that shared information, I'm just really trying to understand. Okay, so what I'm gathering is the information that you would provide would actually be information pertaining to the past history, right?
True, yes.
What got them there, and not necessarily what they've been doing or not doing since.
What they've been doing since in custody? No, I'm quite sure that's going to come from the defense attorney, unless, but quite often, in the sentence mods, I'm sure you're aware in that statute is sometimes there's the ones in courts where there's automatic hearings at certain periods of times. And then there's sometimes where a request has to be made of the state to agree. And that, that law, this body changed that law several years back, but there are some matters which can go right to a judge in a hearing, and a defense counsel will provide us with copies of those materials and what they're sending to the court. And other times they'll send us a packet asking us to consider agreeing to a sentence modification. I have, about a dozen of those on my desk right now. They're two different methods of getting to the same thing, but it's information that's gathered by defense counsel, whether it's a private attorney or a public defender attorney.
Okay, thank you for that. So customarily, up to this point, you have not been involved with commutations, is that correct?
No, up to once I became the state's attorney in New Haven, and there was an increase of them. I became responsible for handling them for the judicial district in New Haven. Just the way that our office is currently structured with, new employees and new staffing, and I've been handling them since I think probably August or September of this year.
What I'm just trying to understand is your office as a body up to this point, you're requesting through this legislation, this piece of policy, that you all get the information prior to, right?
Yes. Well,
So I'm trying to determine whether this is something new. You haven't been involved in the process in that manner up until this request. Is that correct?
Into this request
Yes,
for
this
legislation.
policy before us, yes.
Yeah. Well, Representative Porter, what happened is myself and the other state's attorneys, let's just say once in 21, 22, once the number of commutation hearings were increased and the number of hearings were there, when we were noticed that Mr. Jones is going to have a hearing, and we would say, okay, well, can we get a copy of the packet that he or his attorney have filed with the board so we can review it to prepare and investigate it and generate a response and take a position? We were not provided it. We were told you would have to make an FOI request, Freedom of Information request, which we thought was strange, being another state agency, and being the Division of Criminal Justice, the prosecutor, that we would be able to get this information. And we were told that we would have to make an FOI request. And as I pointed out earlier, it was very ironic because I was willingly and providing information to the Board of Pardons and Parole, and as all prosecutors. But when we needed to get information about this, we were told to do an FOI request. So that is what this is attempting to rectify. Just
Okay.
that we wouldn't have to do an FOI request.
And I'm with Senator Kissel. I really am curious to know how that came about, because it was my understanding that you would get information, but some of the information would be redacted. It wasn't my understanding that you needed to put in an FOI request in order
And
to
it does
acquire
come,
that information.
and when I won't raise that issue, it does, when I do get it, it does come redacted. Okay, I mean, I am a division, work for the Division of Criminal Justice as an investigative prosecutorial agency. And so when I do get the FOI request back, it redacts information like names, last names, middle initials, socials, birthdates, things that I already have, but so I don't know why they take the time to do that, but it's about the FOI request in the first place.
All right, well, thank you. And my last question, because, we did have Chair Giles before us, and some things came up, and I found it interesting. I just wanted to get your opinion on it as someone in the profession. It disturbed me that victims' families are actually getting notified pre-screening just to have something be denied, and it does, it conjures up all that stuff that comes with that. So how do you feel about them not being notified unless it goes through pre-screening and is going to actually come before the board? Do you think that's reasonable?
I would have to say that probably would be a reasonable thing to not kind of generate these fears or these concerns on behalf of victims. If there's not a reasonable probability that, somebody is going to get a hearing. At the same time, it's difficult to say that if I'm sure victim advocates and victim service groups would say, well, we want to be notified even if they're going to the pre-screen part. So I can see the arguments in both ways though, but I can tell you, without getting into facet, there's one very, very serious case in New Haven. And I do know that this victim was contacted about the fact that the defendant was being pre-screened and was called our victim advocates, called our office, spoke to several prosecutors, and was distraught about the possibility that this was even happening in the first place. And to my knowledge, this one hasn't yet been set up for hearing, but it does cause a lot of concern.
A lot of
based on the
angst,
case.
of course.
Yes.
Well, I appreciate your response on that, and thank you, Mr. Chair.
Thank you, Representative Porter. Further comments or questions from the committee? Representative Fishbein for the second time.
Thank you, Mr. Chairman. I'll be quick. Just looking at what you have access to, we're talking about documents that are in a particular file. Do you also get access to the DOC records? Mental health evaluations that may have been done?
Generally, no. I mean, I can get access to records to see where somebody has been housed, somebody's transferred, whether they've gotten tickets, whether they've gotten, good time credits, things of that nature is across the board. But as far as getting their medical or their mental health records, from corrections, no. I think that's privileged. That's something I would have to get a release on. And I've gotten releases on those situations. But I think that with the position Division of Criminal Justice would be, especially in regards to the commutations, if there's a packet and there's information being put in there, that we should know what's in there so we can generate a response. I don't want to go back to the history of commutations and clemency and things like that, but, would just say if somebody was terminally ill and was serving a long sentence there, You know, I mean, seriously, Attorney, though, that's something that I would like to know up front there. Maybe it's going to change the position of a state's attorney or the position of a victim to kind of know that in regards to a commutation or a parole hearing. There may be
because-
certain things that we would like to look into.
Sure,
Part of the
because that's,
process.
you know, the pre-sentencing report has that stuff in it, right?
Yeah.
So now we're talking about possibly reducing the sentence or not.
Hmm.
I think all of that stuff is relevant. So once again, another problem with doing this stuff in a vacuum. But thank you, State Attorney Doyle.
Thank you.
Thank you, Representative Fishbein. Any further comments or questions from the committee? Seeing none, thank you very much, Attorney Doyle.
Thank you. Thanks for having me.
Next up, we have Cindy Wolf Boynton. Cindy Wolf Boynton. Okay, next up, we have Christopher Gilrine.
Thank you, Mr. Chair.
Okay, you have your 3 minutes.
Appreciate it. Again, for the record, my name is Christopher Gilrain. I represent TechNet. We are an industry association made up of about 100 companies throughout the innovation ecosystem, here to discuss just a few key concerns with SB 3, primarily sections 1 through 8. Last year, the state of Connecticut enacted a nation-leading comprehensive data privacy bill. Since that time, we've seen similar legislation filed throughout New England, out in the Midwest and elsewhere. And my message in state after state in my region is in the absence of a uniform federal privacy law, the best thing that we can do now is to align with Connecticut's law for the sake of clarity and interoperability. So here I am imploring the Judiciary Committee to consider alignment with Connecticut Public Law 2215, which will be effective as of July 1, as you consider any additional data privacy concepts, including those that are on today's agenda, particularly when those examples are drawn from states that do not have a nation-leading comprehensive privacy law. With regard to the health data section, this language is modeled after a bill that is currently making its way through the legislative process in Washington. TechNet, both there and here, supports the intent of that legislation to protect and safeguard sensitive healthcare information. This is detailed in my written testimony, but very quickly, the broad definition of consumer health data as currently drafted in SB 3 would cover virtually everything from over-the-counter vitamins to diapers to sneakers. The opt-in requirements that are included in the bill are onerous and duplicative, and combined with the definition means you're creating significant friction between people and their everyday necessities, and putting up roadblocks to the very kinds of care that you are seeking to protect. The deletion requirements in the bill run contrary to state and federal laws regarding the maintenance of healthcare records, as well as sound practices regarding continuing and collaborative care. Fortunately, Connecticut, unlike the state of Washington, has an existing lever to protect this kind of information without putting up these negative consequences of creating a new privacy regime specifically for this data. We'd like to work with the committee and stakeholders to appropriately define and protect reproductive and other healthcare information, and use the protections given to sensitive data as introduced in last year's SB 6. Regarding the privacy of minors, which this bill would define as anyone under 18, as opposed to SB 6's limit of 16, the majority of this legislation is based on California's age-appropriate design code, which is itself modeled after a UK law. The California law is currently the subject of litigation. There are plenty of folks here who can speak much more fluently to the legal infirmities there, but I just want to highlight one very quick piece regarding age verification. The language would require virtually every website to verify the age of every visitor to ensure compliance. This is an evolving technology that we're working to improve, but regardless of whatever advances we're trying to make, accurately determining the age of visitors will require the collection of more data. And to me, that flies in the face of SB 6's requirements for data minimization. I've submitted written testimony, so I'll wrap up there. Thank you. And we hope to be a resource to the committee.
Thank you very much, Mr. Gilrain. Any comments or questions from the committee? Seeing none, thank you very much.
Thank you.
Next up, we have Michelle Voigt. Michelle Voigt.
Hello, can you hear me?
Yes, you have your 3 minutes. Go right ahead.
Thank you. Good afternoon, distinguished members of the Judiciary Committee. My name is Michelle Voigt. I am the co-founder of Violent Crime Survivors. And today I am testifying in support of SB 5 with the addition of an amendment to the general statutes titled 53A, establishing the crime of intimate partner violence murder as a Class A felony. We support the comprehensive provisions and services that SB 5 provides victims of intimate partner domestic violence. However, lacking from these provisions is the necessary addition to Connecticut statute to define intimate partner murder in criminal code. Crucial to the surviving families of intimate partner violence victims who did not make it out alive. 28 members of the House and Senate from both sides of the aisle proposed HB 6431, an act concerning intimate partner domestic violence murder. We were told SB 5 would be included in this proposal. Connecticut Penal Code provides for several circumstances which, if present during a killing, make the crime qualify as murder. However, absent is any reference to a pattern of perpetrating domestic violence against the eventual victim over the course of time. 10 states now include reference to domestic violence or restraining orders among the enumerated aggravating factors in their capital or first-degree murder punishment structures. As a result, perpetrators of sustained domestic violence who kill their partners in those states are less likely to succeed on a claim that they caused their partner's death in the heat of passion, a common defense used by defendants to avoid convictions of murder for lesser charges of manslaughter. It's all too common that the perpetrators of these heinous acts end up serving sentences shorter than the length of time they had been abusing their victims. In 2009, Gina LeCouture, a 23-year-old mother of a 3-year-old son who was present at the time of her killing, was murdered by her husband, Jose. He used a butcher knife, plunging in deep into her chest. Police had been called to their house multiple times when he assaulted Gina. A protective order was in place. He pled guilty to manslaughter and was sentenced to 5 years. In 2010, Roxanne Young was beaten to death by James Ratchford. She was left suffering in pain for nearly 24 hours before any attempt was made to help her. A protective order was in place when she was murdered, and he had been previously arrested of assaults and had multiple prior domestic violence arrests. He received a plea deal for first-degree manslaughter and a violation of protective order and was sentenced to 9.5 years. In 2012, Jeannie Barnum, a 30-year-old mother of a 6-week-old baby, was killed by Anthony Garofalo. He received a plea deal for manslaughter and tampering with evidence and was sentenced to 25 years. He was on probation at the time that he killed Jenny for a 2001 sexual assault in which he received a plea deal there as well. Anastasia Casey, 24, was shot to death by her boyfriend, Steve Simpson.
Just quickly wrap up.
Quickly, the list goes on, unfortunately. There's so many victims that this applies to. The addition of this amendment to SB 5 is critical to hold perpetrators accountable and to provide a legal framework so that states' attorneys may charge intimate partner murder for what it is, murder, not manslaughter. Thank you.
Thank you, Ms. Voigt. Any comments or questions from members of the committee? Seeing none, thank you very much.
Thank you.
Next up will be Jesse Kelly.
Yes, hello.
Go ahead, ma'am.
Okay. Good afternoon. Thank you all for taking the time today to discuss this really important piece of legislation. My name is Jesse Kelly, and I work with the Clean Slate Initiative, a nonprofit, nonpartisan organization seeking to automate the sealing of arrest and conviction records after people have completed their sentence and remain crime-free for a period of time. The Clean Slate Initiative supports HB 6918 and asks the committee to report the bill favorably out of this committee. HB 6918 clarifies the clean slate eligibility to maximize the number of people who qualify for clean slate record relief. The collateral consequences of an arrest or conviction record impact approximately 630,000 Connecticuters. An arrest or conviction record creates lifetime barriers to obtaining jobs, housing, and education, putting other opportunities out of reach. Currently, 22% of adults in Connecticut have some type of record. HB 6918 requires proper notice to third-party data buyers, such as background check services, about record erasure. It holds them accountable for not adjusting their databases to remove erased convictions once a record is cleared under Connecticut's clean slate law. Directly impacted people can benefit from clean slate automatic record clearance, as well as their families, local employers, and the community. It will benefit even more with the passage of HB 6918, since the bill makes the technical aspects of implementing automatic clean slate erasure smoother than it would be under the existing law. From a national perspective, clean slate policies have been enacted in 10 distinct states, with each of those states in some stage of the implementation process. And as we work alongside key state agencies and advocates, we learn more about how to make improvements to the implementation process, which is what we're seeing here in Connecticut. We believe that people who have made mistakes, paid their debt to society, and now want to make a better life for themselves and those who depend on them really deserve a chance to do so. As such, the Clean Slate Initiative supports HB 6918, and we request a favorable decision. Thank you.
Thank you. Questions from the committee? Seeing none, appreciate being with us.
Thanks.
Next up will be Vanessa Cardella.
Good afternoon, distinguished members of the Judiciary Committee. I am Vanessa Cardella, licensed clinical social worker and executive director of the Psychiatric Security Review Board. I'm here to provide information about the board as it relates to Senate Bill 926. SB 926 eliminates the right of the state attorney to request the Superior Court continue the commitment of an individual committed to the jurisdiction of the Psychiatric Security Review Board. With the changes proposed in this bill, the state attorney becomes reliant on the probate court to determine if an equity requires inpatient hospitalization. The probate court does not have the authority to mandate treatment or services for equities living in the community, which may leave equities under-resourced and at increased risk. Currently, the board determines when equities can begin community reintegration and sets conditions for those discharged from the hospital. Conditions include ensuring appropriate housing, access to treatment services, and drug and alcohol monitoring when necessary. This process has resulted in a 0% criminal recidivism rate for those on conditional release. Such oversight would be eliminated for those impacted by SB 926. There are currently 34 equities under the continued commitment status, or approximately 23% of the board's population. 20 of those equities are currently residing in Whiting Forensic Hospital, and 13 of those equities are currently conditionally released in the community. If any of these equities are not found or not committed to an inpatient facility by a probate court, they could be placed in the community with no oversight to ensure treatment compliance or access to services. Civil commitment standards are different than board standards. The board standards adequately assess for current risk and future risk related to persons with a history of violent offending in the context of their mental illness. Civil commitment standards assess only for imminent risk or immediate risk. Equities are not arbitrarily or indefinitely confined to the jurisdiction of the board. As they recover, they progress through the system. Applications come to the board at the discretion of the treatment team providing care. Equities can also file for a change in status, and furthermore, equities are eligible for discharge and may apply to the court for discharge. The board will make a recommendation whether it's related to the court based on the evidence provided to the board, whether it be a matter of continued commitment or early discharge. And it should be known that the board has no control who enters or leaves its jurisdiction. That is at the discretion of the courts. The board has recommended, and the court has subsequently approved, early discharge to 76 of 401 equities.
Thank you.
Yeah.
Questions from the committee? Seeing none, appreciate being with us.
Thank you.
Joanna Bennett,
That's me. Hi.
go ahead.
All right. Good afternoon, distinguished members of the committee. My name is Joanna Bennett. I am from Waterford and a member of the Connecticut Protective Moms Group. I am a protective mother trying to keep myself and my 2 children, ages 5 and 7, safe from continued harm after leaving my abuser in 2019. Even though I physically left, there is still continued harm and danger with the post-separation abuse I experience. I'm testifying in favor of SB 5, an act strengthening the protections against the response to domestic violence. I think that having a program for the use of electronic monitoring will be helpful in keeping more domestic abuse victims safe and their abusers accounted for. The part that confuses me is that many times when a protective order or a restraining order is approved by the court, there's a stipulation that allows abusers to remain in contact with their victims on matters such as custody and visitation when children are involved. Sometimes, especially with restraining orders and protective orders, family relations and other court professionals will pressure a victim into giving their abuser access and visitation with children. If this is the case, the electronic monitoring will not be very useful as the abuser will be given legal access to their victim. In my experience, the Connecticut Family Court professionals don't really understand that cases involving domestic abuse are as serious as they are. Domestic abuse is a family problem. Domestic abuse is an abuser problem. But in our court system, it's been historically seen as a victim issue, and this focus needs to change to keep victims safe and their families safe. With the funding in the proposed SB 5, I would really like this committee to think, if possible, where these funds are going to be allocated. I survived my abuse from the tireless assistance and counseling from State Futures in New London. We've seen a couple of members testify here today. I have no doubt that without their assistance, I might not be here today. They quite literally saved my life. But once I was brought into the Norwich family court system, no one understood my situation. I was repeatedly told that my concerns were not valid, and I was forced to give unsupervised access to my children. The systems in place currently, including DCF, family relations, and other court professionals, don't really understand the nuance that domestic abuse is. After having my restraining order approved, I felt safe for the first time in years. After my few divorce mediations, I felt as though I was being pressured into arrangements that were unsafe for both myself and my children. I still feel this way today. My abuser still takes me to court at every opportunity, draining my financial resources and continuing the abuse and the control. I'm grateful to be away from the constant threat of living there, and I'm grateful to have survived my ordeal, but more can and should be done to train the professionals who meet with survivors to keep their families safe on a continued basis. I've spoken with another protective mom that could not be here today that said the judge in her case out of Hartford repeatedly gave the domestic violence advocate grief for being in the courtroom with her. So having DV advocates in court alone hasn't been effective in helping survivors. This is the environment that needs the most training. I'd love to see a part of the general fund go to programs that will help court professionals identify and process these cases of domestic abuse in a more informed manner. Connecticut court professionals should be trained by neutral authorities, both local and national. Such experts and organizations are right here in Connecticut, including Dr. Christine Cocchiella and Evan Stark. On a national level, there are so many resources such as Peter Jaffe, Joan Meyer, the National Family Violence Law, the Institute.
Thank you for your testimony.
Thank you for your consideration. I ask that you favorably report SB 5 out of committee.
Thank you. Barbara Fair will be next.
Good afternoon, distinguished members of the Judiciary Committee. Thank you for the opportunity to speak on several bills, and I'll do very quickly. Supporting SB 1070, SB 952, 1233, and 6917. Quickly for 6917, the Correction Advisory Committee, my concern was that this committee was supposed to be independent from day one. All our conversation was about being independent. And so I do have some concerns about having correctional people on the board that's supposed to be independent of corrections. On SB 1233, I quickly want to say my concerns about community-based sentencing is actually who will benefit from this. Because I heard it said many times throughout the decades of being here, that it's hard to get in prison. From my view, it's hard for some of us to get in prison, but it's quite easy for others. On SB 1070, I just want to say that this is not a huge ask, that people be, that the very system that caused the systems which have caused the most harm in our community and broader marginalized community be held accountable for the harm that they have caused. I think it's a bill that's been getting baby steps to justice, and I'm hoping that this session, they will actually pass SB 1070 and make prosecutors accountable for the harm that they cause in our communities. I'm listening to a prosecutor earlier who talked about wanting to be part of the commutation process. I can't understand why people who their whole career has been about getting convictions at any means necessary and locking people away for as long as they can. And now we want to make them a part of the process of giving someone the possibility of being released. If they had never gotten a long, ridiculous sentence in the first place, then we'd never have to have the commutation process. So I really don't understand that process. I don't understand, to me, I'm trying to understand the process of the board of paroles and pardons even being questioned because they let out more people than they've done in years. I mean, that was the purpose of having the board, is to give people, some people a second chance. Many of us didn't even get a first chance, but at least give people a chance to, after they've served a certain amount of time and they've done well, to be released and come back to community. And we've seen examples of people who have done that. And it wasn't about rehabilitation in the system, because every time I hear the system's rehabilitating, I don't know what system we're talking about, certainly not here in Connecticut. But I think we're blessed to have the Mr. Giles to be the leader that he is.
Thank you, Barbara. We appreciate your testimony on this bills. Questions? Yep. Senator Kissel.
Thank you, Chairman Snapstrom. Ms. Fair, great to see you again. You've certainly been around this building for a number of years, and this session a lot of days, and appreciate it. On the oversight board for the Department of Corrections, I know that you said you felt that it was inappropriate to have anybody from DOC or even retired from DOC involved in that. You pointed to a bill. Does that bill remedy this? And the second part of my question is, I believe the current board has had one meeting. I don't know what transpired, but did anything transpire at that meeting, if you know?
Yes.
That would cause you concern?
I was actually at the meeting. The biggest concern I have for having correctional staff on there is because it's supposed to be independent oversight. For me, I don't see how it's independent if we have two correctional staff sitting on the board, because how do people from inside bring things to this board to be handled when you have correctional people sitting right on the board? And I didn't have a problem with past correctional people, because we actually have Commissioner Scott Simple on the board, which he was the one to provide expert opinion on corrections. And that's what we needed. We wanted to balance it with some expert opinion. These two people that they put on the board have no expert opinion. They're just work for DOC. And so I just didn't see the need for them to be up there, but I think they take away any confidentiality, any trust that people will bring to this board, knowing that everything they discuss is right in front of correctional officers who are still connected with DOC.
But again, just very briefly, you said you attended that meeting.
Oh, yes. Right.
I was just wondering what took place, that if anything happened that caused you concern.
The thing that really caused the most concern is the fact that neither one had anything to bring to the board. It was just like they were just sitting there listening. They introduced themselves, but had nothing to contribute. And so it just furthered my concern for what is their purpose on being on the board.
All right. Thank you, Mr. Chair. Thank you, Ms. Fair, again for your input.
Further questions or comments? Seeing none. Ms. Fair, always good to see you. Thanks.
Thank you.
Alexa May Richards.
Hi, can you hear me?
Yep, go ahead, ma'am.
Good afternoon, Chairs Winfield and Safstrom, Vice Chairs Flexer and Quinn, Ranking Members Kissel and Fishbein, and members of the Judiciary. My name is Alexa May Richards, and I'm a resident of New Haven. I am fortunate enough to be here today, not as a victim or survivor of domestic violence, but as someone who wants to lend her voice to victims and critical domestic violence service providers that need Senate Bill 5 for their safety and to continue the important work they do. In 2020, my city, New Haven, had the highest number of reported family violence arrest incidents in the entire state of Connecticut. This bill takes crucial steps towards making our community a safer place for those people. Too often, in cases of domestic violence, turning to authorities for help only increases the chances that victims might be subjected to violence and abuse via retaliatory intimidation. And too often, restraining orders are only enforced after they've been broken in a dangerous way. In 2012, Connecticut launched a GPS tracking pilot program designed to enforce restraining orders by tracking domestic violence offenders. SB 5 builds on this program by providing victims with a device that would notify them and the law enforcement if their abuser has violated the restraining order, and provides a live monitoring feature as well. This kind of GPS tracking has the ability to change restraining orders from what is often a reactionary measure to a preventative measure for domestic violence revictimization. Another important function of Senate Bill 5 is preventing victims of domestic violence from having to pay alimony to their abusers following a divorce. For victims exiting an abusive relationship, space, both physically and emotionally, can be essential to moving forward with their lives. Having to pay alimony leaves a financial tie between victims and their abusers that allows abusers to hold a place in their victims' lives that they do not deserve. Additionally, it is morally reprehensible to force victims to pay money to someone who inflicted harm upon them. This section of Senate Bill 5 is long overdue and would release many victims from a financial responsibility that leaves them tied to their abusers. Finally, one of the most eminently important functions of Senate Bill 5 is providing funding to services that were previously reliant on funding from the federal government. Starting in 1984, the Victims of Crime Act, VOCA, funded grants given out to a variety of victim services, most of which are nonprofits, to allow them to carry out the necessary work in helping victims of crimes, including domestic violence, sexual assault, human trafficking, and child abuse. The recent cuts of 50% of VOCA funding mean that most victim service providers will face major financial hurdles in trying to carry out their work. Staff cuts and lack of resources will impair these services and has the potential to leave many victims at risk and without the support they need. Passing Governor Lamont's proposed $13.175 million in funding would allow victim services like community advocates and the Connecticut Domestic Violence Hotline to remain up and running. In conclusion, this bill has the potential to protect victims of domestic violence now and in the future, and not passing it could leave so many victims in harm's way. In Connecticut, victims of domestic violence are open.
Thank you for your testimony. Folks, I know it's hard on the remote to hear the bell, so I do apologize for cutting folks off, but we do still have quite a few folks left to go who want to testify, and the hour is getting up there. So we are going to be strict with the 3 minutes. Not trying to be rude, but we do want to make sure everybody has a chance to testify or signed up. All right, next will be Patrick Tomasowicz. Thank you. Appreciate that.
Not at all. Hello, Mr. Chairman and other members of the Judiciary Committee. It's an honor and a pleasure to be in front of you, and I'll be brief. I have two matters that I represent the claimants on. Matter number 21, which is the claim of Mark Stewart, and matter number 33 on the docket, which is the claim of Macy Torres. These claims have been pending since the date of the event, about 7 or 8 years with the agency. And when Commissioner Scott was reappointed, I testified in her favor, making a plea during, I think it was a COVID reappointment hearing, that her agency be restructured and she get more help. I think the Claims Commission was restructured, and I think that a new commissioner is going to be put in place. I've learned that. I had made multiple inquiries on these cases because they've both been litigated and they're both waiting for a decision. And the matter of Stewart, if a clerk checks the file, this case has been pending 7 or 8 years, was litigated 2 or 3 years ago. We never got a decision. The matter of Torres, I think we've been waiting for a decision. There was a motion to dismiss, which delayed things, which was denied. And then we tried this case It was on the papers by agreement, and it's been 2 or 3 years, and we haven't received a decision. Briefly, and not to be overly dramatic, but justice delayed is justice denied. And I really believe my clients, when I tell you, are in pain, and when I tell you they call me, and when I tell you they ask me what is going on, and when I tell them that the Claims Commission just is broken and needs to be fixed, their patience has like run out. And that's why I'm here to, I suppose, object to the extension of time, or formally to object to the extension of time, chairman and other members, to dispose of the claim of Macy Torres, and to object to the extension of time to dispose of the claim of Mark Stewart. I'm here to request that both matters be permitted to go forward so I can institute suit, which is long overdue on these claimants' behalf.
Thank you. We hear you on that. You're not alone. Unfortunately, some of these resolutions got put on today instead of claims day last week when we did the rest of them, just because of drafting time. But we hear you. We do have a new claims commissioner who's hopefully going to be confirmed very soon. We also had a bill and are hoping for budgetary appropriation this year to appoint a deputy claims commissioner, full-time deputy. So certainly would encourage you to lobby in favor of that. We are working to get this cleared up. Senator Winfield.
Yeah, thank you, Mr. Chair. So I'm familiar with at least one of your clients.
Yes, I think we've spoken.
We spoke a couple of years back.
Yeah.
Have tried to get your client what they need. I think the committee is outside of your client. The committee is fully aware of what has happened in the claims process. I'm not sure that there's a great answer here. Representative Fishbein the other day, when we had the hearings, talked about the options that the committee has. None of them probably make your client whole immediately. But I think we understand what has happened and have an eye towards getting your client and others towards some semblance of justice. So that's what we're working on here. And hopefully we will not have to hear from your client, although we'd love to hear from him in other respects, have to hear from your client for much longer.
Chairman Stafford and Senator Winfield and the other members of the committee, thank you for allowing me to speak on behalf of Macy Torres today and Mark Stewart. Thank you.
Yep, appreciate sticking with us. Holly Cheeseman.
Good afternoon. Chairs Winfield and Stastrom, ranking members Fishbein. I see Senator Kissel has stepped out, and distinguished members of the Judiciary Committee. I'm happy to appear before you today. Thank you for hearing my testimony in support of raised House Bill 6887. I was here last week with Heather Rodriguez, whose daughter Corinna was murdered by her abuser in my district. Corinna was stabbed 47 times. The bill Heather was testifying on 6682 has a section that's similar to one in here, treating murder in the course of family violence as a special circumstance crime. We've heard a lot today about how people convicted of crimes face lifetime barriers to employment, to education. What about the lifetime barrier Corinna Zukowski's sons face of not having a mother? The lifetime barrier that Heather Rodriguez has by not having a daughter to embrace. The lifetime barrier victims of these violent crimes face to have peace of mind, to have physical health, to have mental health. I firmly believe that murder in the course of family violence, because of the barriers it places before the victims and their families, deserves to be treated as a special circumstance crime. I believe that the same sanctions, that we accord for other crimes against police officers, corrections officers should be applied to someone who stabbed someone 47 times and deprives 3 little boys of their mother. A section, I am strongly in support of Section 3, which I believe also appears in SB 5, would provide statewide electronic monitoring, particularly for pretrial accused. I know when I attended last summer a meeting of the Connecticut Coalition Against Domestic Violence, there was much testimony in support of this pretrial electronic monitoring, because that is the time at which victims may be most at risk. And surely we as a state can provide some semblance of safety. When I talked to Judge Pizzuto afterwards, she indicated that the cost of extending this throughout the state for the biennium came to just under $4 million. Is there a price we can pay that is too great to protect these women and men and their families from their abusers when they're waiting for trial? I think that is a worthy expense, something that will pay big dividends. I want to urge you to support this. I want to thank you.
Representative. Thank you. Questions from the committee? Seeing none, appreciate you being with us.
Thank you.
Sandy Lamonaco.
Yes, thank you. I'm number 79. I'm here today in support of 2 bills, SB 1070 and Act concerning prosecutorial accountability. I ask that you please support this bill and vote yes, because state's attorneys are some of the most powerful but least accountable actors in Connecticut's legal system. And the public has a right to information from each prosecutor's office at 13 different districts, so we could better determine what are best practices across the board. I'm also, thank you very much. Oh my God, I'm so sorry. Senator Winfield, Representative Strasser, and Judiciary Committee members. The second bill would be to support Senate Bill 952. I am a mother of 2 children, a 22-year-old and a 4-year-old, and I'm also a formerly incarcerated person who received a pardon. Today, I've been privileged to have 2 master's degrees in social work and public health, and I have worked for the ACLU to develop smart justice, worked for the Best Chance program, and a halfway house. We need to end the criminalization of young people and finally end lengthy sentences. At the age of 13, I made a mistake that could have cost me 20 years in prison. I never forget that harmful mistake that I made. If you have kids, particularly those under the age of 25, you know that young people do not stop making mistakes for some time. Brain science states, if someone experienced trauma, the frontal lobe may take longer to fully develop. Most people in the United States legal system have been survivors of multiple types of trauma. The DOC is not equipped to help young people with growth adjustments, trauma, or rehabilitation. Giving a young person a long sentence knowing that there is a lack of resources in a punitive system doesn't make sense. It's also not right. Fortunately, many people who have been sentenced lengthy sentences have taken upon themselves to be better individuals, to help other people by being mentors, by getting education for themselves and becoming teachers, facilitators, and certified nurses aid to take care of others. This is all selfless acts. I know that this is true. Having worked directly with people inside, I created a blog for people to have a voice and talk about those experiences. I also work on reentry resources and help other individuals that are formerly incarcerated develop their own programs to give back. In my professional field, I've learned a lot about evidence-based approaches to raising successful and confident children. And having been in the justice system myself, I can tell you that young people have often been failed through various systems. When we throw away a young person's life by sentencing them to lengthy sentences, what does that say about our society as a whole? There isn't mental health or rehabilitation inside, unless you're sentenced 2 years or more. You're put on a waiting list. But these individuals who have lengthy sentences are told by the DOC, no, you cannot take these programs after you wait a very long time on that list. They tell you that that program is safe for someone with a shorter sentence. What does that say about the Department of Corrections? And what does that say about us as a society and rehabilitation as the public believes there is inside these prison systems? I believe that you should support Senate Bill 952 because it rights the wrongs of over-sentencing practices. In research, it's shown that there's about 200 people left that are over-sentenced. Thank you so much.
Thank you. Questions or comments? Seeing none. Representative Porter.
Thank you, Mr. Chair, and thank you for your testimony. I wanted to check because I do believe that you do a lot of work with folks that are going through the commutation process. Is that correct?
Yes.
Okay, so we heard that there is a request that the prosecutors would like to have information in that commutation package. And I didn't think to ask him while he was before me, so I wanted to see if this is something that you could answer. What exactly is in the commutation package? And do you think that that is fair? That
Yeah.
information be shared with the prosecutor's office during that time?
That's a really good question. So I think there's a lot of misconceptions and questions about the commutation process. I've helped put those packets together, and a lot of it is just support letters, and that includes from DOC staff and from other programs that people have participated in. There were a lot of applications, but just to clarify that a lot of those applications were not even eligible, did not make it to pre-screen. And the reason for that is because there are a lot of questions for people inside, because there's not much information that people have inside or access to information, especially if you are sentenced a long sentence. So to go back to your question, the packet for commutation, I could understand if they want to know if the person has been rehabilitated, but the question for me would be, why do they need to know that if they're not making the decision, if the decision is made up by the board, and then respecting their roles and respecting the legislative process and the powers that, you guys, the legislators have invested in the Board of Parole and Pardons and the trust that we have in their decision-making. And just to be clear, the commutation process is not easy. There are very difficult questions. You can look at those, and you will not be considered unless you answer those questions just in your application portion. There also are names, phone numbers, email addresses. So that's very private information. So I could see why, if that prosecutor is asked to file a FOIA or a Freedom of Information Act, because there's a lot of private information about public people who may be writing support letters, including staff from various organizations, friends and family of that person. So that could target individuals. So I could see how, they would want to keep that information private.
All right, thank you so much for that. I appreciate you bringing that clarity for me. Thank you, Mr. Chair.
Thank you. Further questions or comments? If not, thanks for being with us. Maureen Platt.
Good afternoon, Representative Sandstrom, Senator Kissel, and other distinguished members of the Judiciary Committee. I am Maureen Platt. I'm the state's attorney for the Judicial District of Waterbury. I'm here representing the Division of Criminal Justice, and I would respectfully oppose Senate Bill 926. Now, our reason for opposing 926 are concrete, and I will be brief. The first reason, as this body has heard, there is currently a task force. That task force was just established last year under Public Act 2245, which is presently examining this issue. It is a multiple disciplinary task that has been diligently meeting, doing its homework, and venting out this issue. There are many people on that task force, only one prosecutor, I would point out, Attorney Radler, who spoke to you earlier. We also have 2 acquittees on this task force, so they can speak to the experience of being under the PSRB and many healthcare professionals. So we would ask you to allow us to continue to do the work that we're now doing now. Our report will be available in 8 short months, and we would ask this body to wait for any major changes. The second reason is that, as Representative Fishbein correctly stated, state's attorneys will still be moving for commitment. Only the forum for that commitment will change. We would ask that it remain with the state Superior Court, and our reasons, again, are concrete. The first and foremost is the standard use. Under the present system, the court looks at public safety with a secondary consideration of the welfare of the acquittee. If it went to probate court, that standard would change and it would go to the least restrictive method. So it is a different standard. It's a vastly different standard. We would argue public safety would be jeopardized, and the probate court could not consider the danger to the community. We would also cite 17A 498C1. If it goes to probate court, there will be a major change. And that means that the PSRB, who had supervised this person for perhaps decades, would not be permitted to submit its assessment of whether the equity should be recommitted. So they would be denied this information. Specifically, physicians connected with the hospital for physical disabilities to which the application is being made would be prohibited under our law from submitting the certificates required for civil commitment. Now, as previously stated, this is a small group of individuals. As of last Friday, I think there was 141 individuals committed to the PSRB. Of those, only, I think it was 37 who were actually recommitted. Thank you very much.
Thank you. Questions or comments from the committee? If not, thanks for sticking with us. Najij Ahern. Najee Ahern. Jeffrey Perry.
Good morning, distinguished members of the Judiciary Committee. My name is Jay Sheen Perry. I'm a formerly incarcerated person. I've just been released not too long ago on accommodation. I'm here in support of the Senate Bill 952 for the juveniles. And I believe that a lot of juveniles have been incarcerated, and a lot of them don't understand the whole system. I've been incarcerated for 30 years. I was there with a lot of young men when they came in. They had to figure out the system. They didn't understand why they was in prison. They didn't understand, if they would ever get out, and they would come to me and they would ask me, how was I able to do the time that I was doing? And a lot of them young men have testified before you today. And I just want the people to know that these were some of the brightest young men that I ever met in my life. Some of them have excelled in college, higher than some of the students that have been there for a year or two before them. So to look at them and to say that they don't deserve a second chance, you're throwing away some of the best of our community. And I witnessed that. I've sat there when they had issues with DOC, family members passing away, and not knowing what to do or how to handle it. And being an older person myself and able to deal with the situations that I have dealt with in my past, I was able to mentor them, and I was able to see that they could come home to society and be an asset to society. So this is why I want to support the Senate Bill 952, because some of these young men and women that have been incarcerated at a young age, they are adults now, and they understand their mistakes. Some of them have rehabilitated themselves. There's no rehabilitation in the DOC. I heard a lot of testimony today talking about rehabilitation. We have rehabilitated ourselves. We have sat down in the rec rooms, in the child halls, and sat down and talked to each other and figure out what we have done wrong, how we can make it better, how we could come home and be an asset to society. I'm the founding member and vice president of Guided by Purpose Reentry Initiative. We have started this organization while I was incarcerated.
Thank you, sir. Questions or comments from the committee? Seeing none, we appreciate you being with us today and for advocacy.
Thank you very much.
Kathy Flaherty.
Good afternoon, Representative Staffstrom and all the members of the Judiciary Committee. My name is Kathy Flaherty. I'm the Executive Director of Connecticut Legal Rights Project. I want to put our position on several bills on the record, and then I want to spend my time talking about Senate Bill 926. We are in favor of 1062, the Medical Civil Rights Bill. This committee passed it unanimously. It passed the Senate on the consent calendar. It would be great to get it through the entire legislature this year. We are against 1231. CLRP's legal director submitted lengthy written testimony. Unfortunately, he's not going to be able to appear at this hearing. The bill is probably unconstitutional, so I would not recommend proceeding with it. Also encourage you to move 6918 forward and make clean slate a reality. But I want to talk about 926. That is a priority bill for us. And yes, it absolutely is a change from the current way of doing things, because the current way we're doing things is wrong. There is currently a federal civil rights lawsuit pending in the District Court of Connecticut, filed by Connecticut Legal Rights Project and Disability Rights Connecticut against DEMIS, the PSRB, and Whiting Forensic Hospital, because our current system violates people's rights under the Americans with Disabilities Act and the Rehab Act. The standard we use is legally wrong, and we need to change the process. Just because we've been doing it this way since 1985 doesn't mean we need to keep violating people's rights under the law when it comes to recommitment. And just because it's happening to 34 people is violating the rights of 34 people something the state should be doing? My answer to that question is no. It's an issue of fundamental justice and equal protection for people living with mental health conditions, instead of perpetuating discrimination that is based on bias, misperception, and stigma that somebody who has once been violent will always be violent. And gee, if they have a mental health condition, we better just keep them locked up forever. It needs to stop. And this committee needs to be part of doing that. The group that's meeting now is a working group. It is not a task force. Yes, it was established legislatively, but that's because its legislature already appointed a task force after a significant abuse incident at Whiting. It didn't even get everybody appointed till after I wrote an op-ed that was in the Sunday Hartford Current. It finally met. It issued a final report recommending abolition of the PSRB. And the response of this legislature was, oh, let's create another working group that is constituted differently that will come to the opposite conclusion. That is not forward progress. So I'd encourage you to move 926 forward. You've heard from people who are inside Whiting this morning. I'm happy to answer any questions.
Questions from the committee? Representative Porter.
Thank you, Mr. Chair, and thank you for your testimony, Ms. Flattery. We just heard someone before you that was saying, and I'm curious what your take is on this report and the fact that we're being asked to wait. Why shouldn't we wait until the working group issues its report to do something?
This is not to downgrade the work of the people who've agreed to serve on the working group and the legislature in creating the working group. But when what you're doing currently violates people's rights, I don't know why you need to wait for yet another group to issue yet another report that's probably going to tell us the same things that we've been told since literally 10 years before I was born, when Governor Dempsey's had a blue ribbon commission on mental health. And we issue report after report after report saying what our system needs to have, and we don't do it. There is no rule saying you only provide services to people who are under the jurisdiction of the PSRB. There is nothing saying you can't adequately resource our community-based system of services and supports, including community-based forensic mental health services. There is nothing saying you need to have this group of 6 political appointees who serve at the pleasure of the governor with a mandate for public safety and whatever safety and well-being of the equity means, because we don't even know what that means, when it does not align with the direct threat exception of the ADA. We don't need to wait.
Okay.
Have political courage, move it forward.
I appreciate that. And my last question through you, Mr. Chair, just for edification for those that don't know, what is PSRB?
That is a great question. It is the Psychiatric Security Review Board. And it was established in the wake of the John Hinckley verdict. And it is a group of 6 political appointees who serve at the pleasure of the governor, who do have, at least through last year, that mandate to solely work for the protection of society. But was added a second concern for the safety and well-being of the equity with the bill that passed last year.
All right, thank you. Thank you, Mr. Chair.
Further questions or comments? Seeing none, thanks for being with us.
Thanks.
Yolanda Wong.
Yes, can you hear me?
Yeah, go ahead.
All right, thank you for having me here today. My name is Yolanda Wong, and I'm a student at Yale University. And today I'm testifying in strong support of the passage of Senate Bill 1233, which is an act establishing community-based sentencing alternatives for primary caretakers. The passage of this bill is the best option for protecting families in the state and communities from the destructive impacts of incarceration, and this bill best aligns with Connecticut being a second chance state. First, I'd like to go over some of the ways that incarceration negatively impacts families. With more than half of Connecticut's prison population being comprised of parents, it's evident that mass incarceration is something that prevents primary caretakers from being able to provide for their dependents. When it comes to minor children, the imprisonment of a parent or caretaker is recognized as a stressful or traumatic event for children, having long-lasting effects on children's development and mental health. Similarly, for elderly and disabled individuals, finding an alternative source of support when their primary caretaker is incarcerated is often a severe financial and health burden for them. Furthermore, the effects of incarceration extend far beyond the term of imprisonment. Incarcerated parents are likely to lose their parental rights due to strict timelines set by the Adoption and Safe Families Act, or the ASFA. And additionally, incarceration means a loss of family income because primary caretakers often cannot work from prison and often struggle finding stable employment after re-entry. By providing community-oriented alternatives to incarceration, such as drug addiction treatment and family counseling, this bill would allow families to stay together. The standards on who qualifies for alternative sentencing based on whether someone's crime is nonviolent and based on their previous criminal history also means that this bill would still promote community safety. And the bill doesn't only benefit the families. This bill is fiscally and logistically beneficial for the state as well. Research has shown that rehabilitative measures cost less per individual compared to imprisonment, and not only that, these measures reduce recidivism rates. By directing primary caretakers out of rather than into prisons, this bill also addresses prison overcrowding problems and court backlogs. In conclusion, SB 1233 offers sentencing alternatives that keep families together and help communities heal from the negative impacts of incarceration. Thus, I urge the distinguished members of this community to vote in favor of this bill. Thank you.
Questions or comments? Seeing none, thanks for being with us. Christina Quaranta. Christina Quaranta. Dieter Tejada.
Good evening, Senator Winfield, Staffstrom, Representative Porter, Kissel, respective members of the Judiciary Committee. My name is Dieter Tejada, and I'm here today to testify in support of 3 bills, 952, 1233, and 1070. I'm here primarily in support of 1233 in my capacity as a board member of WWAMI. I urge you strongly to vote in support of all 3 of these bills. And I know I'm mentioning 3 bills, but they're all connected. I can tell you that they're connected because the system's connected, and I know the system's connected because I've been through it. I went through it as a teenager. I was arrested along with 3 of my friends and wrongfully convicted. And then I went to law school, and I went to a very good law school, and I did very well. And I can tell you this much, going through this system and seeing the way it was all connected, I knew a lot more, and I will always know a lot more than all of my law school classmates. And I can tell you one thing, prosecutorial accountability is necessary. It was necessary in my case that could have prevented me and 3 of my friends from being put in prison, which hurt all of us. And it hurt our families. That's why I'm in favor of the primary caretaker bill. I wasn't a parent when I went in. I was a son, and I went through a lot of trauma inside and going through the process with the courts, like incredible trauma. Like you can hear all the like victim stories you want. Like trust me, I've gone through it. Physical, all types of stuff. And the hardest part for me was what my family had to go through, what my parents had to go through. I cried twice inside. I cried when I was sentenced. That was out of frustration. And I cried when I got a letter from my parents that I saw their tears on it. I can just tell you this much, it's affected us to this day. Everything's been harder for me. I worked my ass off when I got out, and I have done okay. But it's been hard on all of us. And for families to get torn apart, we're talking about more than half of people in prison are parents. And Senator Kissel, you said that like you're asking a general question about how do we stop crime, and you said that one of the issues is right that we have a lot of children without fathers and without parents involved. Well, maybe it's because they're going to prison. So if we could do something just to create the option. I know I'm about to run out of time probably, so I'll just say this. Both these two things are just options. Parole is an option. Not everybody will get it. And the primary caretaker alternatives are just an option. They can be smart. Also, they don't cost any money. Somebody was talking about $4 million not being a lot. All these things will save you money.
Thank you. Questions or comments from the committee? Seeing none, appreciate you being with us. Lauren Ruth.
Good afternoon, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and distinguished members of the Judiciary Committee. My name is Sana Shah, and I'm testifying today instead of Lauren Ruth on behalf of Connecticut Voices for Children.
Ma'am, I'm sorry, we can't allow substitutions. I apologize about that, but because of our rules, we're not allowed to do that. You're certainly welcome to submit written testimony. Next, we'll hear from Ileana Pujols. Ileana Pujols. Christopher Dukes.
Good afternoon, folks. It's good to see you all in person. You're used to seeing me on screen or standing out in front of the Capitol waving my billboards of evidence. My name is Christopher Dukes. I'm glad to be here. I'm sad to be here on the occasion of still representing the Justice for Dukes Coalition, something I hope we had put to bed years ago. I submitted written testimony because 3 minutes is never enough time. However, I wanted to strongly support Senate Bill number 5. And specifically Section 7 refers to the funding and sources that are going to go towards children of domestic violence. Why this is so important to me is that I was blessed to be a father of 2 children. And I want to tell you about my 2 children. On April 25th of 2018, in the early morning hours, my children were awakened by a SWAT team in their bedrooms. And why was there a SWAT team in their bedroom? Is because unbeknownst to them, their mother had made a fake 911 call alleging that she was being killed, being bound with duct tape, all sorts of things, okay? Those children on that day were separated from their father. They lost their father for 10 months, absolutely no contact whatsoever. Those children, as of today, some 1,793 days, I believe, if you ask Siri, those children are still separated from their father. Those children did not deserve that. Those children have been in supervised visitations for the last 4 years. Luckily for all of us is that I was able to prove my innocence. And I heard Pat Griffin talking this morning about accountability. Accountability is on paper. However, in practice, it's not true whatsoever. The prosecutor who maliciously prosecuted me when she learned that she had made a mistake, deeming the female being the victim versus the male. I understand I don't fit the narrative, but you need to know this narrative is true, which is why I submitted to you in my written testimony the DNA evidence, the 2 sets of DNA evidence that confirmed that it was the mother who fabricated the duct tape evidence that was used and almost wrongfully convicted me. So the reason why, again, I'm still here is that our system is broken. As Mr. Tejada said a little while ago, our system is broken. It stems from the local police departments all the way through family court and so forth. Unfortunately, as a victim of domestic violence, no one wants to listen to me. So I appreciate the fact that you're listening right now. I've only had to seek retribution through civil litigation. The family court is being exposed right now at the appellate court. My employer who wrongfully terminated me are being exposed right now at the state Supreme Court. The accountability for prosecutors is necessary. I appreciate what's been put forward, and I look forward to, I hope that my testimony today spikes your interest to at least ask questions, and let's follow up. Thank you very much for your time.
Thank you. Comment or question for members of the committee? Comment or question? Seeing none, I want to thank you for joining us again. And people do hear you because you will not let them not.
I will not let this rest. Thank you very much. I hopefully I'm not here next year saying it's day 2000. All right, let's put this to bed, please.
All
Thank
right.
you.
Nicholas Budo.
Hi, good afternoon.
Good afternoon.
Good afternoon, distinguished members of the Judiciary Committee. Thanks so much for the opportunity to speak with you this afternoon. I'll be very brief. My name is Nicholas Budo. I'm a lawyer currently in private practice, but have worked with a number of survivors of domestic violence over the past decade, and have been working with violent crime survivors who you heard from earlier today. And I'm testifying in support of the addition of domestic violence and intimate partner murder to Senate Bill 5. I'd just like to briefly touch on a few key impacts I think this portion of the bill would have, both from a legal and public policy perspective. First, this provision aligns with the core principles of the criminal justice system. I'm personally and politically opposed to overburdening prisons or attaching harsher penalties to crimes than may be warranted. But I also believe in the foundations of the criminal justice system, one of the most critical of which is that within that system, the most serious or violent crimes warrant the most substantial sentences. In other words, whether you're a believer in deterrence, retribution, or any number of theories of criminal justice, the punishment should fit the crime. Second, this provision would allow Connecticut to keep pace with the prevailing wisdom we're seeing across the country. In the past decade, we've seen a huge uptick in the number of states that have introduced domestic violence as an aggravating factor in their murder statutes. And these changes are meant to acknowledge a greater culpability for some crimes than others. And I think we would be hard pressed to find someone who believes that sustained domestic abusers who commit numerous acts of abuse over long periods of time and who end up killing their partners are not more culpable than the average individual who, in a single isolated or impulsive incident, kills a victim. And third, and perhaps most importantly, this provision would send a message to domestic violence survivors and the families of victims that they matter. Intimate partner violence has historically been one of the lowest reported crimes. It's a crime that takes place behind closed doors, but it has effects that pervade all corners of our society. Giving prosecutors another tool in their toolbox, which they can use to say to juries, to say to victims, to say to perpetrators, and to say to communities as a whole that there's no free pass for domestic and intimate partner abusers simply because we have historically not been willing to open that door and hold them accountable, would be a significant step toward creating a society that is committed to openly acknowledging and to fighting against the pervasiveness of domestic violence. And that's all I have. Thank you.
Thank you. Comment or question for members of the committee? Comments or question for members of the committee? Seeing none, thank you very much for joining us. Kirk Lowry. Kirk Lowry. Anthony Small. Good afternoon.
Good afternoon, Senator Winfield, Senator Kissel, the rest of the committee members. I guess I'm the guy you want to hear from because I'm the one who had the life without parole sentence. And since Monday, I've been hearing about life without parole. I'm in support of Senate Bill 952, youthful offenders. I was given life without parole in 1995. I categorize myself, as Ms. Fear said, as someone they threw the book at. I was charged with capital felony murder, 2 counts of felony murder, conspiracy, kidnapping. At trial, I was found not guilty of the kidnapping. I went to jail. I was 30 years old. My crime happened in 1990. I was convicted in 1995. Selfishly, I mentored a lot of youthful offenders at first because they were ruining my visits. They were locking down the block so I couldn't go hug my kids, my family members. So I had to artfully figure out a way on how to stop them from locking down the jail in the unit I was in. I noticed they called me OG and I was only 30 years old. I didn't like that. But years later, after a quarter of a century of time, I was in jail for 28 years and 7 months. When the scientific studies came out and it said that the mental state doesn't fully develop until 25, I started thinking back to how these youthful young men were acting. And we used to tell them, yo, you're a grown man, stop acting like that. And they never listened. But once they got to be around 26 and they was in jail for maybe 8 years, 7 years, a lot of the intelligence that they had matured. My peer groups are the guys that came before you. You wouldn't be in my circle unless you was rehabilitating yourself. Millions of dollars are spent on rehabilitation. The punishment is given, the deterrent is given. So now, once you work on your civility, there's a lot of individuals who didn't have mitigation hearings. I had one. I was given an immediate release in less than 24 hours after having a modification hearing by Judge Richards. Since I've been out, I spoke at the Career Resources press conference with Senator Blumenthal, Congressman Haley, Mayor Joseph Ganim was, where they gave the money to Career Resources. I've also lectured at several colleges. I will continue doing that, and I haven't charged anybody anything. I believe it's my civic duty. I want to say that there are a lot of youthful offenders who they really have worked on their civility and they don't have a chance because they were not 18. I recently watched a news clip where a victim said that they studied and they seen the scientific studies of the mind developing by the time you're 25. I'm a victim of crime also. My son was murdered coming out of a club. That didn't stop me from rehabilitating myself, and that didn't stop me from trying to help the city of Bridgeport I once destroyed in the state of Connecticut.
Thank you, Mr. Small. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none, thank you for spending your day with us, and thank you for talking to me in the hallway.
Thank you.
Next, we have Jonathan Roach. Jonathan Roach. Andrew Kingman.
Hi, good evening, Mr. Chair, Mr. Co-Chair. Can folks hear me okay?
We hear you loud and clear.
Okay, fantastic. My name is Andrew Kingman. I represent the State Privacy and Security Coalition. I'm also a member of the Connecticut Privacy Task Force, and I have a background as a compliance attorney helping clients navigate state privacy laws. We're here today in opposition to SB 3, but with a willingness to continue working on these important issues. And we oppose SB 3 for 3 reasons. The first being that Connecticut has a comprehensive privacy law that encompasses nearly all of the privacy controls and personal data that the children's section and reproductive health sections of this bill attempt to capture. This law, as you all are aware, was the product of 4 years of work demands tens of millions of dollars in compliance costs from both in-state and out-of-state businesses, and is not even in effect yet. Connecticut should allow this law to be operational before seeking to add additional compliance requirements. Continuously making changes to Connecticut's law threatens to move it from its rightful place as a national model to a statutes like California's, which has not been replicated in any other state, in large part because it continues to be a moving target. With regard to the reproductive health care section, of course, we believe this issue is incredibly important, but the bill is patterned after an unfinished product in Washington state, which critically lacks the same comprehensive framework Connecticut has. In that state, there are no heightened protections for health data, geolocation data, and biometric data, no right for consumers to delete, access, or correct their information, and the definitions in the bill are so broad that they would undermine the central framework of the Connecticut Comprehensive Privacy Law. And with regard to the children's section, we appreciate that this section attempts to crosswalk this to the comprehensive law, but there is much more discussion needed on this subject. The first issue is the definition of child, which is defined as a consumer under the age of 18 years. And the fundamental premise of the United Kingdom's guidance here is that individuals have different needs at different developmental stages. But the legislation before the committee today and that California enacted requires businesses to treat a 4-year-old the same as a 16-year-old. And additionally, the willful disregard standard of knowledge for any minors visiting a website or project brings into scope nearly every internet website and app available. Because of the way this bill is drafted, businesses will need to start verifying ages of all individuals online, which will result in a substantial increase in the amount of personal information businesses will need to collect on individuals in order to be in compliance with the law. I should say that this is not something that is just a concern of the business community. There are many civil society groups that have expressed concerns about federal bills with the same implications, as well as California's bill. Thank you for your time. Happy to answer any questions.
Thank you. Comment or question from members of the committee? Comment or question from members of the, can I ask you a question?
Yeah, of course.
But I didn't have my pen out quick enough, so I don't remember. At the beginning, you said you opposed this with some suggestions, or did you oppose this with a willingness to do? I missed. Can you run that back for me?
Yeah, just that you know, again, I'm a member of the Connecticut Privacy Task Force. Worked with Senator Maroney in this legislature for years on the privacy issue. So certainly willing to continue working with the sponsor. We oppose the bill as it is right now.
Oh, okay. Thank you. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us today.
Thank you.
Rafi Podolsky.
Thank you very much. My name is Raphael Podolsky. I'm an attorney with Connecticut Legal Services, and I'm testifying on behalf of the legal aid programs. I'm here to speak in opposition to Senate Bill 1041, which is a bill on small claims jurisdiction. And I have to say, it feels like I'm a little out of place at this hearing because it's kind of in its own world for being a different theme for the hearing, but it's on the agenda. I also want to apologize for testifying today remotely rather than in person. I really would much rather be in the building with you, but it didn't work out for today. This bill proposes to raise small claims court jurisdiction by 50%, from $5,000 to $7,500. Notwithstanding the existence of inflation, which we obviously recognize, we believe it is preferable to retain the existing $5,000 small claims maximum. We therefore oppose the bill. There's several reasons for this. First, it appears that relatively few claims are at the $5,000 maximum. From preliminary review of judicial branch data, it seems to be under 4%. That also shows that approximately 83% of claims are for less than $3,500, which is not even close to the maximum. So it's not clear there's any need for the bill. Second, the informal procedure of small claims court is intended for claims that are really small. For example, small claims decisions are made by magistrates. They're not made by judges. There's no right to appeal a small claims decision. It is what it is, and you're stuck with it. As the jurisdictional maximum is increased, the purpose of the court becomes distorted by the capacity to go to larger claims. An amount as high as $7,500 is simply not a small claim. Increasing the maximum jurisdiction simply moves the court away from being a small claims court. Third, the maximum has already gone up substantially faster than inflation. For this, you have to have some history and look back at what this court used to be if you go back far enough. In 1981, the small claims maximum was raised to $1,000. That was a quadrupling of the pre-1971 maximum of $250. Since that $1,000 was set in October of 1981, the consumer price index, by my calculation, has risen by more than 200%. The number I had was 221%. The small claims maximum, however, has risen to $5,000 from $1,000. So that's a 400% increase. It's a quintupling, much, much higher than the increase in inflation. It's almost like we've already worked ourselves ahead of the game. And last, the small claims courts were once seen as places where individuals could initiate lawsuits to resolve small disputes with business and other individuals. This is really not what the small claims court is today. It's become primarily a creditors collection court. And the main
time has elapsed.
Oh, I'm sorry. Oh, excuse me. So the nature of the court has changed, and that's not entirely independent from the increases in the jurisdiction. So we urge the committee to leave the present maximum in place. I'm happy to answer any questions I can, and thank you.
Comment or question from members of the committee? Comment or question from members of the committee? Representative Osborne.
Thank you, Mr. Chair. Good afternoon, Mr. Podolsky. Do you recall, isn't it 1978 when the small claims limit was set at $5,000?
No, it was set at $5,000 in 2005.
2005. Do you know what that would be with inflation today?
Well, with inflation, and there has been roughly a 50% inflation since 2005. So I don't think this is out of, if you're going to start with 2005, then I don't think this increase is out of line in that sense. If you look, but getting to the 2005 was way ahead of inflation. So I would agree that you get a different result. If the farther back you look, the more the result becomes different, because the court has moved away from the legislature has moved the increase away from the rate of inflation. But if you look back to 2005, I think that's I do think that it's not necessarily out of line with that time period.
Wouldn't you agree that the average person who has maybe a claim for $6,500 or $7,000 or $7,500 against the guy who didn't finish their deck or a small contract matter, that's not something that's worth pursuing? You can't hire an attorney for that amount and take the whole thing to Superior Court. Wouldn't it be far preferable for the average person to be able to pursue, instead of they hand over $6,500 and they have no recourse essentially if they don't get the product that they were promised or the service they were promised?
There's actually an exception in the statute for home improvement contracts that's fairly recent. Maybe from 2 or 3 years ago, where I believe you can go up to $15,000. I think that has some of the same problems, that because it means you're dealing with cases with no rights of appeal and no real formal structure. But that, I would say, is already in place. So to the extent that is what you would see as the issue, then I don't think this bill is necessary for that at all.
So it doesn't have to be necessarily a home contractor, but doesn't the average person isn't it cost prohibitive for the average person to retain counsel to pursue a claim in Superior Court? And isn't $7,500 just not that much money in today's dollars as compared to 2005?
Well, I think it's important to note that those are really atypical cases. If you look at this, what's going on in small claims court, when I said it's to a large extent a collection court, what that really means is that the people who are consumers are a very, very high percentage of them are defendants. They're not plaintiffs. So the plaintiff case, which is what you're describing what actually is the classic small claims case, a person suing a business over a consumer complaint. That's pretty unusual in small claims courts if you look at the total number of cases.
But wouldn't that be because
the consumers are almost always the defendants?
I'm gonna remind both of you that in order for everybody to follow, one person has to talk and then the other.
I'm sorry.
I don't
And
know
I can
what's going
continue
on.
this conversation, given the large number of people that still have to testify. And Mr. Podolsky and I can certainly continue this conversation elsewhere. But
would be
thank you
great.
very much. I appreciate your testimony today. It's good to see you. And we'll keep at it. Thanks so much.
I'm sure. Thank you very much.
Good to see you.
Representative Doucette.
Thank you, Mr. Chair. Thank you, Rafi. I must admit that I was a little surprised, and my thought process is similar to Rep. Osborne. I thought perhaps that you would support this in favor of giving people access to the courthouse. But then your last point, I think, is probably an important one. Do you believe that opening this up, it just simply invites more creditors and debt collectors claims? Is that the basis of your opposition today?
I would say more and higher. I mean, it is true that I think from a creditor's debt buyer's perspective, that they may well choose to sue for $5,000 in small claims court rather than $6,000, say, in the regular docket. And I think what you'll see is you will be picking up creditor claims and more of them in that larger range. I mean, I guess you can't be certain of that, but I guess I would predict that's what would happen.
Yeah, you may very well be right. I'm not sure how many claims there are on regular docket between 5,000 and 7,500. Curious to know that, but no, just wanted to ask that. Thank you, Rafi. Thank you, Mr. Chair.
Thank you, Representative. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none. Thank you very much for joining us again.
Thank you very much.
I'll just remind members that there are still at least 30 people who are signed up to go. Carlos Rebolo. Carlos Rebolo.
Yes, I am here.
All right, you may testify.
My name is Carlos Rebolo. I stand here today to provide testimony against SB 952. To begin, I was 15 years old when I heinously attacked an innocent person, was charged as an adult for attempted murder, and sentenced to 45 years in prison. In 2015, proponents of PA 1584 decided that those under the age of 18 were the only ones that deserved consideration for parole, granting children a category apart from adults that has long been denied to them, while still allowing them to be charged as adults and sentenced as such. They now want to propose raising the age to 25 years old. What is the difference between that and a 26-year-old? We could continue ad infinitum, but at its root, the thing that has brought us into such a proposal are the kinds of punishments that are being imposed. And in my experience, the very children that should have the most consideration receive less when they are placed in comparison on an age scale due to brain science, leading the identity of children to be used as bargaining chips to extend consideration to older adults. If laws were consistent and punishment were graduated, commensurate and proportionate, the issue of age would have no similar bearing on age differences as it does today. Legislatures should not be able to leverage their inconsistent practices by repackaging children under brain science that extends beyond the identity of children, just to include others who are not children. And yet it does. I will not be a part of such recklessness. SB 952 will cut branches off a rotten tree. It will only deal with back end of consequences that stem from a cause nobody is willing to do away with. Children, juveniles deserve a category unto themselves to forbid the kind of punishment that this state continually uses to blur the lines between our children and adults. This has to stop. Thank you.
Thank you, Mr. Rebolo. Comment, question from members of the committee. Comment or question from members of the committee. Seeing none, thank you very much for joining us. Have a good evening. Robert Devlin.
Good afternoon, distinguished members of the Judiciary Committee. My name is Robert Devlin Jr. I'm the Inspector General for the state of Connecticut, and I'm here to speak in favor of Section 8 of House Bill 6917. As Inspector General, one of my jobs is to release publicly body-worn camera recordings and dashboard camera recordings from instances of officer-involved shootings in Connecticut. And I've been doing that since October of 2021. when I was appointed to this position. The statute that governs these disclosures is somewhat complicated, but basically, in my experience, it comes down to about 96 hours. 96 hours from the date of the event, I'm required to disclose publicly these recordings. And in the cases that I've done so far, I've written 9 reports. We have 8 cases under active investigation in our office. I've written 1 report on an in-custody death and police custody death. And in all but one of those cases, it was very easy for me to comply with that 96-hour rule. In fact, usually far before that, I was able to disclose the relevant recordings. But in one case, I had a problem. And that one case was an extremely serious case. It's that terrible case out of Bristol where these 2 police officers were murdered in the line of duty. So a black day on our calendar. And the officer that stopped that rampage was himself shot and received a serious injury himself and was hospitalized. Now that incident happened on late Wednesday evening. The 96 hours was set to expire late Sunday evening. And the officer came into the police department on Sunday afternoon and reviewed that material, and it was able to be disclosed Sunday evening. But we could have used more time. I mean, we could have really used more time to allow him to take a measured and recover more, take a more measured review of this material. So what I'm asking in this bill is if it's unreasonable because of an officer's medical, physical, or acute psychological distress arising out of the incident, if they can't reasonably review this material, we get an extra 48 hours. The deadline date extends from 96 hours out to 144 hours. I don't think this will be used very much at all, but where it's needed, I mean, it's needed. And so this is not a hypothetical thing I'm putting forward here. It's based on my experience. I think it would improve. I mean, a bedrock principle in this Police Accountability Act is giving officers an opportunity to review this material before it's made public. That's a good public policy, I believe. And so this will facilitate that and improve that. So thank you very much for your attention, and I ask your support in this bill.
Thank you. Comment or question from members of the committee? Comment or question? I have a question. How are we to determine the medical response or physical response or the stress that might prevent the officer from functioning?
Well, you're going to have to, I guess the simple answer is you're going to have to rely on the good judgment of the Inspector General. That's how that would be effectuated. Some reasonable approach to in the case I talked about, there was actual, medical records that demonstrated the degree of the person's injury. And that I think one factor that could be relevant in these situations. We're talking about situations where you can't have an exchange of gunfire between a police officer and subject. And that's really, injuries are certainly foreseeable. But to be perfectly straight, I think it'd be the judgment of the Inspector General whether this is a situation that went into that, special category to get some extra time.
But as you suggest, the exchange of gunfire is a stressful situation. So how could it not potentially open it up for any of those circumstances?
Well, I think you're right, but each case is unique. Officers oftentimes are not reluctant. They are remarkably resilient in these situations, and they're able to review this material in short order, and I'm able to disclose it in short order. So that's in practice, I haven't had any problems except for that one case.
The law doesn't allow for anything other than what we currently do, though.
Correct. Right now, 96 hours, I'm required to disclose information publicly. Exactly.
Thank you. Comment or question from other members of the committee? Comment or question from other members? Thank you.
Thank you.
Good to see you again.
Good to see you, Senator.
Julie Nash.
Good afternoon, co-chairs Senator Winfield and Representative Staffstrom, vice chairs, ranking members, and distinguished members of the Judiciary Committee. My name is Julie Nash, and I'm speaking to express my support for Senate Bill 5, which proposes important changes to protect victims of domestic violence and crime in Connecticut. The tragic story of Julie Minogue brings me here. A mother, like many of us, who was brutally killed by her ex-boyfriend, highlights the urgent need for electronic monitoring in cases of domestic violence. In this case, Julie had previously filed for a restraining order against her ex-partner and had expressed fear that he would harm her. Despite this, he was able to enter her home and commit the violent act that ultimately took her life. Julie did everything right, and the system let her down. Electronic monitoring, such as GPS tracking and ankle bracelets, could have been used in this case to monitor the offender's movements and ensure that he did not violate the restraining order. This could have alerted authorities if he had approached Julie's home, giving her a chance to seek help and protect herself and her children. Moreover, electronic monitoring can serve as a deterrent for abusers, as they know that their movements are being tracked and they will be held accountable for any violations of restraining orders. Section 1 of Senate Bill 5 proposes to establish a new program within each judicial district for the purpose of using electronic monitoring. This program would be used to warn law enforcement agencies, a statewide information collection center, and the victim when a person charged of the violation of a restraining order or a protective order and who has been determined to be a high-risk offender by the Family Violence Intervention Unit is within a specified distance of the victim. This change is necessary to protect victims of domestic violence from their abusers and is an important step towards ensuring their safety. I urge you to dig into the many layers of this issue. This is the first step of many we need to enact. Bail reform, local law enforcement and prosecutorial procedures and discretion need to be scrutinized and rehauled. Before I conclude, I want to make a special mention and thank you to our Milford delegation, Senator Maroney, Representative Kennedy, Representative Smith, and Representative Ferraro for their support on this issue. I'd also like to thank Megan Scanlon and her team at CCADV for their work and assistance to the victims. And lastly, I want to thank you to Julie's family, Julie Minogue's family, for participating in this process to bravely fight in Julie's name. In conclusion, I strongly urge you to support Senate Bill 5 as a first step in many. These proposed changes will help protect victims of domestic violence, making our state a safer place for all. Thank you for your consideration.
Thank you. How many questions from members of the committee? Comment or question from members of the committee? Seeing none, thank you very much for joining us this afternoon.
Thank you.
Tracy Bernardi, welcome back.
Hello, all of the distinguished members of the Judiciary Committee. My name is Tracy Bernardi Guzman. I'm a resident of Waterbury and an ACLU Smart Justice Leader. I am testifying today in support of SB 952 regarding parole eligibility for people convicted under the age of 25. I believe that SB 952 is the right bill to give people who are incarcerated for such long periods of time an opportunity for a second chance. I entered prison in 1993 when I was just 19 years old and was not released until right before my 42nd birthday in 2015. I served 23 years in prison. Today, just 7 years later, I'm a reentry case manager, a college student, a soon-to-be homeowner, and most importantly, a wife and a stepmother to 5 children. I, like many others, grew up in a dysfunctional, traumatic household. As a result, I sought love and acceptance in a gang, and I could not differentiate between what was familiar and what was abuse. I was sentenced to 30 years in prison with no hope of parole. And because I saw no light at the end of the tunnel, I attempted suicide multiple times. Eventually, I got to a place where I wanted to live and my self-esteem increased. I was able to grow in prison to the person I am today. And I'm still growing. As human beings, we're constantly evolving. I'm certainly not the teenage girl I was 3 decades ago. Sentencing someone to more than 10 years without the opportunity for a second look suggests that change is not possible. I know from firsthand experience that change is extremely possible with the right supports. A person who made a mistake can grow up to be an asset to their community like I am today. Connecticut has already recognized that people under the age of 18 are less culpable for their choices, but there is further to go. We know that psychologists and neurologists have concluded that the adolescent's brain, specifically the decision-making realm of the brain, is underdeveloped until at least the age of 26. Adolescents are impulsive, make poor decisions, especially in times of stress or in the presence of other adolescents. I want to take note that nothing proposed in this bill would guarantee a person's release. What the bill does do is ensure that young people get a chance once they have had the opportunity to change and become better. As a society, we will do better if we move towards redemption and forgiveness and invest in people, not prisons. I urge the members of the Judiciary Committee to support SB 952. Thank you for listening to my testimony, and I'd be happy to answer any questions you may have.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? Seeing that, Tracy, thank you for joining us again.
You're welcome. Thank you.
Mike Murley.
Private. Oh, this year? Or is that? This is already, okay, yeah, sorry. Good evening, members of the Judiciary Committee. My name is Michael Murley, and I'm a resident of Milford. I was born and raised there, and I also lived in Bridgeport for several years, and I'm still very involved in that community. I'm here in support of SB 952. I am speaking today as an organizer with Abolition UMA, a grassroots organization building community power with incarcerated Muslims in Connecticut. And I'm also here today as a paralegal for attorney Alex Taubes. To say these have been transformative experiences doesn't even come close. My life has changed forever. I didn't know anyone who was incarcerated until I was in my late 20s. Now I cannot forget about all the things I've heard and read about what goes on behind those walls. Through the organizing and legal work I'm engaged in, I now know many people that are currently and formerly incarcerated in prisons and halfway houses here in Connecticut. These men are my brothers. We have built deep and profound friendships over time. There's someone I got to know really well through letters and eventually phone calls. We became friends over time, and he really opened up to me about his journey and about some of the horrible things he suffered in his life, beginning at a very young age. He was released from prison to a halfway house in Bridgeport last year. During his time there, he worked at CCAR and was excited to begin the next chapter, to dedicate his life to helping others. I'm holding in my hand the letter of recommendation that I wrote for him when he applied for a recovery coach position at Liberation Programs in Stamford. The day after I wrote and faxed this letter, my friend was released from the halfway house. That day was his 52nd birthday. As soon as I got the call that he was out, I met him and his sister at a diner where they were eating a celebratory lunch. He was so happy. 11 days later, he died. I remember praying Friday prayer with him at the Bridgeport Islamic Community Center. I remember the good morning, my beloved brother text messages I came to expect every single day once he had his own cell phone in the halfway house, and that I woke up for days after he passed expecting and hoping to find waiting for me. It breaks my heart over and over when I think of my friend and how he isn't here right now to experience the first night of Ramadan in about 2 hours. I'm here to remember my friend. His name was jihad, which is an Arabic term that means to struggle and to work hard to improve oneself. I think about the 4 addiction service programs he completed along with Voices. I think about the parenting class he was in and all the progress he made in therapy. Jihad had transformed himself, and he was focused on helping other people transform themselves. He was so excited to become a recovery coach. If you believe that recovery is real, which I do, if you believe that alcohol and drug addictions can be overcome, which I do, then by definition, you believe in second chances. And that means that you believe not only that people can change, but that they deserve the opportunity to change. Jihad believed in second chances. I believe that SB 952 represents an opportunity that so many people in prison here in Connecticut right now deserve, a second chance. It's too late for Jihad now to make new memories with his children and his grandchildren. It's too late for me and him to continue to grow our friendship. But it's not too late for so many people incarcerated right now who deserve a second chance. Thank you.
Thank you, Mr. Burley. Comment or question from members of the committee? Senator Kissel.
Thank you. I just want to express my sympathy on the loss of your friend, and I just wonder how he passed.
If it's okay, I'd rather not go into that. And thank you for your sympathy.
Absolutely, but you do have my sympathy.
Comment or question from other members of the committee? Comment or question from other members of the committee? If not, Mr. Murley, thank you very much for spending your day with us and testifying.
Thank you for your time.
Misan Osarabaje, I'm gonna.
Hello. That's okay.
Sorry.
Hi, my name is Misana Sarabaje. I'm a student at Yale University with the Yale Undergraduate Legal Aid Association. I'm currently working with Women Against Mass Incarceration to support SB 1223. This bill acts to provide an alternative to incarceration for primary caretakers. And as somebody who has had a primary caretaker, my mother, be in and out of my life, it definitely creates a lot of anxiety and fear, and it transfers responsibility. I have a younger brother, from the parent to the child, to take care of other children at a very young age, often at which they're not ready for. And I really believe that all children should have the opportunity and the chance to grow up in a safe and stable environment. And I also believe that Connecticut is a second chance state. And this bill is smart in that it also reduces recidivism. Like I said, it allows dependents to grow up in a safe household. It's also cost effective. It costs less to keep people out of jail than it does in jail. I've also seen the negative effects on my mother, as she also has a very hard time getting employment now as somebody who has gone through the carceral system. So this bill really supports keeping communities together and giving people the chance to do better at life, which is something that I believe that Connecticut and the legal system does believe in. It also tackles the racial issues and the nature of mass incarceration. As you can see, I'm a Black woman, and the majority of the prison population, both male and female, are people of color and Black people. And I'd really like to reduce the ongoing effects of racism within the criminal legal system through implementing things like the primary caretakers, alternatives to sentencing, to get people into a space where they can grow and they can support those around them just as they should. So thank you to the Judiciary Committee, and thank you to Senator Winfield for also sponsoring this bill.
Thank you. And I think it's Osaragbaje, so I'm sorry for butchering it in the beginning.
No, that's fine.
Are there comments or questions from members of the committee? Comments or questions from members of the committee? It's important to me to get everybody's name right. Thank you for joining us today to testify and provide us with your perspective. Appreciate it. Jennifer Root Bannon.
Hi, I just want to thank the Judiciary Committee for your time and for everyone else who's here and been here all day. I am here because I'm in support of Bill 1062, an act concerning the provisions of emergency medical services to an individual who is in direct contact with or in the custody or control of a peace officer. I'm also in support of SB 952. Just wanted to say that. Again, my name is Jen, and I'm here to share the story of my brother, Justin Root. He was 41 years old and suffered from schizoid affective disorder. When he was having medication issues, he would have delusions and paranoia and mania. And on February 7th, 2020, my brother was steps from his Mass Mental Health Center, where he received treatment for the last 8 years of his life, which is right next to Brigham and Women's Hospital. Justin walked right up to a hospital security officer across from Mass Mental Health. He didn't threaten him. He didn't take out or touch the clear plastic 12-inch paintball gun with a 1-inch chimney that was tucked into his waist. This officer described my brother as nonsensical, paranoid, manic, and delusional, that something was seriously off with him, and that their interaction ended with my brother extending his hand out to him, and they shook hands. What transpired after this led to him crashing his car in Chestnut Hill. 2 wheels flew off, and he had lost 2,000 cc's of blood in his car, and he stumbled to the mulch area and dropped to the ground. A former EMT ran from the parking lot to help him. She was at his side. She described Justin's state, and the police arrived with their guns drawn, running, and they ordered her to leave his side. One officer went up and kicked him, and then from point blank range, 6 officers shot 31 bullets. Had a bill like number 1062 had been in place, my brother could very well be here today, because Justin was at a hospital and he needed to be hospitalized. And that security guard would have had a legal duty to have called EMS first before calling the police. And this outcome would have been very different. Justin was shot 31 times, and he was on the ground, incapacitated, with nothing in his hands, and he was unarmed. I believe that that was another instance where the police would have had a legal responsibility to get him medical aid. I just want to explain that people who have severe mental illness usually have agnosia, and they can't understand and perceive their illness. So this usually leaves people like my brother at the brink of danger before being able to legally intervene. So there's many interventions and there's many occurrences with law enforcement being called. And really what we're talking about here today is the fundamental human right that someone in a medical emergency deserves, at the minimum, a medical response from the onset.
Thank you. Ms. O'Bannon, your time is elapsed. I'm not sure.
Okay. All right. Well, I hope that you can support this bill and this will save lives.
Thank you.
Thank
Comment
you.
or question from members of the committee? Comment or question from members of the committee? If not, thank you for joining us today to offer your testimony, and sorry about the loss of your brother.
Thank you.
Christopher Marchese. Christopher Marchese. Alexander Thomas.
Thank you, Senator Winfield, Representative Porter, Senator Kissel, members of the Judiciary Committee. My name's Alexander Taubes. I am a civil rights attorney in New Haven, Connecticut. I have represented 43 people who've received sentence commutations over the past 2 years, as well as 36 people who've received sentence modifications from Superior Court judges. And 8 of those people who received that type of relief have come before you today to testify in favor. Oh, well, one was against, but most of them were in favor of Senate Bill 952. And I am here to testify in favor of Senate Bill 952 as well. In those 79 cases where I represented people who receive relief from the Board of Pardons and Paroles or from a Superior Court judge, the judges and the Board of Pardons and Paroles has taken more than 950 years of excessive incarceration off of these individuals' sentences. That's billions of dollars that's been saved from the state of Connecticut that would have otherwise been used to incarcerate in the big house reformed people, people who there is no longer any public purpose to incarcerate. At many of these hearings, victims have spoken out in favor of releasing these individuals. State's attorneys have spoken out in favor of releasing these individuals. And the Board of Pardons and Paroles has not been doing this in the dark. It seems to me like Senate Republicans might not be reading the newspaper, but it's been on the front page of the newspaper for over a year, the changes in policies regarding the Board of Pardons and Paroles. Our first person who received one was Michael Cox, been incarcerated for approximately 30 years from when he was approximately 20 years old, who receives dialysis 3 times a week, was putting an extreme strain on the Department of Correction. That was on the front page of the newspaper in Connecticut, across the state, in all of our major newspapers. It was also in the New York Times. That was in December of 2021. So we've had the commutation policy going. It's not been a surprise. It's not been a secret. Nothing has been done behind closed doors. In fact, I would argue that the Board of Pardons and Paroles has been more transparent, more deliberative, and has spent more wisdom and made better decisions than often this committee does, meeting behind closed doors where we don't have a chance to see some of the decisions that they make. I think that the Board of Pardons and Paroles has been doing an amazing job. And to say that releasing 70 people out of 9,000 people in prison is some kind of floodgates or problem is ridiculous. It's to say that we don't have reformed people in our prisons, which is to say that the corrections department isn't doing corrections. So I think that the focus of negativity on the Board of Pardons and Paroles has been completely misplaced. I think that the legacies of racism from the tough on crime era of the 90s and 2000s is what's being addressed finally by the Board of Pardons and Paroles, and I'm happy they're doing it. Please support 952 so we can continue that important work.
Thank you, Attorney Thomas. Comment or question from members of the committee? Comment or question? If not, thank you for joining us today.
Thank
you for hanging out with us for a very long time. And thank you for the work that you do. Norman Gaines. Norman Gaines. Alex Spiropoulos?
Hi, I'm here. Good afternoon, distinguished members of the Joint Committee on Judiciary. Thank you for the opportunity to testify today. My name is Alex Spiropoulos, and I'm here on behalf of the Computer and Communications Industry Association to testify on SB 3, specifically sections 1 through 8. CCIA is an international not-for-profit trade association representing a broad cross-section of communications and technology firms. CCIA strongly supports the protection of consumer data and understands that Connecticut residents are rightfully concerned about the proper safeguarding of their data, particularly when it comes to health information and children's data. However, as currently written, SB 3 includes several provisions that raise concerns, which I will highlight here and have expanded on in the written comments I have submitted to the committee. CCIA suggests amending definitions included in Section 1 in order to provide clarity on the scope of the section and avoid conflicts with existing privacy laws previously enacted. As currently drafted, Section 1 includes broad definitions that could capture health data generated by everyday consumer activities, as well as prohibit consumers from utilizing location data to get directions after leaving a healthcare facility. Furthermore, the addition of the term personal information, which was not included in the comprehensive privacy bill previously passed, is problematic as companies are already spending resources to comply with that act. CCI recommends allowing for geofencing, provided consumers opt in for the use of such technology. The current language ignores scenarios where some consumers may want to opt into the use of such technology. For example, a system that allows a patient to virtually check in for a doctor's appointment that becomes available to them when they arrive at a healthcare facility, enabling to wait outside the facility or in their vehicle until a provider is able to see them. Furthermore, CCIA urges lawmakers to avoid unintended pitfalls which could put more children's data at risk. Well-intended efforts to bolster children's online experience would actually likely require the harvesting of additional data on all internet users, including children, in order to comply with new statutes. This could include the collection of location and biometric data in order to facilitate age verifications, information which many consumers may not feel comfortable providing. Additionally, restricting access to the internet for children also restricts their access to supportive communities that may not be accessible in their physical location. CCIA notes that different age groups operate differently online and therefore suggests that the legislation treat them accordingly. For example, a 16-year-old conducting research for a school project is expected to come across and learn from a wider array of materials than a 7-year-old on the internet playing video games. We suggest separating out children under the age of 13 who use the internet in a much different fashion from their older peers to help ensure that older teens can still benefit from the internet's resources, while also ensuring that additional protections are installed for younger users. Thank you again for the opportunity to testify today. I'm happy to answer any questions the committee may have.
Thank you. Comment or question from members of the committee? Comment or question? If not, Mr. Spiropoulos, sorry about the name. Thank you for joining us this afternoon. Thomas Burr.
Didn't want to play today. Good evening, Senator Winfield, Representative Staffstrom, members of the Judiciary Committee. My name is Thomas Burr. I'm the Public Policy Manager of the Connecticut chapter of the National Alliance on Mental Illness, otherwise known as NAMI Connecticut. I am testifying today in support of SB 926, an act concerning persons committed to the jurisdiction of the Psychiatric Security Review Board, otherwise known as the PSRB. As the country's largest grassroots mental health organization, we believe that diverting people with mental health conditions from involvement in the criminal justice system is smart public policy. NAMI fights for policies to get people help, not handcuffs. This includes expanding access to crisis services, promoting best practices in de-escalation and diversion of people experiencing psychiatric crises to treatment. We also know that continued confinement for people with mental health conditions that are no longer a danger to themselves or others is morally repugnant and a clear violation of their civil rights. Currently, people who are found not guilty of a crime by reason of mental disease or defect and committed to the PSRB are treated with less rights than people sentenced under the Department of Corrections. The PSRB can recommit people at the end of their original maximum commitment. This has led to many people facing lengthy commitments at Whiting Forensic Hospital with no end in sight. This current system discriminates against people with psychiatric disabilities and must be changed. A politically appointed board should not have the power to recommit people after their time is up. It should be noted that if indeed a person remains a danger to themselves or others, or is gravely disabled at the expiration of the maximum term of commitment, an application for civil commitment would be granted by a probate court. Therefore, there is no danger to the community at large by implementing this change in statute. So therefore, we echo the earlier testimony of Kathy Flaherty, the Executive Director of the Connecticut Legal Rights project and ask for passage of SB 926. And I should also note that the committee leadership should receive many emails from our membership echoing our support of this legislation. I'd also like to go on the record really quickly in support of SB 1062, an act concerning the provision of emergency medical services to an individual who is in direct contact with or in the custody or control of a peace officer. And I encourage the committee to pay particular attention to the testimony of Leonore Dooley, the Director of Medical Civil Rights Initiative. And lastly, for the record, we oppose SB 1231, an act concerning a defendant's competency to stand trial and early release into the community. And please refer to the written testimony of Kirk Lowry, the legal director from CLRP, on why we also oppose that bill. Thank you for your time and attention.
Thank you, Representative Stafford.
Thank you. And thank you, sir, for your testimony. I will just note, just because you brought it up, you know, while the committee does appreciate receiving testimony from folks on the bills before us, so the out of district emails are not effective. You know, when we get emails from constituents directly, that's helpful, but the out of district ones, we much prefer that those be submitted as formal testimony rather than just sort of the same email over and over to us, just for future reference.
No, I understand. I mean, I could
Thank
I
you,
could
sir.
pack the room here if you wanted me to, but then we'd be here till 2 a.m. So that, I figured that's the less of two evils, you know?
Thank you.
Written testimony.
Thank you. Comment or question for members of the committee? Comment or question for members of the committee? Seeing none, thank you very much for joining us this afternoon.
Thank you.
Karen Healy. Karen Healy. Kadeem Roberts.
Good evening, everyone. Chairs, Senator Winfield, Representative Stafford, and ranking members, Senator Kiskell and Representative Fishburne. Thank you for the opportunity to speak today. Speaking today on behalf of Senate Bill 952. Just a quick story. You guys have heard from a lot of people, so I won't be before you long. Growing up where I'm from, in low-income housing, what many call the projects, it was very much you were exposed to the good, the bad, and the ugly. But most importantly, I was blessed to have a praying mother and a praying father. Those of my counterparts weren't, able to have that. So they sought to either, one, defend themselves or be put in a situation where they had to choose themselves or choose their life. But most importantly, I just, want to tell my counterparts today, fully support this bill. I do believe people deserve a second chance at life, especially with lengthy sentences. We do also see the science, fully, as far as the brain fully developing, in regards to the age of 26. There are numerous people that I do know and numerous people that I work with within the reentry programs that have been in the system for, the time being. I do see, those that are in the system still to this day receive college credits, receive other opportunities in certain programs. But most importantly, from line 60 all the way down to 75, it explains, like overcoming substance abuse and addictions and traumas. So most importantly, I just do want to tell my counterparts and my colleagues today, fully support this bill because, I believe in second chance, and Connecticut is a second chance state as well. So thank you so much for the time. And thank you so much for allowing me to speak.
Thank you. Some of the questions from members of the committee. Comment or question from members of the committee? If not, Representative, thank you for joining us.
Thank you.
Maddie Abraham.
Good morning. My name is Maddie Abraham. I'm from New Haven, lifelong member. I'm formerly incarcerated. I was incarcerated for 20 years and 7 months. I was sentenced to 30 years at the age of 19. In 2021, I had a sentence modification hearing where I was able to present myself to the courts. When the victim's advocate spoke on behalf of the mother was opposed to my modification. Once she heard everything, she flagged the judge down and asked the judge, no, she didn't ask the judge, she told the judge, let him out of prison. He's been in there too long. He was young. I did not know what he was doing while he was in prison. who he is today, he'll be a benefit to the community. I wanted to start with that. Since I've been home, I had 2 friends murdered within 6 months. Another friend was just shot over 30-something times. If I was 18 years old, I don't know what my high probability would have been in response to that. It would have been, I probably would have been back, I would have been in jail, right? Today, when that happened and I got that news that my friends were murdered and another friend was shot over 30-something times, my core told me to go out to them streets and talk to them young men. Talk to them young men and let them know, listen, this is not what you want. Do not continue to do this cycle of violence. It's not going to benefit you. I was 18 years old when I went to prison. I wouldn't have made that decision at 18. I'm at 40. I know men incarcerated who has been in prison under the age of 25 that would have made the same decision I made this year, within this year, not to go and continue a cycle of violence, but to go hit them streets and talk to them young men and tell young men that, listen, this is not what you want. Save your life, save your mother's life, because incarceration killed my mother. My incarceration killed my mother. So I want y'all to understand that there's people inside prison that can help with this cycle of violence, and giving them that opportunity at the age of what SB 952 offers is the first step to getting people that can help our communities get a hold of what's going on in our communities. We don't need other folks coming in and tell us. We have it right here. If people could just look and see, we have these men who've been in prison for decades, that these young guys come into the prison system and look up to. I just wish y'all past 952 will understand that it's a real crisis out there and you got help.
Thank you. Comment or question from members of the committee? Comment or question, Representative Porter?
Thank you, Mr. Chair. First, I just want to offer my condolences to you on the loss of your friends. And I want to thank you. I want to thank you for being here today, for having the courage to have this conversation with us, and for bringing to light what I think has been shown throughout the day from various people who have been incarcerated for a lengthy time and have come home to be more than productive citizens as far as I'm concerned, because there's one thing to take care of yourself and to take care of your family and to fight to survive. But the fact that you are out there in those streets ministering to those young people and sharing your experience and why violence is not the way to go, it couldn't have been said no better than what you said today. So I just thank you for delivering it the way you did, because I'm out there. And what you said touched me. It struck me in a place I haven't been struck in a while. And I needed to share that with you. So you keep doing what you're doing. You keep showing up in them streets, because it's street cred. And they know you and they know what you've been through. Your lived experience is your power.
Thank you.
You have been redeemed. That's your power. Continue to use it, because the boys in the street, they need you. We need you. And I'm speaking as a mom who has felt that pain. So my condolences to you in the loss of your mom, because we do that time with you.
No.
But just know, she's looking down and she's so proud of you. I'm proud of you. Thank you, and God bless you. Thank you, Mr. Chair.
Thank you. Comment or question from other members of the committee? If not, thank you for joining us today. Thank you for your testimony. Thank you for the work you do in a almost feels like a prior life. I spent a little bit of time on those streets in our city, as some of you know, and tried to do some of that work. And I think that's some of the most important work that any of us are doing. So thank you for that work.
Appreciate it.
Macy Torres. Macy Torres. Richard Scarzo. Richard Scarzo. Daniel Lohr.
Chairman Winfield, Chairman Staffstrom, and members of the committee. My name is Daniel Lohr and I'm from New Haven. I'm testifying in support of SB 952. A lot of people today have talked about the consequences of passing SB 952, but I want to talk about the consequences of not passing SB 952. Put simply, if you vote against this bill, you will be endorsing the idea that some people should never be eligible for parole, even though they committed their crime before they turned 25. That is a really bad idea, and we should not endorse it. And here's why. At the time a person is sentenced, judges don't know who they will become. None of us do, and this is especially true for young people. They get to write their future, whether they are locked up or not. Parole allows us, as a statewide community, to take a second look at the sentence once we know who the person has become. We can use information that the judge simply didn't have. This information helps us recognize when we are needlessly keeping someone in prison, when we are needlessly keeping someone from supporting their family, and when we are needlessly wasting state resources to effectuate these harms. What I'm trying to say is that the parole process shines a light on the difficult decision of sentencing, a light that judges simply did not have. To vote against this bill is to leave our decision makers operating in the dark. It's to leave our judges with the impossible task of divining the future, a burden they don't want. The most important consequence, though, is this. If you vote against this bill, you are condemning people who committed their crimes as young adults to die in prison without ever having the opportunity to prove their redemption. I know some of these people personally, and this would be a horrific outcome. There has to be an opportunity for redemption. SB 952 provides that opportunity. Some of you already plan to vote for this bill, and I'm grateful for that. Others plan to vote against it. And to you, I make one sincere request. Before you vote, go meet one incarcerated person who will be affected. If my experience tells me anything, you will meet someone who did make a bad decision when they were young, but someone who has worked really hard in prison to make sense of their life, to atone for their mistakes, and to chart a new path. Someone with a clear vision for a peaceful and free life. To vote against this bill is to deny them even the opportunity to ask for that peaceful and free life. And I don't want you to make that mistake without first meeting them face to face. Thank you for the opportunity to testify.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? Representative Porter.
Thank you, Mr. Chair. And I just want to say thank you for your testimony and for your advocacy. You are appreciated. Thank you so much. Thank you, Mr. Chair.
Thank you.
Porter. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none. Mr. Lair, thank you for joining us this evening. Chloe Dysart.
Good evening, distinguished members of the Judiciary Committee. My name is Chloe Dysart, and I am testifying on behalf of the Center for Children's Advocacy, a nonprofit law firm that represents underserved children in Connecticut. Today, like many before me, I testify in support of Senate Bill 952. As part of my role as an intern through the University of Connecticut School of Law's clinic, I assist attorneys with cases involving people who are convicted for the crimes that they commit in their youth. Senate Bill 952 would expand eligibility for a parole hearing to those who have committed a crime under the age of 25. We urge the support of this bill for two reasons. First, Senate Bill 952 continues the progress that Connecticut made in Public Act 1584. In 2015, Connecticut passed Public Act 1584, a bill that allowed those who committed crime under 18 to be allowed parole eligibility hearing once they had completed a certain amount of their sentence. This decision was based off of our traditional notions of fairness and culpability, that those who do not fully understand the consequences of their actions should be treated differently under the law. This decision was also based off a series of cases such as Roper, Graham, and Miller, where the Supreme Court ruled that it was unconstitutional to sentence a youth to mandatory life without parole or the death penalty. Also based off the idea that youth experience impaired decision-making and are capable of rehabilitation. This bill would be a continuation of the progress that Connecticut has made in 1584. Second, we support this bill because it is based off of updated brain science. We know that individuals do not suddenly become mature at age 18. Research of brain development has shown that the prefrontal cortex, the part of the brain that controls rationality and decision-making, isn't fully developed until age 25. Those who are under 25 are more likely to be impulsive, more susceptible to peer pressure, and less able to understand risk and consequences. This bill simply allows the parole board to do what they are intended to do: make decisions about the progress an incarcerated person has made and if they are ready to re-enter society. While these individuals may be in need of rehabilitation and services, they also deserve the chance to prove that they are ready to resume their lives outside of a conviction. The center thanks you for your consideration in this critically important issue for those incarcerated for crimes committed in their youth. Thank you.
Thank you. Comment or question for members of the committee? Comment or question for members of the committee? If not, thank you very much for joining us this evening.
Thank you.
Thank you. Next, we have Jacqueline Wyman. Jacqueline Wyman. Jess Zaccagnino. Every time. I know. I know by now, but I mess it up every time.
Senator Winfield, Representative Staffstrom, Ranking Members Kissel and Fishbein, and distinguished members of the Judiciary Committee. My name is Jess Zaccagnino, and I'm the Policy Counsel for the American Civil Liberties Union of Connecticut. I'm here to testify in support of Senate Bill 1070, an act concerning prosecutorial accountability. The ACLU of Connecticut believes that mass incarceration is the liberation struggle that defines our era in United States history. We've come to a point where approximately 3 out of every 10 adults in the US has a criminal record of some kind, and over half of the people in this country have a close family member who has been incarcerated. Prosecutors hold people's lives in their hands. Their decisions impact a person's freedom, fundamental rights, and entire future. For a long time, prosecution was a black box, shielding prosecutors' decisions from security and insulating prosecutors. Following the passage of the nation-leading Public Act 19-59, prosecution in Connecticut is incrementally becoming more transparent. That transparency is shedding light on areas where prosecution perpetuates rather than ameliorates mass incarceration. The data gathered under Public Act 1959 demonstrates that prosecutors play a critical role in deciding who enters the criminal legal system and provides the perfect opportunity to apply that data to assess the 13 judicial districts' successes and growth areas as proposed in this legislation. But our state's attorneys are not answerable to the public and are rarely answerable to any oversight agency. Judicial districts can and do operate independently of one another, meaning that outcomes for victims of crimes and defendants can vary depending on people's zip codes. Senate Bill 1070 is designed to break down these systemic barriers. First, it requires the 13 states' attorneys to annually check in with the CJC. Each year, each state's attorney would be required to go before the CJC for testimony and comment on case-level data that's already being collected under Public Act 1959. During these check-ins, state's attorneys can explain the trends in their judicial districts. The CJC can highlight areas for improvement or changes if necessary. People living in the judicial district could weigh in on what's going wrong and right in local prosecution. Second, Senate Bill 1070 would shorten term lengths of state's attorneys from 8 to 5 years, which is more in line with national standards. Transparency and accountability for state's attorneys is a necessary step for ending mass incarceration, and Senate Bill 1070 lays out the map to get Connecticut there. If this bill is passed, Connecticut would once again demonstrate its leadership in this era-defining civil rights struggle. We support this bill and urge this committee to do the same. Thank you very much.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? If not, thank you for joining us again. And next time I'll try to get it right. John Tracci. John Tracci. Nancy Navarrete. Commissioner, before you begin, I just asked the same question I've asked everybody today who's come up with multiple people. Who's with you?
Yes. I have with me Dr. Michael Norco, who is the Demas Director of Forensics and a subject matter expert in this specialized area.
Okay, and he's not signed up to testify, correct?
Correct.
Uh,
He's only here to answer questions if you should have any.
So you'll get your chance to testify and we'll see what happens after that.
Okay. So good evening, Senator Winfield, Representative Staffstrom, from and members of the Judiciary Committee. I am Commissioner Nancy Navarrete of the Department of Mental Health and Addiction Services. Thank you for the opportunity to provide testimony related to SB 1231, an act concerning a defendant's competency to stand trial and early release into the community. So DEMIS is a healthcare agency that provides prevention, treatment, and recovery services to individuals with behavioral health conditions. The DEMIS Division of Forensic Services implements and coordinates specially skilled evaluation and treatment services for individuals with serious mental illness and/or substance use disorders who become involved with the criminal justice system. The division works closely with the courts and other components of the criminal justice system. DEMIS efforts are intended to promote recovery and prevent or mitigate criminal justice system involvement to the extent possible, to promote public safety and coordinate activities with other state agencies and private agencies. Services within the division span the continuum of the criminal justice system from pre-booking to end of sentence after incarceration and return to the community. The Division of Forensic Services provides clinical programming, specialized consultation and evaluation services, specific intervention programs to divert people from criminal justice system into treatment where possible, programs to help people reenter community living successfully after a period of incarceration, and training and consultation to the criminal justice system. The DEMIS Office of Forensic Evaluation employs 16 clinical social workers, 4 psychologists with specialized forensic training and expertise, as well as a group of 3 psychologists and 10 forensic psychiatrists on a per diem basis to evaluate defendants' competency to stand trial when ordered by the Superior Court under the provisions of Connecticut General Statutes 54-56D. These staff are organized in 4 offices around the state and complete approximately 600 evaluations a year. Approximately 10% of these evaluations are conducted by a psychiatrist alone, the others by a team, usually consisting of a social worker, psychiatrist, and a psychologist, who interview the defendant, review records, prepare a report, and testify in court. DEMIS has a number of concerns related to this bill. A sampling of these concerns follows. The DEMIS Office of Forensic Evaluation team is removed from the competency evaluation process. It is concerning that the staff best qualified to do this work in the state will no longer be part of this very important part of the criminal justice system. There is no available alternative system in the state for accomplishing these evaluations without the criminal justice system, without which the criminal justice system would be unable to move forward.
Thank you, Commissioner. Representative Porter.
Thank you, Mr. Chair. And I'm certainly, you mentioned the competency evaluation process and that you all would be taken out of that process. Is that correct?
As written, yes.
Okay. And can you tell me what else would be eliminated that you are currently providing in this critical
Sure.
process?
So the other thing we're concerned about is that there mentions a final examination, but there's no definition of final examination. And so that would mean without some new language, defendants could automatically be committed to DEMIS for over 60 years or more without review, which would conflict with civil commitment laws and our mission to serve people in a least restrictive environment. In addition to not allowing the forensic team to evaluate folks, and there's no one else to do that.
Right. And this has been the custom up till now. Is that correct?
Yes.
All right. Thank you. I appreciate you being here today. Thank you, Mr. Chair.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? If not, thank you very much for joining us, Commissioner.
Thank you.
Next, we'll have Gerald Minogue. Gerald Minogue.
Yeah, hello. Good evening, committee members. My name is Gerald Minogue. My comments this evening will be brief. I'm here today to request your support of Senate Bill 5. As I think some of you know, my daughter Julie Minogue was murdered as a victim of domestic violence on December 6, 2022. I never thought I would ever be in a situation like this, but I believe this bill will receive some traction as a result of my daughter's death. I can let you know that despite the tragedy we are experiencing, my family is most honored by that fact. As you can imagine, it's been difficult dealing with the death of my daughter at the hands of someone who had the sole desire to take her away from everyone because she sought the protection that he be denied access to her. He was full of vicious hate and went on to commit the most heinous violent crime against her. As terrible as that all is, it's more difficult in attempting to explain the whole tragedy to her 3 surviving sons, explaining how something like this could happen to good people, and then telling them that despite this tragedy, people are safe to go about their daily lives. Nothing will bring my daughter back, but I hope the passage of this law save lives of others who will find themselves in a similar situation, and it will make us all safer and ensure that some good comes out of this terrible event. Thank you.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? Not. Thank you for joining us and sharing your story. Shelby Henderson.
Thank you.
Good evening, Senator Winfield, Representative Strasstrom, and distinguished members of the committee. My name is Shelby Henderson. I'm a Smart Justice Leader with the ACLU of Connecticut. I'm a formerly incarcerated person, and I'm a student studying for a dual MPA JD degree. I'm here to testify in support of Senate Bill 1070, an act concerning prosecutorial accountability. I first testified before this committee on prosecutorial accountability in 2021, and I also came again in 2022. Today, I'm continuing to express my concern over the alarming reports of racial discrimination in criminal prosecution. Pointedly, my 2021 and 2022 echoed what I experienced to be true and also repeated what the Connecticut's 2020 prosecutor data analysis also confirmed. In every single GA court in Connecticut, Black people are convicted more often than white people. There's not a single GA court in Connecticut without a racial disparity in conviction rates. In the most recent analysis of prosecutor data, OPM conceitedly reported they could not answer the question of what impact prosecutors have on the well-documented disparities in the criminal justice system. This is inadequate considering the actions of prosecutors, not judges, unbound, effectively predetermine the outcome of most criminal cases. In Connecticut, that means that Black residents are more likely to receive harsher sentences, and we see the outcomes. According to the 2019 census, Connecticut's population is only 13% African American, yet Black people make up 44% of the incarcerated population. No other actor in the criminal justice system drives case outcomes as profoundly as the prosecutor. At the start of any criminal case, irrespective of factors of guilt or evidence, state's attorneys can add additional charges. They can drop charges. They have discretion when entering plea bargains, and they can even decide whether to prosecute or dismiss a case, all without oversight or performance evaluation. Now, despite the years of complaints from the community, the lack of concern is not what I would call prosecuting, protecting, and serving all of Connecticut. State's attorneys should be representing the interests of people of Connecticut. That includes incarcerated people and formerly incarcerated people. That includes people like myself. So reasonably, my scrutiny focuses on fairness and efficiency. How do I know if the state's attorneys are fairly implementing justice? Or more importantly, the question is, how would you know if they were not? The only way I would be able to comment on their work is once every 8 years when a state's attorney is up for a reappointment.
Thank you very much. Comment or question from members of the committee? Comment or question? If not, Shelby, thank you for joining us again. Sure, we will see you in the future.
Hopefully not for this.
Well, but in the future nonetheless. Gus Marks Hamilton.
Good evening, Senator Winfield, Representative Staffstrom, Senator Kissel, and all the distinguished members of the Judiciary Committee. My name is Gus Marks Hamilton, and I work as the campaign manager at the ACLU of Connecticut Smart Justice Campaign, and I'm testifying in support of Senate Bill 1070, an act concerning prosecutorial accountability. As an organization that believes that government transparency and accountability is imperative to a democracy and that fights for fair and equal justice for everyone in the criminal legal system, we believe that SB 1070 is the right step towards more transparent prosecution with meaningful opportunities for both oversight and public input. Every Connecticut resident is affected by the decisions made by Connecticut prosecutors, known as state's attorneys. People accused or convicted of a crime, their families, victims of crimes and their families, and taxpayers who foot the bills for both prosecutors' budgets and the cost of incarceration are impacted by the criminal legal system and deserve to know about the role that prosecutors play in the operation of the criminal legal system. Prosecutors hold people's lives in their hands. Being charged with a crime can lead to a lifetime of being denied housing, employment, licensure, education, and other opportunities. Prosecutors can impose effective life sentences every day. Following the passage of Public Act 1959 in 2019, prosecution in Connecticut is becoming more transparent, and SB 1070 will continue to build on that work. First, it requires the 13 state's attorneys to annually check in with the Criminal Justice Commission. Each state's attorney would be required to go before the CJC and comment on case-level data being collected and trends they see in their judicial districts. The CJC would be able to highlight areas for improvement or changes if necessary. And people living in those districts can weigh in on how they feel about local prosecution. In 2019, Smart Justice met individually with all 13 of the state's attorneys in their districts and asked them what their community engagement looked like. The responses from all the state's attorneys varied from community boards to shopping in a local grocery store. The annual check-ins proposed in SB 1070 would create a formalized role for community input. And since the CJC began holding appointment hearings at the Legislative Office Building in 2019, there has been a great deal of interest and participation from members of the public. SB 1070 would also shorten term lengths of state's attorneys from 8 years to 5 years. And this is more in line with other positions within the Division of Criminal Justice. Transparency and accountability are critical to creating a smarter justice system, and SB 1070 lays out the map to get Connecticut there. We urge the members of this committee to support SB 1070, and thank you for listening to our testimony today.
Thank you. Comment or question from members of the committee? Comment or question? Seeing none, thank you for joining us again. See you again as well. Danetta Robinson Scott. Danetta Robinson Scott. Julie Engelfinger. Oh, I see Danetta. Go ahead.
Yes, hello.
Yes. Go ahead. You may testify.
Hello. Distinguished Judiciary Committee. My name is Dinetta Robinson Scott, and I'm here to testify in support of SB 1062. My son was an active duty soldier that self-reported for a weekend to the El Paso County Sheriff's Department, where he was detained and begged for help for hours at a time. He was never given the medical attention that he needed. Therefore, he subscued after hours of begging for his life. It's been a decade and my family has not received any justice. There's no amount of money that could bring him back. Today, I come before you begging that you support this bill to save many, many lives in the future. Had this bill been in place, my son would have gotten the medical attention that he needed 10 years ago, and he'd be alive and here today. Thank you for listening to my testimony. Also, Selwyn Jones is also in support of this bill. He's the uncle of George Floyd, but he unfortunately was taken to the hospital And so once again, I want to submit his support for SB 1062 as well. Thank you.
Thank you. Comment or question from members of the committee? Comment or question, Representative Porter?
Thank you, Mr. Chair, and I just want to give you my condolences on the loss of your son. I am certainly going to be voting for this and hope that we get it out of committee and across the finish line this session. But I just really want to thank you for sharing your story and sharing your son with us. Thank you, Mr. Chair.
Thank you, Representative. Comment or question from members of the committee? If not, I also want to thank you for joining us to share your story with us. I know that it's not easy to do that. Thank you.
Thank you.
Julie Engelfinger. Julie Engelfinger. Okay, Mark Donald. Mark Donald. Anne Marie Grant.
Good afternoon, Anne Marie Grant for the record. My brother, Thomas Purdy, was 38 years old when he was killed by law enforcement while visiting the state of Nevada. My brother Thomas suffered from mental illness his entire life. He was a guest at the Peppermill Casino when he had a mental health crisis on the casino floor. He asked security for help as he believed someone was trying to kill him. Instead of calling for medical attention, they called Reno police. His alleged crime, trespassing at the hotel he was a guest at. Thomas was unarmed, non-combative, and non-violent and weighed 140 pounds when Reno PD hogtied him for over 40 minutes. Nearly every page of the device manual warns never use to hogtie a human being, yet officers did that. This is why I'm calling in support of the Medical Civil Rights Act, SB 1062. This Medical Civil Rights Act would require that a police officer immediately request EMS either when a person reasonably appears to be in a medical crisis or when a person communicates that they are in a medical crisis. My brother was dumped at that jail in Washoe County, Nevada, still hogtied, only to be asphyxiated on video by 4 deputies, placed face down, neck, back, legs, and still hogtied, and asphyxiated him to death. Had Reno police called an ambulance, my brother would still be alive. I want our states to value the sanctity of human life, and let's start passing bills like this that will preserve the sanctity of human life. Thank you.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none, thank you for joining us and sharing your story. Next, we have Ivelisse Carrera, followed by Representative Ali Brennan.
Hello. Okay, pulling up my speech. So it's short. I'd like to thank the committee for allowing me to speak today. My name is Ivelisse Correa, Executive Director of Good Trouble Advocates, Vice President of BLM 860, and a member of the CT Canna Warriors. I'd like to express my support for SB 1230, enact expanding access to public defender services. I support this bill and hope our state appropriates the appropriate amount of funding so that we can close the gap between private attorneys and our underfunded public defender system. Next, I'd like to express support for SB 1233, DCF alternatives to incarceration for primary caretakers. After the legalization of cannabis, the state of Connecticut took no steps to reunite parents whose children may have been removed for cannabis. I believe this bill is a step in the right direction and hope that we continue to fund alternatives such as this one. And finally, HB 1070, an act concerning prosecutorial conduct. Prosecutors are entrusted with a lot of power and drive incomes in cases. We need to do whatever we can to close gaps in our judicial system, especially when it comes to racial gaps. I would hope that the committee go even further and request quarterly reporting in racial gaps in
prosecutors' districts. Thank you very much for allowing me to speak today, and I'm happy to answer any questions.
Thank you. Comment or question from members of the committee? Comment or question from members of the committee? If not, thank you for joining us again. I'm sure we will see you as well.
You guys will see me tomorrow.
Representative Ali Brennan.
Thank you, Mr. Chair and members of the Judiciary Committee. I rise today along with violent crime survivors in support of SB 5 to strengthen protections against domestic violence. As you all know, the statistics surrounding domestic violence and intimate partner homicide in Connecticut are alarming, and the brutality of these crimes has become even more extreme, highlighting the urgent need for legislation such as SB 5. While domestic violence affects every community, the towns in my district, Bethel and Danbury, have been hit especially hard by multiple domestic violence tragedies. Most recently in January with the murder of Tracy Marie Jones, a 52-year-old mother of 3 who was killed in a murder-suicide by her estranged husband, whom she had been granted a restraining order from just 2 weeks prior. I applaud the section of the bill which would expand the state's domestic violence offender electronic monitoring program to all judicial districts. This would provide 24/7 live monitoring with the capability of issuing automated alerts to the victim and local law enforcement should a violation be detected. I constantly think about how this change could have potentially saved Tracy's life. I'm also here today on behalf of Emily Todd, a beautiful young woman and friend from Bethel who was killed in 2018 by a former dating partner. While her family and I support this bill, we urge the committee to add language from House Bill 6431, which is supported by more than 30 bipartisan members of the House and Senate and many members of this committee. This language defines and creates a crime for domestic violence and intimate partner murder, making it a Class A felony. The current criminal law in Connecticut makes it incredibly difficult for prosecutors to charge perpetrators of intimate partner killings with murder, even when there is a pattern of ongoing abuse leading up to the killing, by claiming that they acted in the heat of passion. Avoiding a murder charge often means pleading down to a lesser manslaughter charge, meaning these violent killers will often serve sentences shorter than the length of time they've been abusing their victims. This goes against many of our principles of justice and public policy. In Connecticut, a conviction for murder carries a minimum sentence of 25 years, while a conviction for manslaughter in the first degree carries a minimum sentence of only 5 years. This definition will help establish domestic violence murder as a serious and deadly crime it truly is, and provide greater protection and support for victims while holding perpetrators accountable. It's time to take a strong stand against domestic violence and intimate partner murder, and this language addition to your legislation is a crucial step in that direction. I want to thank you all.
Thank you, Representative. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none, thank you very much for joining us this evening. That's the end of my list. Are you signed up? What's your name? You are in person, so you can testify, Mr. Bloom. I remember your name.
I apologize for not being here this morning.
It happens. It's not a problem. You may testify.
Thank you. Well, my name is Andrew Bloom. I'm immediate past president of the Bail Association of Connecticut and a bail bondsman for 27 years. I've testified over the years for and against different bail legislation. And without going into my written testimony that I submitted, more so I want to express, number one, I gave written testimony supporting House Bill 5824, the act reforming bail bonds, because I felt it was a strong act and it has a lot of good things for helping to regulate our industry and strengthen the regulations of our industry, which I've always been for. The raised House Joint Resolution 261, unfortunately, would eliminate our industry and remove bail from the Constitution and replace it with preventative detention, which I cannot support, and I have data upon data upon data as for why that wouldn't work and why our system right now isn't necessarily broken. Our system is working and getting better, if anything. Over the years, our system in Connecticut has been tweaked, revamped, and worked on with this committee, with the Judiciary Committee, and I've been here every step of the way trying to help. And our industry, some of our members, some of our more proactive members have been here along my side trying to help to bring down the prison populations and help make there be less people getting arrested and held on bail. However, there is going to be people who do wrong and end up getting arrested, and will have either one of the three things that happens in Connecticut right now is they're either let go after they're arrested, or they're held with achievable bail, or they're held with non-achievable bail. And those are the three options right now. And non-achievable bail happens a lot. And to say that we don't have preventative detention already, non-achievable bail is preventative detention. As we speak, there's 1,048 people being held with bonds of $500,000 or more in Connecticut's jails. That's non-achievable bail. That's people that are being held preventatively. So to change the Constitution to remove bail as an option for people who could get bail is not giving them their right. They should have a right to bail, and replacing it with, well, we're just going to let the judges and the state's attorneys decide who should go and who shouldn't go. And that will lead down a slippery slope.
Thank you. Comment or question from members of the committee? People always do, sir. Comment or question from members of the committee? That was in response to, I have more.
I know.
I remember sitting on that side. Thank you for joining us today. This is a long-standing conversation that will probably be a conversation we're having for a long time, no matter what we do here, but we appreciate your testimony.
May I say one last little thing on it?
You know, you are the last person, right?
I know, and I know you want to leave, but Connecticut is the 7th best in pretrial release right now, and our rate of incarceration is down to 269 when the country is at 505. So we are not broken. We are getting better and have been getting better. To throw the baby out with the bathwater would be a mistake. That's all.
You provided written testimony as well, correct?
I did.
Okay, thank you.
Thank you.
Thank you for joining us again, by the way.
Thank you. And
All right, that's the end of the list. Happy to spend my day with you. I think we will call this public